Good morning, everyone. This is the New York City Board of Standards and Appeals public hearing for March 26, 2019. We will begin with the appeals calendar.
I don't think your mic is on.
Oh, it is on. I'm just not close enough, I think.
Okay.
Okay.
There you go.
Good morning, everyone.
Hey.
This is the New York City Board of Standards and Appeals public hearing for March 26, 2019. We'll begin with the appeals calendar, continued hearings. Item number 1, 2017-144A, 25-30 44th Street, Queens. And item number 2, 103-79BZ, 25-30 44th Street, Queens. It's an 8.
No,
the second one is
she's representing for the variance. So.
Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Aren't you speaking first? Yeah, you're about the variance, right?
Do you want to sign in here?
Yeah. You're not sworn in.
Oh, I see. DOB's the first, right.
Introduce yourself for the record.
Orantia from Equipment LLP on behalf of the applicant for an amendment to the variance. At the board's request, we submitted revised plans to both the DOB and the fire department. And we have a set of plans for the board here.
And I believe we got a fire department letter agreeing that the plans comply with fire code, right?
So the plans were reviewed by both agencies, and the fire department submitted a letter to the board stating that it had no objection to the application for the variance. Therefore, we're respectfully asking the board to close the hearing and vote on the application for amended variance, considering that the Department of Buildings application to revoke the certificate of occupancy will remain open. And the board can be assured that all code work that's required in connection with three-family occupancy will be done, given that the DOB's action is
So what I wanted to propose for consideration by the commissioners, because this is a two-fold application, right? One is that DOB will not withdraw its application to revoke the C of O until the work is done and their inspection reveals that it complies with code, right? Fire department is also vigilant and will be conducting inspections while the work goes on to make sure it complies with fire code. So one suggestion, as kind of pointed out by the applicant, and I certainly understand this, is that the owner, if the owner goes in and makes these corrections prior to our granting the variance, it's a big risk and a big financial expenditure. What if something happens and we change our minds a year from now, or however long it takes for the work to be done, or let's say 6 months from now? So one idea for consideration is that we grant a conditional variance where that runs where the variance is conditioned on completion of the work according to the drawings, and that in 6 months we have the applicant come back for the CO revocation hearing. And at that point, DOB and fire department will have inspected the site to give us an idea of where we are. And if we find out that in 6 months there hasn't been significant progress made on bringing this up to code, we revoke the variance and also revoke the C of O. It has to be significant work. It doesn't mean necessarily complete, but significant to the satisfaction of both DOB and fire department. That sound reasonable?
That makes sense.
Okay. Okay, so this is still an open hearing. So I need to then ask if there are any speakers on this. Mr. Carl? Yeah.
I'm the owner of the property, 2528 44th Street, which the property that we're discussing is next to mine. He violated the R5 zoning code. There was a legal-sized driveway existing when he built, and he made it null and void. And the board is not addressing this issue. So he has to comply with R5. And R5 didn't allow him to change the violation to just do away with it. That was a condition in order for him to build these two structures. Very clear. It wasn't built yet. To allow him a 4-foot side yard when R5 zoning clearly stated he needed an 8-foot side yard. And they never mentioned any bypass of him not abiding by an 8-foot driveway, which he made null and void. And you're considering to lift it, and he illegally changed the occupancy in 2003 behind the boards and behind the DOB. And granting him further destruction of my property, because this property cannot hold more than a two-family. The parking, the water and sewer problem, the drainage has not been addressed. But it's particularly the R5 clearly states there was a legal-sized driveway clearly in the deed, and he made it null and void, and no one's addressing it. Also, there was never a site examination. You're going on non-credible paperwork given by his attorney, where all along he's never been credible in what he did and say. And that house was always a 3-family when he was never allowed to do that. And and this has been going on for 40 years. And now, in 2014, you knowingly know that the Deputy Borough Commissioner is ordering a revocation of the C of O because he is in clear violation of the BSA ordinance. And you're not taking this into account. I've been here numerous times, and I don't hear any address to your findings, and if you did an actual site examination. Going by paperwork that could be fraudulent, all along that they've been doing this. You're not verifying anything. And another thing, you're allowing occupancy in a house where has never been a COO cleared. And you have put my property in danger and his tenants in danger because the house is not to code. It's not to code to a 3-family, and it's always been occupied as a 3-family. You're putting the neighborhood and my property in danger. You had concerns before, and you're not addressing the concerns. You're allowing him to continue the corrupt manner in which he does business. And I feel that he's making a mockery of this board, and this board should have more integrity to do what's right. And like they say, when there's a decision to be made, you don't go wrong by doing what's right, not what's easy. And what you're doing to me and my family, we're the face of what you're deciding on. You're not deciding on what's, you're saying it's common in the area. Those houses were built before he was there. And him to go bypass every code, use self-certification, which is the architect, was disciplinary action, is no longer in the picture now. And to continue this mockery it's devastating to my family because it's not going away. He doesn't have the ample parking space. He doesn't have a legal-sized driveway. He doesn't have the proper sewage and drainage.
Mr. Carr, if you can wrap up your comments.
I am
in 3
wrapping
minutes.
it up, but I want it heard. I want the board, please, for verbatim to read the minutes in 1979. A board member to please read the minutes.
Thank you. Thank you,
I
Mr.
would like to, someone to respond to me, not to you. Chairman.
Sorry, we're not going to recycle this
You're not answering
argument.
my question, you're not answering the issue.
Yes.
It's very clear why it's deed restricted.
Mr. Caro.
Because he wasn't allowed to have a 2-family house, and you're bypassing this. You're clearly bypassing this. You're not giving me an explanation why you're coming to this decision. I'm here to get an explanation.
Okay, so please sit down and we'll talk about it, and
Well,
then we're
I
going
like
to
it on
close
record.
it.
I like
We
it on
don't
record what
have
you're speaking
we
about.
don't have debates like this
I'm not
with
debating. I
testimony.
want an answer. I have a right for an answer. You're affecting my family. This is not paperwork.
I don't know how many hearings we've had. We've had a lot of hearings on this. We've had
And you haven't
2, 4,
never-
5, 6. This is the 7th hearing on this
Yes.
application.
Ms. Vaccaro, if you can just let the chair finish.
This
her.
is the 7th hearing we've had on this application, and during those hearings, we have repeated over and over again that the board had the authority to grant the variance that allowed for a 4-foot side yard, and did. That the easement has nothing to do with it because the 4 feet is clear of your easement. Actually, your building is in violation of the
No, it's not.
easement. The easement was 3'6", and he's clearing it by 4 feet, okay?
not
So
what you're
we're
saying.
not having a
It's a-
debate.
it says
Ms.
and
Vaccaro,
driveway. You're
we've
not
had,
reading what's
Ms.
there.
Vaccaro, please, you need to sit down because I'm not going to have a debate with
Okay,
you.
this will, I will not go away, this has to go further. You're
Okay.
granting something illegal, and the board and the mayor's office is going to know about this.
Okay.
It's illegal what you're doing to our family. It's clearly what he did to our family, he destroyed our property.
Ms. Vaccaro, we need to move on. Thank you very
No
much for
problem.
speaking.
No problem, this will go further, believe me.
Any other speakers?
Okay. So with that, I would like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown? Aye. Commissioner Shetza?
Aye.
Commissioner Shabeta?
Just to be clear, we're closing both the CO revocation and the variance application?
No, we should, oh, good point.
Because they're both actually
Oh,
on.
I'm sorry, yeah, that's a little confusing now. So the CO application, we are not closing.
Okay.
Just keep
So
that
this is for
open.
the 103-79-BZ is closed.
No, oh, it is?
This,
No, it-
that's the variance application.
That's the yeah, okay, we're closing the 103-79BZ
If we can do that vote
variance.
one more time.
Okay,
Yeah.
Chair.
Thank you.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shetza?
Aye.
Commissioner Shabeta?
Aye.
Great.
Okay, so then on 103-79BZ, I'd like to make a motion to approve conditionally. The condition is as follows. All work as shown on the drawings that were reviewed by Department of Buildings and the Fire Department, which are plans that were submitted, it says submitted with the February 13th, 2019 cover letter. So
No, it's actually March, it would be,
March 22nd, 19 drawings.
Yeah.
Right? So it's drawings dated March 22nd, 2019. All of the the work that is shown on those drawings shall be substantially completed within 6 months, or the board will revoke the variance. And substantially completed upon a
Per inspection?
inspection by fire department and the Department of Buildings.
Should we schedule a compliance in 6 months and bring him in and?
No, so it doesn't need to be like that because we already have a C of O revocation hearing that's running in tandem, and we'll just put that on for a continued hearing 6 months from now.
Okay.
So when we hear that, DOB will have inspected, fire department will have inspected, and if the work isn't substantially in place or, I'm not sure if that's the right language of substantial, but.
Substantial construction is a
Yeah,
term
substantial
of the-
construction
of the- yeah,
in
the
place,
resolution.
then that would be cause for revocation.
Perhaps
Understood.
after we vote on this, we can go back to case number 1 and schedule?
Yes,
6
yes,
months?
okay. So on a motion to grant on that very strict condition, so the owner has to really understand that the work has to be started tomorrow, and that significant progress, so substantial progress has to have been made on installing the required protections. After permits, it hasn't been permitted. So with DOB here, I would really ask them to speed up the permit process with this because we're on a tight window. So as opposed to it going through a long, yeah, okay, yes.
Yeah, I guess we're,
do you want to make it 9 months?
fortunately, the close.
Do we need to reopen?
I think we do need to.
Sorry, we need to reopen. There were more details.
Yeah.
Sorry, let's just do that again.
Motion to reopen, Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shetza?
Aye.
Commissioner Shabeta?
Aye.
Go ahead,
Okay.
Mr. Wallace.
Good morning, Madam Chair, Commissioners. I did receive just going back, we received the applicant's plans that were submitted to the Board of Fire Department on February 13th, and those were forwarded to the department, to the borough office, and they reviewed them, and they haven't before they were submitted officially, but sort of pre-check, what they were, that they met the conditions. We have not had a chance to review closely the plan, the most recent revised submissions, and I'm not sure that they've been submitted. They have not been submitted yet. So, as explained in the letter that we sent to the board, this is all contingent on the plans being filed, the plans being approved, and the plans that being permitted. Just reiterate that point that fire department is waiting on these plans that were most recently submitted, but our borough has not had a chance to review.
Okay. So I'm just looking at the subject of substantial progress. I don't want to put this off for 9 months, because then what if nothing happens in 9 months?
What is a typical time frame for looking into plans like these and issuing a permit for a job like this?
I can,
Very rough.
I think a 6-month period is adequate.
For what?
For the work to be completed. I think
Oh, you do?
Well, I
Okay.
mean, I think it can be reviewed, depending on what the plans show. It should be, and how much back and forth there is to the applicant and with the plan examiner. It should be well along by that point.
When you say well along, we're talking about construction, not just the
Permit.
plan permitting, right? So you think if we gave them a 6-month window, construction should be well along by then?
I would estimate that, yes.
Okay. So maybe the language should be substantial progress,
Yeah.
right? Okay. Thank you very much. All right then, so the condition would be that substantial progress has to have been made by the 6-month period, or the variance will be revoked, okay? Okay, so then, for a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetza?
Aye.
Commissioner Shabeta?
Aye.
Okay, and a motion to grant on that condition of substantial progress in 6 months?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetza?
Aye.
Commissioner Shabeta?
Aye.
Okay, now we can talk about the CO.
Jella, can you call number 1 again?
Item number 1, 2017-144A, 25-30 44th Street, Queens.
Mr. Wallace, you want to speak?
Sandy Wallace with Department of Buildings. Attended yesterday's hearing, and the department will continue to work with the applicants when they submit the plans, and then let the review and report back after the inspection meeting.
Okay, so this is one of those things where I want to make sure the site is really inspected, and that the architect doesn't try to do a Directive 14 or anything and nobody notices, and, things like that, right? Okay, so on high radar.
Absolutely.
Okay, great. All right then, so with this one, we're just going to put it on for continued
Yeah,
6.
If I can ask the
Yeah.
applicant, will the application be submitted under plan exam review rather than professional certification?
Has to be. Must be submitted under plan review. Right.
Okay.
And not Directive 14.
And not Directive 14.
Thank you.
Thank you.
So,
Does fire department want to add anything? No? Okay. So just for others, Directive 14 is when the architect can sign off on the quality of the construction. So we don't want that. Okay. All right, so in this one, it's just going to be put on for continued in 6 months to see whether the substantial work has been completed, substantial progress. made.
progress has been made.
Yeah.
So approximately 6 months for submission would be September 11th for a hearing.
Can we please make it clear that in 6 months from today, by the coming hearing for this case, if the work is not substantially done, it's not going to be no other chance.
Right.
That's it.
Yes, that's the condition from
Yes,
the
I
last
understand.
one was
Yep.
that substantial progress made. It's not substantial construction, it's substantial progress.
Yes, I understand.
Because part of it is they can't start work tomorrow because they don't have a permit.
Yes.
So let's say it took a month to get a permit. I don't know how long it takes to get a permit. so the work wouldn't start for another month or something, they have to mobilize, et cetera. So I'm hoping, yeah, right.
What I meant is it's a single chance. Take it
Yes, a
or
single
lose it.
chance, take it or lose it, yes, correct. Yeah, yeah.
Carl.
Okay.
Well, but it's about substantial progress, right?
Right, but my fear is we have not articulated substantial progress. And that could be an issue in 6 months, because substantial progress to us could be one thing, and the applicant may have to go through 2 iterations of plan exam and not get a permit for 3 months, and then take a month to mobilize and get whatever financing they have to get together, and then literally just have pulled the permits a month before they come back. That would be substantial progress by
Right.
some of our standards,
Right.
but maybe not all of our standards.
So what I would say is the applicant would need, the owner would need to demonstrate constant prosecution of the work, right?
There's no delay,
Constant.
there's no delay on the part of the owner.
Right.
That it's not a result of, there's no delay that on part of the owner that is not, that it does not have a reasonable purpose behind it.
Right, so and this is again because DOB needs, heightened awareness about this little project, really, is that, for example, I know that if there are reconsiderations and things like that being requested, it often takes a very long time to get an appointment. So if, in the interests of having us achieve substantial progress, that the idea that they're waiting for three appointments worth to get 3 questions answered won't facilitate this progress, right?
Understood, Madam Chair, and I'll convey that to the borough office and to my supervisors.
Okay, great. Okay, so that's what it is. The instruction is to the owner is continuous aggressive prosecution of the case. Okay. Okay, so I'm going to make a note of that also. Maybe we Okay. So you then pick the...
Right, so approximately 6 months is a submission September 11th for a hearing on October 3rd. It's either that or October 2nd or October 22nd.
Let's do October.
Yeah, October. It's
October
October 2nd.
Do you want that one?
October 2nd.
October 2nd submission for October 22nd. Sorry, let's correct that. So next hearing will be October 22nd with a submission date of October 2nd.
So that's the actual deadline, as opposed to whether that's 6 months, really. It's by the time of next year.
And I anticipate by October 2nd, or sometime shortly thereafter, the board would appreciate an inspection and report from DOB and FDNY as to the progress of
course.
the application.
Right.
Mr. Ron.
Ongoing inspections, ideally,
Okay.
right? Thank you.
Okay.
Mr. Ron.
Yeah, good. We'll set Ted a little...
You signed in the wrong place. I crossed out your name.
So Ted will get a little tickler,
Sign
like in July.
Okay.
Are we ready to move on to the next item?
Okay, go ahead.
New cases. Item number 3, 161-11A, 82-20 Britton Avenue, Queens. There is a swear-in sheet for this, however, this is an A case, so
So yeah, just skip it.
just give it, you may just go up to the podium. You don't need to sign it. They don't need to sign it.
No, she needs to sign.
She needs to sign in, just not
She just
swear in.
doesn't- Okay, so please, are you here for the applicant? Okay.
So are you for the case?
Can you put your name here? Got it.
Madam Chair, honorable members of the board, good morning, and thank you for this opportunity for my arguments to be heard.
Can you state your name, please?
Sure. I am Amelia Arcamone Macchianano, appellant and owner of the adjacent property that was damaged during unlawful construction and excavation. I heard you describe yesterday the damage as encroachments and shoring, so let me address that first. During excavation, there was damage to our property. Among other things, 7 steel I-beams were pounded into my property 25 feet down and crossed the mutual boundary line by about 12 inches. The I-beams straddled both properties, and we cannot encase those beams in concrete to develop our property to its full potential, and that would be a 6-story building, much like Britton Properties building, without encroaching on the other side, nor can these I-beams be safely removed. Please refer to Exhibit B of the application. Britton Property Incorporated et al., heretofore Britton or Trespasser, who are the developers and owners in this case, stipulate in their opposition papers for the first time that they did indeed trespass. Upon hearing that Britton had an opportunity to remove the shoring I-beams in the early stages of construction and decided not to because that would cost them a little bit more money to pay for 2 extra days of work. Additionally, the court saw the plans where the shoring was, and they saw that Britton intended to trespass before the construction was began. With that, the Appellate Division, 2nd Judicial Department, decided that the trespasser acted with actual malice involving intentional wrongdoing, amounted to a wanton, willful, or reckless disregard of the property, our right of possession. Please see Exhibit F in the application. Now, Britton does not deny in their opposition papers that their construction was unlawful and their permits were erroneously granted through misrepresentation. Instead, they say that this board cannot and should not hold them accountable to law where others have been held accountable because the case is moot. The building is complete. The building is occupied, latches, and more. The New York City Department of Buildings stated in their letter, their letter dated February 21, 2012, a construction permit cannot authorize a trespass. Now, normally, I would assume that this board, under these circumstances, would vote to, again, revoke the permits. Again, the DOB said, it is commonly known that it is unlawful to install a structure on someone else's land without consent. Permit revocation properly recognizes that a permit never should have been issued without consent, and it allows the department to serve the owner with violations where appropriate for having performed unlawful work. So, now, the only defense here is the building is complete. Now, that would be where the Britton is evoking a equitable estoppel. An equitable estoppel is not allowed in a case such as this, according to settled law. Being that you are a government agency that has acted in good faith. The only exception to the rule is if you didn't act in good faith, but you certainly did in this case. Now I'm going to turn to relevant settled law for a case like this.
So I hope your presentation's focusing on why we should rehear this, right?
Yes.
Okay.
What I'm focusing on is why this should be reheard. That's correct. Okay. Parkview Associates versus the City of New York, 71 New York 2D, 1988. A list of these citations have been provided to the board for your perusal. Now, this is a case regarding a building that was already constructed. It was constructed in excess of the height limitations of applicable zoning provisions. Yet here, as in the case now before the board, an estoppel may not be invoked against a municipal agency to prevent it from discharging its duties after construction. In the case of Parkview Associates versus the City of New York, the error was not due to the owner's misrepresentations as they are in this case. It was due to a bureaucratic error by the city. Yet even in this case, the court ruled, quote, estoppel is not available to preclude a government entity from discharging its duties or to compel ratification of prior erroneous implementation in the issue of an invalid permit. Now, you asked me why am I reading this? Because for one thing, I'm letting you know that according to settled law, the permits issued are invalid according to the way the law would view it or the way the courts would view it. Further on in the same case of Parkview, there can be little quarrel with the proposition that the New York City Department of Buildings has no discretion, and respectfully, this board has no discretion to issue a building permit which fails to conform with applicable provisions of law. And in this case, Britain certainly did not conform with the laws regarding property owners' rights. And the commissioner may revoke a permit which has been issued in error. And conditions are such that a permit should not have been issued according to AC 27-191, 27-197. Another case, Morley and Arical, 66 New York 2D 60. Well, there's plenty of cases. You could read them. They're all in my answer. And I'll just pause now if you have any questions or comments.
So again, the argument for why this should be reheard, what's new that would have an effect on our specific decision? And for me, it's just a piece of curiosity. What are you hoping to accomplish by the revocation of a permit on a building that's already constructed? Do you actually want them to go in and remove the I-beams from your property?
Well, like I said, the I-beams cannot be removed.
So then
and what my motivation is just simply not relevant to this case. I'm bringing this case before...
It is, actually. I'm trying to understand, what's your ultimate goal?
All right. The only one I could say is that if they be allowed to get away with breaking the law. It'll set up a precedent for other builders.
I have a question, actually.
Sure.
But you were successful in your civil suit against them, right? So have they, in fact, gotten away with what, they've acknowledged that they trespassed on your property, as the court found. And there was also a monetary judgment. So I have more questions. If you can explain more about what it is that they're getting away with, exactly.
We haven't been fully compensated. Okay.
But how can
However,
board action fully compensate?
let me say this. I am here to let you know that you will be breaking the law unless you reverse your decision.
So
let's
Now,
let's take it step by step.
Yes.
So it sounds like you're very familiar with our rules. So can you break it down? What do you believe is a substantially new evidence?
I'm sorry, if I could also just correct the board, this was an application that was granted, so this should be an application for a re-argument, not for a rehearing. And the standard is somewhat different. So for a rehearing, which is only available where a case has been denied, dismissed, or withdrawn, you can only get a rehearing if you provide substantial new evidence, there's a material change in plans, or an application is filed under a different jurisdictional provision of law. In this case, the case was actually, I believe it was granted, right? So this has to be a re-argument, and so her task is to show that the board misapprehended the relevant facts or misapplied a controlling principle of law. And I will also note that in our resolution for this action, for this original application, the board says that it takes. I just lost it, but the board said it takes no position on the meeting of the side yard agreement, which is the agreement that was at issue in the civil case, which I believe is what brought the applicant here today. And so I questioned whether, in light of that acknowledgement in the resolution, a resolution of the side yard agreement really is properly before the board. The board never considered it in the first place.
If we
so
did
now it's been resolved,
right,
what is now for the board to consider and contemplate.
Right.
If what council's saying is it seems that this is an issue that's already been decided by another court. And if we have sectioned that part off and that was decided in a separate court, it's not really ours to rehear at this point.
No, we didn't even hear it, apparently.
To hear, I'm sorry.
The VSA didn't take a position on the side yard agreement because it said, we're not going to interpret it, DOB didn't interpret it, we're just looking at what, actually the decision was based on the BSA saying, we don't know what standards the DOB uses to determine notice.
When I said rehear, I mean hear from the other court. If another court heard it, it can't come back here for us to hear it.
Oh. But we never heard it.
Yeah, that's not.
I understand.
The procedure. The procedure was there was litigation outside of the board context. The board said that's an issue to be decided by the courts. We're not considering what that agreement means in our making this decision.
Right.
And so my question is, why does now that the court has determined what that means, that makes it as any relevance to the board's resolution?
it certainly has relevance because at the hearings, the Britain asserted that they had authority to insert a 17 I-beams 25 feet down, crossing the property line by 12 inches. They asserted that they had the authority to do that, which was false. They lied to this board, frankly speaking. They lied to you. Now, they used the side yard agreement as a vehicle for the misrepresentation. They used it to say, here's the proof. Now, the DOB couldn't respond to that. They did respond to it. They knew it wasn't proof because they already examined it when they asked for reasons, give me reasons why you shouldn't be. They submitted it as an exhibit. The DOB had already seen that there was not even a mention of the I-beams. So it is still relevant because that is the vehicle for the misrepresentation. Now, the court, again, examined it. Now, the DOB even asked the board, please wait until a decision can be made. Don't make your decision until the court decides whether or not this side yard agreement is what Britain says it is. But, and I asked you to wait. I was there. I said the same thing is being litigated. Please wait. 3 months later, the court made a decision on the side yard agreement, and they said it doesn't give permission. It does not give permission. Now, that is the new information, and that is why the side yard is relevant. But even with that, according to the rules around equitable estoppel, that doesn't matter either, because I read to you a case where construction was complete. The only thing that matters to the courts and to the law, this is well-settled law, and I hope that you listen to this carefully. This is well-settled law that if it is unlawful work, if permits were granted to the builder by mistake, they not only must they be revoked, but according to the law, they are void. In the cases that I read, they were referred to as void permits.
Excuse me, what effect would a certificate of occupancy have on the holding in Parkview?
Well,
Do they have a certificate of occupancy in that?
Yes, they do. The building is occupied.
Or just a building?
No, in
permit?
Parkview, he's asking.
Oh, I'm sorry. There's no mention of whether or not it was occupied, but even that wouldn't stop.
No,
Yeah, I'm sorry.
not actually occupied, but a certificate of occupancy that is issued by the Department of Building that confirms that a building complies with all relevant laws, and what sort of impact would having a certificate of occupancy issued for a building then have on maybe our ability to hear a re-argument, or what would the proper process be in terms of what you're saying about equitable estoppel against municipal agencies, especially since the Department of Buildings enforces regulations. It sounds like this is an owner authorization issue, right? That's being disputed, and so
Yes.
Have you reached out to the Department of Buildings to discuss the case with them? Is this properly before us today?
I have no further information except for the what I gave you about the building that was constructed. However, what I did read is what are the exceptions to equitable estoppel, if there are any. And there are, the only exception is this: if this agency had, and certainly did not, acted in bad faith. That's the only exception. So I would assume, and it's really worth looking into, that even if the building was occupied, it's not an exception to equitable estoppel.
But
I don't think he's saying that. I think he's saying how you're before us may be an issue. If there's,
Well, I think that the issue is that this building has a certificate of occupancy.
Yes.
Yes, and so certificates of occupancy are final and binding on all agencies unless they are modified or revoked by this board. And so I think Mr. Steinheld's question is, where this has a C of O, can we revoke a permit where there's a C of O that's binding on all agencies unless modified or revoked?
You certainly have the power,
Well, in the absence of an application to revoke a certificate of occupancy.
well, you certainly do have the power to revoke all of the permits.
We do,
You do.
but that's not you're not before us to revoke a C of O, you're before us to revoke a permit, essentially, right? So it's cart before the horse, perhaps, right?
It was revoked, reinstated, and now you should reverse your decision to rescind the revocations of the permits.
No, but there's no permit anymore. It's a C of O.
The C of O, whatever there is.
but we don't have. an
No, but
application.
your appeal to us back then was to revoke a permit. You're asking to re-argue that case to revoke a permit. This is a new case that you're suggesting, it sounds like, to revoke a C of O, which actually I think is brought by DOB, not by an individual. So you need to go to DOB and have DOB bring to us a C of O revocation, right? As opposed to a permit revocation, which is no longer relevant in the face of an existing C of O. But I ask again, really, what are you trying to accomplish here? So let's just say the C of O is revoked. What do you get? What is there for you?
I mean, what do I get from it personally? Personal gain?
This takes a lot of time for you to be here, write these briefs. There must be
sometimes
some
just
motivation.
doing the right thing. I have no personal gain from this. I mean, it's doing the right thing. It was wrong. It was wrong what happened here.
What is the end goal? What would be the right thing to happen in your opinion?
Law and order.
Okay, so and what is that, and what is the result of law and order? Can you tell me the material result of it?
Law and order. I mean, that in itself is the result.
No, but I mean, when you say
because there'll be. I don't. Maybe I don't understand his question.
To get to the,
maybe I don't understand his question because.
What do you want? Okay, if we were to agree with you, what result would you hope happens? What happens to the building that you're adjacent to?
What I hope to happen is to probably, I'm a teacher,
okay.
you know, and with all due respect, just to educate you on the law, that if this ever happens again, and I hope this what happened to us doesn't happen to anybody else, you'll know that these excuses or this type of defense doesn't hold water because another building can make false representations to the DOB, get their permit approved by mistake, and by the time the adjacent owner finds out that their property is damaged, oh, it's too late.
No,
it's
I can
built.
appreciate the argument I can appreciate the position with regard to how things are going to happen in the future. I just want to know what you want to happen to the building that you're adjacent to.
I understand your question, but I just don't know how to answer it any more than the way I've answered it.
So if the building stays the way it is, or it's taken down, would it make any difference to you?
What makes a difference is that the
yes,
board...
I'm just wondering if that would make a difference to you, what the actual happens to the structure that you're adjacent to.
If it's done according to the law, it's okay.
What is okay?
If you proceed forward according to the law and set a precedent so that other builders will not do the same.
So I just want to say that this case was decided quite some time ago, where the board, in 2011, where the board admonished the Department of Buildings for not having a clear direction on how property owners would be notified that work is going to be done on their property. In other words, getting permission. Subsequently, I'm assuming, but I also believe because I've had some direct experience, the property owners are notified within a certain number of days of construction occurring on the site itself and on their own properties and have the ability to deny access. And these days, there are more and more cases where a property owner denies access, and if the developer wants to still continue to use their property, they actually bring it to court in a special proceeding. So there's a very different climate now about adjacencies and approvals, and I like to think that the BSA had something to do with that, in addition to which more and more awareness on the part of neighbors that I don't need to grant the right of entry onto my property. So more and more we're seeing foundations that don't rely at all on the neighbor, or a short time where those rods are put into the neighbor and immediately removed. So if you're concerned about the future of development, I think the DOB is already going there, and so is a more aware community, and also a better notification process.
And I believe on this case, it was an access agreement or some sort of agreement.
No, there was no access agreement. That's part of the point. But what the BSA decided was, back then, the DOB was very unclear about what it expected to see to show that a neighbor had granted permission. Because I remember long before 2011, nobody asked. You just did it. You just did underpinning and you didn't ask. And the underpinning was all under somebody else's property. And the only thing in the code was that you were supposed to notify the neighbor, but DOB never even asked you to prove you notified the neighbor. It was pretty much a Wild West situation. But in the last 10 years, there's been a lot of awareness about, I don't want you to underpin under my property. So, and it's going to cause cracks in my building. Why should I deal with that, et cetera, et cetera?
And I don't believe that anyone can rely on the original case as precedent, that this is something that can happen any longer.
Right. I mean, I think practice has changed at the DOB, and I think if that's your goal, then that's already happened. But to the point of what is this? Has to be a re-argument, right? Then. How did we misapprehend the relevant facts? Because we did not take into account the side yard agreement specifically. And how did we misapply the law? Because the BSA looked carefully at the statutes and said, where is it in the statutes that says that the owner has to do specific thing? Where is the rule? Where is the technical policy notice or operational policy notice that says, fill out this form and have the owner sign the form? Right? And so the BSA admonished DOB and said, given that situation, we can't then, in the face of a building that's already constructed, allow for the revocation of a permit. So I actually don't see where we did any of those things.
We also admonished DOB for having their form of punishment be wildly out of acceptable range for the issue at hand.
Right.
They overreacted to it, and in so doing, it kind of put their foot on the waiting for the adjacent neighbor, almost as if they were following the side yard agreement that they said they were not considering.
Right.
So that's how BSA looked at it, was to remove the side yard agreement from the discussion totally, talk about whether or not DOB had clearly and transparently issued instructions to the public about how you get approval, and then also thought clearly about finding a standardized redress to this issue when it was proven to have not been followed by the developer.
Right, absolutely. Right, and obviously earlier inspections are necessary, that kind of thing. Why weren't the tiebacks removed, et cetera?
And what about fines? Why not issuing fines for people who don't follow the rules, as opposed to just waiting and then after a fact issuing a stop work order?
Right, right.
Which has no resolution because the things were in place and could not be removed. And that was
Right.
the issue that we took with DOB, was like, you're issuing a stop work order that could never be rescinded by your actions because nobody could ever remove
Right.
those beams.
In addition to which, the stop work order was issued when there was no more work to stop. I'm sorry, she's so faster. It's not gonna work out. Right, so the stop work order was issued when the building was already completed, so there was no work to stop, right? So
Yeah.
it's kind of illogical, this whole thing. Right.
I wanted to know if there's anything to hear from the property owners, the developer?
Right.
And by the way, the shoring and these kind of, the dewatering, the shoring are considered according to the building code as temporary works. They are not part of the foundation of the building. So I can't see how you can revoke a CO based on like dislocation of a shoring element. Shoring is not part of the building.
Shoring, oh, that's interesting.
Yes.
Oh,
We call it, in the engineering world, we call it temporary work.
right, but when it's left there,
It became permanent. That's the problem.
but it's not part of the building, it's in the ground.
Even if it's left in place, unless the building is gaining its stability from the shoring thing, the shoring is not relevant to the building.
It's sort of debris.
Sometimes we design a secant pile wall to support the excavation, and in the meantime, to minimize the cost of the foundation for the building, we use the same secant pile wall to support the building, especially if this building is tall building and its supporting element would be massive. If you do that, or if the engineer do that and present it to the DOB in such form, the shoring or the secant pile wall is considered as part of the foundation. But if somebody else designed this building to put the secant pile wall just to support the excavation and build the building independent of that secant pile wall, it's not part of the foundation.
Interesting.
Yes.
Okay. All right, so there are no speakers on
Okay,
this?
thank you, everybody.
Thank you very much.
Appreciate being heard.
Thank you.
Thank you.
All right, I don't know if there's anything further to discuss on this. I don't think there is. So I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetzak?
Aye.
Commissioner Shabeta?
Aye.
And a motion to deny, or a motion to grant?
Chair Perlmutter?
No.
Vice Chair Chanda?
No.
Commissioner Otley Brown?
No.
Commissioner Shetzak?
No.
Commissioner Shabeta?
No.
Application was denied.
Special order calendar decision items, item number 4, 813-87BZ, 110 Borum Place, Brooklyn.
Good morning, Madam Chair, Commissioners, Frederick A. Becker. I'm not saying anything, it's a closed hearing. It's a
This is
decision.
closed, yeah.
I can't
So
talk.
it's closed, it was just that we wanted
The
to know whether...
photographs in that record?
Yeah, and the photographs are now in the record.
Great.
Are there any people here to speak on this application? This is 110 Boyram Place, Brooklyn? Okay, that's why we held it over for today.
I have no
Okay.
problem.
So then, I don't think there were any outstanding issues or any conditions, so I'd like to make a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetzak?
Aye.
Commissioner Shabeta?
Aye.
Thank you very much.
Thank you.
Continued hearings, item number 5, 429-29BZ, 4801 Kings Highway, Brooklyn. This is orange. Do you affirm to tell the truth? You can raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? You know, it's okay.
Good morning, Matthew Schomer, David F. Hutcher and Citron for the applicant. We attended yesterday's review session. I think we appreciate the comments about kind of site design and the extent to which we need to protect the neighbor to our north, which is lot 15. And I think that some of the comments that we received from the chair and the commissioners were very helpful in having us in thinking about how we can better create a site design that's a little more respectful of that neighbor. To that extent, I think we're going to do what we can to provide additional buffering along that wall. I think the comment about providing kind of multiple layers of shrubberies kind of stacked.
But you're just talking about maintaining the layout as it is.
Well, so with respect to the layout, I think that we are going to be looking at pushing, I think the overall layout, we have to keep it the same, I think.
No, you don't.
But we want to push that driveway further to the south, potentially cut off that building, the building corner, chamfer the building corner as was suggested to make that driveway, to push that driveway, give it a little more than the 10 feet that's existing.
So here's the instruction. It has to be 20 feet away, and I don't care how you modify the shape of the addition, but it has to be 20 feet away. to the curve of the driveway. And then densely planted. I mean, effectively, you're creating a forest between. The board has a lot of cases where it insisted on a 20-foot barrier like that between a resident and an aggressive commercial use. And then, of course, we have that issue with your enlargement, and it can't be 50% more than what existed in prior to 1961, right?
Correct, right. So 1535 square feet was existing in 1961. We're adding 390 square feet as part of this application, even though, some of the building is being demolished and kind of reconstructed, but it's all kind of going to be under one alteration application at DOB. So that 390 square foot enlargement is about 25% total.
Okay, so you have some, because we only have drawings that are post-61.
So I think the drawings with respect to the most recent, so the BSA approved drawings that are provided with this application are from November of 1961.
That's right. And the language 11.4.11 talks about December 31st.
Is the creation of the zoning
Yes,
resolution.
1961.
Yeah.
Right.
Okay, so it's pre-61 zoning resolution.
Yeah, that was the
point.
Yes.
Okay.
And that building is, so there was a kind of a little addition that was added, I don't know, sometime in the last 50 years, but we're removing that and not counting that as any existing floor area.
Okay.
That was never permitted.
But you are counting that to the increase.
Well, it's being demolished, we're not counting it as anything,
Okay.
we're taking the 1535 that was approved under the legal BSA plans.
Okay.
I would just note, I understand that, the 20 feet is the standard. I would just note that on the other side of the fence, there is an existing driveway, so that house is not abutting right against that.
It's a
that
residential property, and you're
Totally-
imposing a
yes,
Dunkin'
totally
Donuts that's
understood.
going to be really, really busy all morning, starting the minute these guys open, even if it's 5 in the morning, on one resident.
Okay. The other comment, I think that was about the circulation of the site. We're also happy to make that East 48th Street entrance be an exit-only entrance. That was another suggestion to try to improve that site configuration. I think we kind of expect that most people, that would be mostly used for exit anyway, and so it makes sense to restrict that in that way.
And we're going to have
Go ahead.
DOT also look at this layout.
Okay.
So who's this one, whose case is this? Just Carlo, oh, he's not here. Can you just alert Carlo or however we do this, that this needs to go to DOT? Okay.
Okay. DOT for review of the site
For
plan?
for review of the site plan, yeah.
Okay.
Okay.
There was still some issues with I guess, the zoning calculations for the sign, or for the signage. I think we'll try to clarify that further, I guess. It was, I guess I thought that we had done it right the last time, but we'll have our architect and our office take another look to make sure that we're doing those calculations correctly. There was a question about the East 48th Street landscaping strip on the outside of the fence and the depth of that. It's 1.5 feet, so it's pretty narrow, but we're doing what we can to provide as much planting as possible in that strip. Beyond that, there is
1.5 feet is not enough for anything to grow. Nothing.
so beyond the
Petunias.
property line, there is, the sidewalk has essentially has grass, then the actual concrete sidewalk, and then grass beyond that. So there's a kind of an additional visual buffer in that the sidewalk is not right up against the property line, but we only have really 1.5 feet to work with given the location of the driveway, the width that the driveway needs to be, and the location of the existing building.
So then you're basically providing no planting. Nothing's going to grow there, other than teeny little potted plants that you have to replace every 2 weeks. It's just the reality of how things grow.
I mean, I'm not a landscape
Well,
architect.
that's
so I
why,
don't know.
it sounds like a lot of, well, a foot and a half actually doesn't sound like a lot, but.
Here is a question, that stretch of green space that's there beyond your property line, why can't that be integrated into your design?
I mean, I think to the extent that that's possible, we would love to do that. It's city property, so I don't know, there may have to be, I don't know, some kind of coordination with parks or with DOT or it's
Also,
an
I mean, you
involved
should look at the
process.
opportunity of providing more street trees because that frontage of 48 lacks street trees and you have, I think 174 foot of frontage, so you can put 2-3 trees there. So I would say look at that also.
Yeah, I mean, we don't know
Yeah.
why at this site there are no street trees there. I don't know, sometimes there are reasons that Parks or DOT doesn't permit them
I
there.
think you should then proactively pursue
We
that.
can reach out, okay.
And revise your drawings accordingly.
I think that was the majority of the comments that I had noted.
Finally, what's the resolution? So what you're suggesting with this planting is relying on the city to meet your planting requirements for the street frontage, right? Where where the board in cases like this wants to see planting, right? So you're saying, well, I'm not going to provide space on my own property. Instead, I'm going to rely on the city to let us do it. So that's.
I mean, I think it's really a matter of, we have this existing building here. We need, I think 12 feet for the driveway, and then we have this fence, and basically that leaves only that little,
Well,
18
let's
inches
put it
of
this way.
space.
Look at how much of the existing building you're removing. What if you removed a different amount of the existing building in a different location, right? So you cut back the existing building to give you the 4-foot planting strip along that frontage. And then you enlarge your building, you slip the building back. I mean, it's kind of arbitrary how you're cutting off the building. It's
Yeah,
an
but
odd shape, right? It's this trapezoid.
Yes, I just know that, so our architect kind of has been working in making sure he complies with DOB requirements for alteration, so this can be done as an alteration application.
Right.
And, zoning, the zoning requirements as well, the 50% enlargement requirement, so, I think we can take a look at that.
So your building it's not even I actually don't know what shape that is. It's a multi-zoid.
Neither do I, yes.
And so cutting off that, I don't know if that's north, which way is that? 48th Street is north. Yeah, cutting off that north wall, pulling it back 3 feet, won't have an effect on whether you've got an alteration too, right? Because you're already removing far more than 50% of the existing building. If DOB allows you to do that and still treat it as an alt2, I have no idea. Right? So you're already proposing to remove way more than 50% of the existing building.
Correct. Yeah, I mean, I don't know the ins and outs of
Right.
how that, how they came to that.
So to
those
my point
determinations.
again, you could keep a little more of the existing building if you needed to, because you just cut the wedge a little bit differently. It's really, doesn't matter. And then you pull back that north wall, give us our 4 feet planting bed. You stop relying on New York City to provide the requirements of a buffer. And there we go.
Okay, I'll have to have them, take a look and see what they can do with that.
More than take a look. Do.
Understand.
Okay? Easier, just do. Shorter hearings if you just do. Okay? Okay. Any other comments from anybody? So I sent a note to Carlo to look at the reach out to DOT. And then, in terms of the sound barrier, even by moving it 20 feet, moving the building, or let's say the drive 20 feet away, let's say 10 feet further than it currently is, you're relying entirely on the sound barrier to protect the residential property, but there's no analysis. It just says it probably will be good. You need an analysis, and there's actually standard material available for how this is calculated. That's something either the architect or the engineer would do. It can't just be, it'll probably be good.
Okay.
FDNY and letters of support and objection?
Right.
Yeah,
There were
we're-
violations from fire department?
Yeah, we expect to have them resolved, client tells us within a month, so.
Okay.
By the time we're back here, we expect they'll be resolved.
Okay, and then you had a letter of objection from a neighbor concerned about noise and traffic caused by the store. So that's something that needs to be very formally addressed, right? I mean, so, because that's what we're talking about here at the board, but I think this neighbor isn't necessarily an adjoining property owner, it's a general neighborhood concern. One of the concerns is about people hanging out. Like how would the operation prevent sort of people hanging out in the parking lot? And sort of the writer was concerned about sort of nefarious types or nefarious activities going on in the parking lot. It's actually a real concern. So how is the operator intending to deal with that? Security issues.
Okay,
right?
we can address that.
Okay. All right. Are there any speakers on this? Okay. So,
How much time would you like?
I don't think we don't need a ton of time, a couple months. A month.
Okay, well, how about a submission May 1st for a hearing on May 21st?
That should be fine.
okay.
Thank you.
Thank you.
Item number 6, did you want to speak? Item number 6, 867-55BZ, 66-15 Borden Avenue, Queens. Everyone who's going to speak, please come up. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Oh, no, not here. Oh, no. Here. Next one, swearing sheet.
We're talking about this one forward.
So, they're proposing to address this here.
Yeah.
And they're saying it has to be there because this side is a big line. So,
Good morning. I have a bad case of laryngitis, so my assistant will be
That's
assisting.
excellent. Please, right
And,
away.
Yes.
And if there's questions, I will answer them.
Sorry, I
Okay.
can't hear you.
How's your hand signals?
Good morning. My name is Diwakar Gupta, and I'll be presenting on behalf of Nazir J. Kanzada, the applicant. We reviewed the executive session yesterday, and I believe the board had no further concerns about the landscaping. Okay.
But did you say they just submitted?
Right, we received a revised plan yesterday, and in that you have stated that the trash enclosure will have to locate from the Clinton, from the west side to the east side because of the slope. Can you please just kind of clarify
Correct.
that?
Sure.
And also that you will be revising this layout of the fueling pump. I guess it's moving a little bit
Sure,
So just
let me
kind of
explain that. I
quickly
have the-
walk us through the.
Yeah.
Oh, you even came with a board. And you weren't going to show us?
These are the plans and photos that were submitted on Friday.
Okay.
Is everyone able to see?
Yeah.
So we propose moving the trash enclosure from the Clinton Avenue side.
You can take the mic in your hand so that you can...
And please move the board more.
A little to the left, yeah.
Thank you.
So we propose moving the trash enclosure from the Clinton Avenue side to the eastern side of the lot because this part of the lot is has a high slope. So as you can see over here, if the dumpster enclosure was placed over here, there's a good likelihood that it would roll out anytime the dumpster was accessed. So we propose placing it on the other side over here.
Okay, could you just slide that away for a second? No,
Away.
so
Back to the
the
plan.
plan. I'm just trying to understand, where's the residential properties?
So the residential property is over here and over here.
So that means it's right up against the rear lot line of a residential property, not like in that.
It wouldn't be against the lot line, it would be more than 10 feet away.
No, just so imagine.
The other property.
Yeah.
The backyard.
This
Oh, I
backyard.
see.
So imagine, I'm out, this is the story I always tell. I'm sitting on my little chaise lounge, and I'm having my Mai Tai, and, or whatever, my iced tea. And there's this certain je ne sais quoi in the air. What's it coming from? And there's little critters running around just in front of my feet. What's it coming from? It's coming from the trash disposal, right? Those are really undesirable things to have near residences. So we always try to put them as far away from them as possible. So I don't have an issue with you relocating it, but that's not a good spot.
And there are ways to deal with the slope issue that, it's not outrageously difficult to find a way around.
You could groove the asphalt inside. It's not gonna move.
You could do what? You could
Groove the
cut
asphalt.
back?
Put grooves in it.
So then the wheels wouldn't roll.
Get a machine and have some grooves in.
What do you know?
Or
Grooves in
chain
the
it,
asphalt?
there's lots of different things that,
If you grew, so when the company comes to remove it, the groove wouldn't be in the way of.
No, they pull it, they're
With
using a
minor
truck.
effort, it's gonna move.
Right, it just resists.
But under its own weight, because of the weight component parallel to the slope, it's not gonna
Yeah.
move because it has some sort of brake.
It's friction.
Right.
Yes.
Okay. I love these science lessons.
Okay.
Okay.
We can, we can have a groove there, a groove.
Okay.
Yeah, groove.
you'll find a way around.
Yeah, you can
Okay.
do some
What needs to be
other,
done?
whatever the solution is, but it doesn't, putting it next to the residence.
We
just-
will accommodate it. This was as per the owner. We had to present, I was out there at the site on Friday. And he was saying, these issues, so we said we would present it. But we'll go back to him and just say, we'll come up with a
Solution.
resolution to the slope issue.
Because it's already sitting there in the,
It's actually.
No, they are, right now, this is where they are currently, and that's where the trash people are used, it's very easy for them.
because I'm looking
to-
at a satellite image, and I think that's what those things are in the
No,
satellite
that's
image.
the ice box.
Those are the ice, well, that's to that point, those are big too. If the ice boxes can sit there,
It's on a platform,
They're not
sidewalk.
on a roller.
They're
It's on
not
the
on
sidewalk.
wheels.
They've been-
they're not on wheels, but still, there's something that's leveling them if it's on a slope, right?
It's a raised platform,
Yeah, it's on a, there's actually a
Right.
sidewalk.
so it's not.
But you can also create a platform in addition to roofs, right? You could create a platform so it's in a horizontal position that levels out, right? So on that slope, you create something that is actually true horizontal, and then it rolls right onto the slope, right? Corrects for the slope.
Like you play with the grades for
Yeah.
a 10 feet by 10 feet piece, you make it level, and then you start your slope from the end of that.
Right.
I mean,
This is
Little
another
step
thing.
down,
Yeah.
right?
We could do, when we're doing the resurfacing at the end, we could adjust for that somewhat, kind of doesn't work with the timing plan.
Okay. It'll work.
Okay, well, we'll go back to the owner.
Okay.
Talk to.
You just need to explain what the solution would be to him. Okay, because otherwise, everything was good. We really appreciated the phasing plan. It was really clear and made sense.
I do have a question. In your revised plan, you indicated that the fueling pump is going to be located a little bit on the west side?
So we're not proposing to relocate the fueling pump. We're relocating the proposed parking to make it easier. So this fueling pump will remain over here, but initially we proposed 2 parking spots over here.
Okay.
And a car that was refueling over here would have difficulty navigating if there were 2 cars parked over here to exit. So we proposed moving 1 parking spot from here to the front of the building, and we just shifted this over a little bit.
Okay, that's fine.
Okay.
Great.
And also we spoke to the owner, and he wants slightly smaller signs, so we're submitting a revised signage chart. Same number of signs, but just slightly smaller.
Okay, everybody all right with that? All right. Good, so then move and do, but are there any speakers on this? No, okay. So you just need to proceed according to your phasing plan. So according to that, I don't have a copy of the phasing plan. Let's see, how much time till you get to the point right before you're going to do construction? So that's the end of phase 2.
April.
End of April. Is that what it is?
Yeah, April 2019, in-ground plantings planted as per plans on the side lot lines.
Okay, so how about we put this on for continued, say, in the beginning of June to allow for problems with planting, bad weather, whatever, and then we can see your progress, and then, because the rest is construction work, right? And so with seeing all that in place, then we can close on this and. Right?
Sure.
Okay?
Okay,
So
so
a
early June.
June hearing.
So there's June 4th, which is also a day when we're listening to the FERC. There's June 11th. Those are the
It could be
early-
June 4th, but I don't,
June.
it usually we have, what's the submission date on June 4th?
The submission date would be May 15th.
So that's too tight for planting,
Oh, okay.
maybe. Yeah, so.
So the next one would be May 22nd submission for June 11th hearing.
Okay?
Okay.
Is that all right?
Thank you.
Thank you very much.
Thank you so much.
Feel better.
Yeah.
Item number 7, 223-00BZ, 272 West 10th Street, Manhattan. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Yes.
Good morning, Amanda Iannotti on behalf of the applicant. Unfortunately, we were not able to get anything more conclusive from LPC, but thank you for trying to accommodate this request.
Sure. Okay, so we're scheduled to be heard on this on April 30th anyway?
Yep.
So ideally, you'll have gone through the whole staff review process?
Yes.
Yeah, and just to let you know, we reached out to LPC also, but we didn't get anything for it.
Thank you.
Okay.
Thanks. So just for the record, the next hearing for this is April 30th.
And the submission date is?
April 10th.
Item number 8.
Oh, but just to clarify on that, the LPC sign-off can be the day before the hearing, right?
Sure.
That doesn't need to wait for that.
Item number 8, 26-02BZ, 1680 Richmond Avenue, Staten Island. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Elise Fullader from Eric Palatnik PC. We spoke, or we emailed with Arcadis, the remediation company, and I have an update from them.
Great.
So the discharge to the sewer was disconnected below grade and capped. I'm just letting you know what's been done so far. The stub is currently removed and capped below grade. The electrical meter was disconnected by an electrician, and the fencing and two bollards protecting the electrical meter still remain. These will be removed on either April 2nd or April 9th, because what happens is the forklift operator can only come on Tuesdays. So, for some reason, and they need him to work out what dates which Tuesday they're available to come. So that'll either be done tentatively, we hope, on the first or second week of April.
Okay.
And then we can provide photographs of
Okay, so that's to remove the remediation equipment.
the tent and everything, yeah.
The tent, oh, the whole structure.
It seems that way, yes, but I will provide photographs.
Okay, so,
But they're awaiting confirmation from 3 subcontractors involved with the final lifting and trucking removal to get rid of the whole system. So it's a lift has to come, and then 3 subcontractors all have to come kind of together at once to get the whole thing done.
okay. So, therefore, we should give you some serious time, like 2-3 months. Because they said April something.
Yeah,
but then that's really not April something, that's
Okay,
more like May
understood.
something. So how about the end of June?
Can we do the middle of June? So I'm like, because I want to get this going, but I want to find like a sweet spot.
But we want to see
Yeah.
all of that,
Yeah.
the remediation and the structure removed, because the work apparently was completed 3 years ago?
Yeah.
Right.
So, okay, we can do the end of June then.
End of June is probably a little safer, even if your photographs are submitted on the day of the hearing to show it's removed.
Okay. June,
So the last hearing in June is June 25th.
okay,
That's a submission of June 5th.
June 5th. And then you asked how long do we need to get a final C of O?
Yes.
We have apparently had various difficulties with getting different items done, but all the work is completed except for the striping. But we've had like various issues, so whatever amount of time you're willing to give we would more than happy. So if you
Sorry.
give 2 years. We want as much time as you're willing to give because of various hurdles we've had along the
We need a
way.
little more information than that.
There's a
because-
lot of different things. I can get back to you with more detail, but I don't
Yes,
want to waste your time.
So that's the thing.
Yeah.
You're going to have to come back here in June anyway. So,
So hopefully we've taken care of all of these.
Yeah, that would be
items.
great.
We had to file like a builder's pavement plan, then they had questions about it, then we had to go back, like stuff like that.
okay. But so I think part of it is what is left that has to be done to obtain the CO?
Okay.
How much, and to, there's these construction timelines that are done. Why don't you just give us a construction timeline? What is left to be done?
There's apparently no construction.
Or
It's just.
That's just
yeah.
a concept.
Oh, okay.
Yeah.
Just
So
letting you know.
submitting a
Okay.
timeline where it says builder's pavement plan started today, it takes a month to prepare, it takes another month to be reviewed, like that.
Yeah.
That's how those timelines work.
Yeah. Apparently DOB just keeps coming back with us with questions, so we'll
Right.
say what we have.
But this is also the experience of the engineer who prepares
that's
that stuff, that
yeah.
every time I do a builder's pavement plan, it takes me 6 months to get it approved.
Okay.
Or something like that.
Okay. So I'll ask him for that. So June 5th with the June 25th.
Well, first, we should ask if there are any speakers.
Yeah, are there any speakers on this? No, okay.
So available for you is June 5th, submission with June 25th, continued hearing.
Okay. Okay. Thank you very much.
Item number 9, 189-08-BZ, 228-230 Mercer Street, Manhattan.
We did get it.
Would that affect the legibility?
Yeah, you did. If you go to the.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
So this one is just about the.
Yes, we have the 3.
Good morning, Madam Chair, Commissioners, Frederick A. Becker. I understand with the fire department issues, I'll let the chief speak, and we did submit yesterday a copy of the certificate of appropriateness with a approved plan that was showing what signs were to be removed and which were to stay.
Did you bring a copy?
I have one copy I can share with you.
Please.
Need it back? I can share it.
You sent it to submit, or?
We sent it,
Okay.
and we delivered by hand.
Oh, All right,
We did
let's see if
submit.
we can find an
Yeah.
email. Hold on one second.
We delivered it by hand at 4 o'clock yesterday, and we
Oh, at
submitted
4
it
o'clock.
prior, well, we submitted it prior.
Doesn't matter.
And then you also submitted electronically?
180.
Absolutely.
Great.
I can give you, you can take a quick look.
No, I know, but it's, if we have it, then it's great when all the commissioners can look at it.
Of course.
I don't find anything.
Do you mind if you share the copy?
Yeah, okay.
The one copy you have?
Who gets it? I'll check it.
Yes, yeah.
The last submission we have on this is March 14th.
Yeah, I didn't see anything this morning.
Attached is the C of A, and, which we saw. So, the C of A says, status update letter, this approval, does it refer to drawings, though?
I've included a drawing.
No, but how do we, the C of A refers to drawings.
Right, and you have a drawing.
Issued on November, it says, repairs and cleaning, specific, occupied, replacement. Subsequently, on November, Commission received the final drawings, 1, 2, and 3, all dated November 14th, 2012. This is November 20. It's stamped, okay. Stamped approved, okay.
So it shows there are four banners. 2 were to be removed, it says remove and repair, and then 2 were to remain, and if you compare the 2 that remained with the photographs we submitted and the plans, they are the one and the same.
So then the question is, when we look at our drawings that we have, do they look like the drawings we have? That's the issue. So, 189.08.
Was there a revised plan that was submitted in March?
No, we have February 11th. There was an existing and proposed plan set submitted, hopefully with the
It
elevation.
would be the last page. I didn't bring the plan by mistake.
It's only showing, it's showing a banner on the far left and on the far right.
It's the far left and not on the far right, it's.
Middle-ish,
It's the
or
middle, right.
quarter-ish.
It's to
from the
the,
door.
it's to the left of the doorway, which is, follows, there were 4 banners. They kept 1 and 3, got rid of 2 and 4.
Okay, so they got rid of 2 and 4.
They got rid of 2 and 4, yes, and
Okay.
1 and 3 remained.
Yeah, so they kept this one, got rid of this one and that one. Okay,
Right, so the extreme one is removed.
okay, that's good. As long as LPC was good with it. All right. Are there any speakers on this? Thank you for bringing that.
You're welcome, sorry we didn't get it earlier.
All right. I think that's it then. So no speakers on this? All right, so then I'd like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta,
All right.
And a motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta.
All right.
Granted.
Thank you very much.
But the next one, he's not.
Okay.
Okay.
Please raise your right hand.
You should call
You
the
gotta call the
case.
case.
Oh, I'm sorry. Item number 10, 150-14 DZ, 30 Broad Street, Manhattan. You are here to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions.
Oh. Darryl just sent, he just sent it to us, right?
Yeah, I just.
Yeah,
Good
yeah.
morning again, Frederick A. Becker.
Sorry, preoccupied with the little one. There we go. Just want to note that we did receive on that last one submitted. Okay. Okay. So the only thing that I had a question for was fire department. If fire department could verify that the proper applications for the PA what was it? It says the Schedule A does not show the proposed use in the subcellar, and the PA application only lists the second floor. And then the applicant submitted copies of DOB applications that were old-ish. So the question is that what you were looking for? Didn't have a chance.
John Daly Fire Department. I apologize, I did submit early this morning my request to withdraw filing a PAA. I apologize.
Okay.
But, so I will, once the permit is granted and they have get their final C of O or a temporary C of O, an inspector will verify that the C of O is correct. Okay. And, we'll be good. If not, well, there should a violation ordinance.
Okay, so you're fine with us proceeding?
Yes, ma'am.
Okay, good. Okay. Great, thank you very much. All right then, are there any speakers on this? Okay, then I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Allen-Brown?
Aye.
Commissioner Shetza?
Aye.
Commissioner Chabet?
Aye.
And a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley-Brown?
Aye.
Commissioner Shetza?
Aye.
Commissioner Chabet?
Aye.
Thank you very much.
Thank you.
Now I'll sit down.
Okay, good.
New cases. Item number 11, 156-73BZ, 1975 Eastchester Road, the Bronx. Please raise your right hand when you have an opportunity to. Can you also print your name? It's kind of hard to read it. Sorry, can you do it over here? Thank you. I saw it. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? I do. Thank you.
Good morning. My name is Gary Maranga. I represent Albert Einstein College of Medicine. We're here to request the renewal of the transient use within as-of-right parking garage, which is used for student and faculty on the Albert Einstein College of Medicine campus.
Were you aware that there was a review session yesterday that was videotaped?
I did not.
Okay, so that's, I don't know that you appear that often at the BSA, but that's what we have the day before the hearing. We have an executive session where the commissioners discuss the application. So I'll just go through the comments.
Thank you.
First of all, do we have proof of service of this application?
I think this one just circulated it to you.
Okay, that was submitted, okay.
He just forwarded it to you. Yeah.
Okay, so there was, community board didn't take a position on the application, you may know that. We need proof of compliance with all the conditions, so the grant came with conditions, right? Before I say that, there were photos that were submitted with the application that were almost illegible. So to the extent that the photos actually show compliance with the conditions, forgive us because we couldn't read what they show. So, and part of it is because we're reading PDFs, so when you submit something and the PDF scan isn't legible, that's what we're seeing. So anyway, so what we need is a photo of the recapture sign in the garage.
Well, yeah, we actually did hand deliver originals, and that was lost, and we sent over new ones, but I do have photos that are
Okay, but you see they're photocopies of photos, right?
I believe I might have clearer ones, but, you know, we have the recapture sign, as you suggested, for the multiple dwelling law to reclaim any transient parking spaces that are within 30 days if they're required.
Okay, so we need to see that sign, and it needs to be legible when submitted so that it's in the record legibly.
Okay.
Okay, so that's the first, and they shouldn't be little, what I'm seeing on your it looks like it's about, 2 by 3.
Oh,
It should be something that you can
No,
actually
they're
see.
actually pretty large. They're approximately
But
like
those are
18
black
by
and white
24.
photocopies,
Yes,
right? So there should be color photographs, and not just the sign. It needs to be taken back so we can see where it's located on the,
We could
the
place it.
site.
And can I make a suggestion, if you can also provide, key the photos with the plans? So,
Well, respectfully, they are, and we do have that, and it is in context. So maybe they just got lost in the sauce and.
We did not see that.
Yeah. Would you like to see that?
Yes, sure. You can start it over there, and, yeah. So, because I'll go through the other comments. So, it's the recapture sign in the garage. We needed to see where the signs are located, shown on the drawings, actually the formal drawings, not just a key plan, right?
Okay.
It's right here.
Then, there's supposed to be in the lease, a recapture provision.
That's a picture.
I saw that you have this memorandum
This is
of recapture.
Photographs in the initial.
But that's something presumably that was issued to the tenants way back when the leases were still invalid, sort of. But this was granted a long time ago. By now, there should be a rider in all of the leases allowing for recapture. These are not legible.
Unfortunately, I'm not able to read it, and
Yeah, I
neither
can't read
is
it with my
Commissioner.
glasses.
So I think what we want is a single-page photo
Sure.
of each one of these. Maybe that will make it more legible, and please make sure that these photographs are clear and not kind of
Sure.
fuzzy.
The original presentation was 11 by 17. That's just my hand copy, but we will.
Oh, I see.
The ones that we have,
Yeah, so
we have the
imagine-
same ones that you just
Right.
gave us. It's just it's the same
Understood.
concept. Thank you.
Right. Same concept, imagine you're reading it. Try to read this. Read it out loud, for your eye exam.
It was 11 by 17.
Okay, but we also, okay, if it's submitted 11 by 17 as a PDF, it should be fine, but only if the scan is a good scan.
Understood.
All right, so the lease, we need to see a sample lease rider.
Okay.
And that needs to be used in all of your leases. And then this memorandum of recapture, in the meantime, how often do tenants receive that memorandum? And is the memorandum, for example, posted in the mailroom? Like, how do people know they have the right to recapture?
What's the
If they never
methodology?
go to the parking lot, what?
The methodology of
the
this notice.
Yeah. I believe it would be every semester.
And how would-
That's a renewal time, but I'll check on that.
Sure, so
Okay.
you have the time and then just the procedure will be the second part. So
Okay.
if every semester, how is the notice
The
given?
notice? Sure.
Thank you.
What I want to say is, so if your leases are coming up annually, because that's the nature of the kinds of rentals that you have, there's no reason why there isn't a rider to the lease,
I understand.
right? Okay, so we should see that.
You're not suggesting that there isn't a rider to the lease?
I don't believe there is, but I'll check. When we asked Einstein, when we asked the college, they just provided us with that generic lease, which we sent on to you.
Right, okay. So rather than having another method, it should just be standard on your lease rider, okay. And then apparently in your statement of facts, you have an incorrect number of parking spaces stated.
Yeah, I think in one section it stated 694, whereas I think it's 691.
Okay. But 694 is the number of the apartments. 631 is the,
So I think
I'm sorry,
there must have been
it's
just some
reversed.
typo somewhere.
Okay.
So if you can just kind of.
And then we need also a photo of the rate sign, which may be in those photos, but who knows? And we noted that there are 2 entry points to the garage, so where, do you
Yes.
have this information at both entry points?
Yes, actually, one is, the lower level entrance is dedicated to the access for the transient parking.
Okay. So, and the upper level is
For general parking.
for general, as in permanent parking for the
Correct.
residents? Okay.
Correct.
So it's only the lower level that's transient?
Well, it's the access for it, yes.
Okay. Okay. Are there any speakers on this? All right, so this is something that you should be able to turn around pretty quickly, these responses?
Sure.
Also, Mr. Murga, if I could request that you, when you submit materials, you not submit them as a single PDF, that you separate them as like your statement of facts, your photos, your supporting
Itemized,
materials.
sure. I apologize, I missed the meeting yesterday. It just never
That's
was
okay.
aware of it.
It's all right. Can you comply with that and provide separate documents? Because it's difficult to then have to parse it
You
out.
don't have to attend in person, you can just watch the video if you want.
I would have liked to come, but...
Well, you could still watch it. They'll still be up there.
Yeah,
It's,
in perpetuity, perhaps.
But you can, again, just confirming, you can provide separate PDFs for all of these
Understood.
documents. Thank you very much. Appreciate it. So how much time would you need?
Well, I think we could turn this around as soon as you're ready to meet us again.
Okay. We have room on 26, on the 1st? Okay. So we can put it on for June 4th, which would be a May 15th submission.
Great.
Yeah, June 4th.
Thank you very much.
Thank you very much.
Thank you.
Item number 12, 245-03BZ, 160-11 Willets Point Boulevard, Queens. Here's the swearing sheet. Sure. Yeah, you can just print your name up here.
up here.
Yeah. That's the applicant's representative. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Good morning, Maria Papasavastos of Seifarth Shaw on behalf of the applicant. This is an application for an extension of term of a special permit allowing a drive-through at the site, which is the McDonald's restaurant. I was in attendance at yesterday's review session and heard the board's comments. It seems that there are a few modifications to be made to the statement of facts and the plans. We will make sure that the statement of facts accurately describes the site and the dimensions of the curb cuts to match the plans. We'll also update the plans to include the curb cut dimensions. We will indicate where the pickup window, so it's a separate pickup window and a separate cash window that's at the drive-through. So in looking back at the plans, I see that wasn't clearly shown, so I can make sure that's added in. In the
A separate pickup window and a separate what?
A separate cash window.
Cash window.
Yes.
Oh.
So the customer will first pay at the cash window. So there's the ordering point, which you see in the plans.
That's clear.
Yes. Then there's a separate cash window where the customer will pay for the food. And then there's a separate pickup window, which is all the way at the end by where the exit is. And that's where the customer will pick up the food.
Okay, that's not, neither of those are marked on there.
Right. So we'll add those in. And then there was a question about the reservoir space. So the reservoir space includes all of that up until the final pickup window, which is at the end of the drive-through.
Okay. Also, you need to respond to the community board comments. They had a lot.
Right. So we've been working with the community board on those items. We, of course, want to make sure that they're very supportive of our application and the business, and we want to make sure that we're addressing any concerns they have. The speed bump, of course, is already there, so during construction, we'll just make sure it's still there. We understand the concerns about the curb cuts for getting into the drive-through, as well as you make the turn by where the order point is. It's a bit of an odd angle, so you have to go up and around to get into the drive-through. So we discussed with the community board pushing back the curb cut so that you don't have to make such a wide of a turn. And it seems like, based on the site visit that Commissioner Chandra did, that would be a good idea to make sure that we cut down on the kind of congestion getting into the drive-through. So we told the community board that we're happy to make those modifications as we're going through construction, but we had to make sure that the board was on board with these modifications.
So my concern about, so when you're saying pushing it over, you mean pushing it to the right, which
That's
is
correct.
the
North.
northish, yeah, northeastish, right? So that's pushing it closer to the resident.
Yeah.
That's correct.
That's very not nice.
Unfortunately, there is
Extremely unnice. So I think that's probably the reason why it was angled like this.
It actually, if, the problem is if it's further moved towards the building, the angle gets more exacerbated. That's...
Right, but so this is again, why should the residential property pay for your McDonald's?
Correct.
I never understand that, without you compensating them. If you gave them a monthly stipend or something like that for living with the misery of all the traffic almost on their property,
Right.
that'd be different.
And
But
we
so-
expressed these concerns to the community board too, because this is something that they wanted. They thought that it would help get into the driveway. We explained that there's residential buildings next door. However, based on how you go into the drive-through, it does angle so that it gets closer to where the residential is as you get more into the parking lot. So I don't think it would be that big of an impact on the residents, since it's only at the front portion of where the road is.
But it won't be dense, but, yeah, Commissioner Chandra's suggesting more dense buffering at the corner, but when you shift the drive closer, how do you get dense buffering? You've just filled up that with a parking driveway.
There's enough space, but right now the landscaping is very minimal. It's just in-ground. It has to be much more robust, taller trees, and that also visually blocks it. And
Yeah.
so.
I mean, looking at it, I feel like that would better buffer. Yeah.
But I just had one question. When you're moving it over, are you then also moving over that access lane that passes by the drive-through, because or are you getting rid of it?
No, it would just widen.
Right, so then you are shifting closer to the
residents.
home, because then you're shifting the pass-through lane
Right.
almost exactly on the lot line with the residents.
But the residents aren't actually up that close to the road. They're actually back further.
It's their house.
Right, but where you shift it, part of it is going to shift that access lane almost adjacent to that lot line. That's what I'm saying, for the pass-through traffic.
Yes, and I understand that, and that's what we raised with the community board as well. I guess what I would argue is that the resident isn't actually as close as it is. Where you go back to where the house actually is, the access lane is closer to where the house is, where there actually is residential.
Which isn't good either, by the way.
Right.
So that's not an explanation, an excuse for, let's say, doesn't compensate, right? From my perspective, it's far too close entirely. But by bringing it even closer, and it's clear to me that the reason for that sort of triangular buffer area was to protect the resident from all the cars loading up right at that spot. So you're suggesting moving it, eliminating the buffer that I think the prior board went out of its way to
No, I don't think
encourage.
this should in any way eliminate the buffer. I'm not at all advocating for that. If anything, I'm looking at maybe a little bit of a shape of the landscaping without significantly eliminating the buffer and enhancing it with more dense landscaping. Because right now the landscaping is like I said, is low, there's
Right, but it's a different thing, because the other problem is you can't have the landscaping be too tall, or it blocks your visibility for the cars that are coming from the north and turning right. They need to be able to see what they're turning into, right? So actually the landscaping needs to remain kind of low within some visibility distance, whatever that magic number distance is. So you can't get dense for a while. So in lieu of density, you use distance. So, or you do both when you have a choice, right? So
I mean,
Yeah.
we're not proposing to, and I don't think the community board was proposing to push it back very far. It's literally just shaving.
It's just it's there for a reason, and that's what we're getting, and we don't want to sacrifice its purpose.
And I think the community board also is focusing on experiences within the community, that you have a traffic problem here, and they're not focusing on the neighbor who may not have come to the community board hearing for a lot of good reasons. Most of the time, the neighbors people don't even know there's such thing as a community board, so they wouldn't have come to the hearing.
I have a different question, and I think that might also lead to why we're having this issue, and that is typically when we do see these drive-through lanes, there's at least, I understand what you said about the reservoir spaces, and the reservoir spaces counts 10 all the way up to the last window. However, it really, we typically look at applications where there is enough of space for 3 or 4 vehicles before even they get to the menu board.
Yes.
And I don't think right now the plan has adequate space for more than one, maybe, very so many, 1, 2, 3, and or maybe at a stretch 3. I think it's more like 2 because you're at a curb. So I think that also is causing the spill, and that is the reason why that is creating the conflict of vehicles turning into the parking area. So I think this needs to address not just the not just those vehicles trying to get into the parking lot, which I think will get addressed once you try to provide a little bit more additional reservoir spaces for the vehicles, even getting before getting to the menu board.
How are you going to provide more reservoir spaces? You have to move the whole menu board and order board and everything down.
Maybe the menu board has to be moved then.
I think
the menu board then has to be moved up.
I can provide, I know that McDonald's, the broader company, does studies on the distance between the order point until the cash window, until the pickup point, and they try to maximize that space due to speeding up drive-through times. It's in McDonald's interest to get them through the drive-through faster. So my understanding, and I can get you the data on this, but my understanding is this is the way to maximize and to make it go more quickly.
Does McDonald's corporate, the larger company, does it go do site visits on their
It
site?
does.
It does. And in their site visits, they try to find out the best way to maximize.
That's correct.
And has one happened here recently?
I'm not sure, I could check on that.
If they may be the best equipped to know what is the best way to
Saturday morning.
And I'll also note that in part of the community board's request had to do with speeding up the drive-through, and we had mentioned the pre-browse board and the menu reduction. So that first proposed pre-browse board, that's just the board that shows like the specials and key items to try to speed up so people know what they want by the time they get to the order point. That's one effort to try to speed this up. Another effort that they're making is to try to reduce the number of items on the menu so that people, there's certain items that take longer amount of time to make and things like that. So they're doing these things, and those are things we discussed with the community board to try to speed up the amount of time to get through the drive-through. So I can provide more information on that as well if it would be helpful.
So I think one of the problems is there's nobody here from McDonald's or the engineer who worked on the drawings.
The engineer was not available.
Okay, so a lot of this discussion is about design. I have enormous problems with this application because, for one, the 10 reservoir spaces are supposed to be before you're actually doing anything, and you've got 2 or 3 on a good day. That's the first. The second is, for some reason, you've got a flight of stairs, some concrete area for I don't know what, an asphalt area for I don't know what, and then a kind of a walk-around thing, all forcing the lane to be the drive-through, to be very far away from the building, and therefore taking this super wide turn. Right? So that's part of the reason why it's forcing the entire operation up against the resident. So my first reaction is take all that stuff out and move the curb cut to the left, to the south instead, not to the north. And have the the angle of the turning radius modify so that it reaches, and maybe you can do something like this. You modify the turning radius, and at that turning radius point, there's a menu board. So another little island, a menu board, and when you swing back around, that's when you do your pickup and your cash.
So you're saying the menu board facing in towards the McDonald's?
Yeah, so I'm saying create another little island that's out there so that the cars keep going past the building because they can't possibly make the turn closer, right? Keep going past the building, and on a little island out there, there's a menu board, and the driver drives around the menu board somehow. And whether or not it can be on the correct side, I don't know.
Okay.
But, you know, the speaker systems work. I don't know if that'll work because without an engineer working on this, but it seems that sort of the whole premise of this is not fulfilling any of the requirements of a drive-through with 10 reservoirs, with putting all of the pressure on the road. All the business is being operated on the roadbed.
So that would be, and just for the space that's to the left of the drive-through, that's a parking spot for deliveries so that the delivery truck doesn't have to be there.
Not our problem.
Well,
so the parking spot for deliveries goes someplace else. The question is, do you or do you not have a drive-through, right? So deliveries, they go in a truck, they open the back of the truck, they unload onto a little rolling cart thing, and they roll it in. It doesn't need to go to a loading dock, right? Or you relocate the loading dock, or on the days when, on the early mornings when there's deliveries, the loading dock is shared with the drive-through. But the loading dock is not our problem. The question is, can you have a drive-through? And my feeling about it is no, at the moment.
So what you were referring to is having the, where the customers would order facing the building, going around on the other side, just so I can discuss that with the engineer.
Yeah, so, I mean, again, I don't want to be the designer because I'm not here with I don't have my CAD equipment here to move stuff around. That's what that's what the engineer should be doing, right? That's why the engineer really needs to attend these hearings so we can have a conversation about design. But the instruction is you need to, it's just a very simple design instruction. You need to provide the 10 reservoir spaces before the menu board, right? That's where it normally goes, before the menu board.
I think it goes before the payment.
Before the payment, okay. Before payment?
No, I've seen the reservoir spaces go at the window, from the window back.
No, true,
Okay.
but my question is typically where the menu board is placed, we generally see at least space for 4 or 5 vehicles. And here, I don't think the space is able to accommodate that.
Yeah, no, I get that. I get it.
Yeah, the question is, when do you start the 10?
I've seen them started at the window.
Okay.
So that's all I'm saying. But I do agree with you that after the menu board, usually there is quite a few spaces. Is there a way to swing the drive-through further, I guess that would be west, and loop around?
This is a very tight space.
Yeah, 'cause
and it's a very
tight.
well-utilized space. I mean, every parking spot was taken, and I was there Saturday morning.
This is crowded. I've gone here and turned
So-
around
so
around
yeah.
lunchtime and said,
Right.
I'm not even going to bother.
It's
Literally,
good,
I've
it's
turned onto
well-utilized,
Willis Point
but I
Boulevard,
think
and
you're
the
trying-
drive-through is
Don't talk
up
at
the
the same
boulevard.
Sorry. I think it's
So-
good that it's well-utilized, but that means there are issues that you have to address, and maybe drive-through is not the solution. You're adding too much program within this small space.
So McDonald's does this for a living, right?
they
Designing
should.
these spaces. They need to figure this out. You know, urban McDonald's may be a rare thing on their drawing boards, but they need to figure this out. Because normally, if we look at a typical drive-through site, it's 2 to 3 times larger than this site. And the building is always pushed far into the corner, to the far corner of the site, and you drive this long distance down along the property line and then take a left around the building. And that's what we see as the standard layout. And this standard layout is sort of being applied at the front of the site, hence no place for any cars to wait. Hence they're waiting on the roadbed.
Well, there is space for 4 cars to go before the order point, so I can show that and have the engineer show that.
We need to do, no more of that, okay? This doesn't work, this needs to be redesigned, and otherwise you don't have a drive-through. That's what everyone is saying, okay? So don't prove to us that it works fine, because it doesn't. We have site visits that are indicating it doesn't. We have a commissioner who actually goes there and realizes that it's too tight of a lot. And so you need to respond to that very seriously, and don't come back to us with arguments for why this is fine. Okay?
Okay.
Thank you.
Oh, and also for the concern is to explaining this to an engineer, perhaps he can just review the tapes of the review session and the hearing, so he or she can hear the comments for themselves.
Okay.
Yes, and we also have compliance officer site visit, but unfortunately I'm not able to get quickly enough onto the website. So everyone, just to note that our Ted went to look at the site and took a lot of photographs, so you can see it in action from the day of his site visit. I'm sorry, I just can't get there fast enough. Okay. All right, so I think you need some time to work out a better solution.
Speakers?
Oh, yes. Are there any speakers on this? McDonald? No? Okay.
How much time?
Maybe like a 2 months out, and then it would be a
Sure.
1 month out submission?
May.
Or maybe, should,
You go ahead and get your calendar if you want to.
Yeah.
Yeah.
2:45, I got it. 2:45.
So 2 months to hearing was your idea?
I think that should be good.
Great.
That's May, it's late May, okay. Is this tiny enough for May 21st?
No. Further?
Is this tiny enough for June 4th?
June 4th, we have big.
All right, so we'll do, the earliest we can hear is June 11th.
Okay.
At the submission on May 22nd.
I just have one more quick question.
Sure.
Are the hours still the same as the resolution hours that say Sunday to Thursday, 6 a.m. to midnight for the drive-through, and Friday and Saturday, 6 a.m. to 1 a.m.?
So they change during warmer months. During warmer months, I will need to confirm with the operator, but I believe the drive-through is until 1 a.m. During summer months, but I'll confirm that.
Okay.
Okay, I'm just, before we move on, I just was able to load the photographs, which I can pass around.
And which we should also make available to
Yeah,
review in the
so I'm not sure how that's done, but.
We can email them.
Yeah, we can email them.
Yeah.
So these are our compliance officer actually visiting the site. It's taking a little while to load, but some of them are about the general condition of the site, where it's pretty devoid of landscaping, but that's another day. The grass looks bad, the shrubs look pretty sad. But let's see about, I'm just trying to, the photos load kind of slowly. Yeah, so this is the loading. So you can see they're using the loading dock, and the loading dock is what is, and I'll pass this down. The loading dock is what's kind of replacing the opportunity for the drive-through. And you can scroll, 2 fingers scroll to the next one. No, not on the screen, I'm sorry, it's a Mac. And describe what you're seeing as you go, because we're recorded.
Oh, okay, so we're looking at photos of the entire site, and the building is clearly flush against the eastern lot line, but looks like it's in pretty good condition. Then we go down to the next pictures of the landscaping strip that is next to the homes. And it's basically low-rise, very low landscaping, about 1 foot, 2 feet off the ground, and doesn't really serve as any kind of a sound or light buffer.
Not terribly dense either.
Speak louder because you're away from
Not terribly dense.
Yeah.
Oh, this is a site of the drive-through where you make the payment while you're waiting to pick up. And there are no cars in front of this one vehicle that is actually making the payment right now. This looks, I can't tell, it's probably the northern lot line adjacent to the homes that shows almost no landscaping, but there's probably a vermin problem because there are vermin boxes alongside the fence.
Oh, good call.
This is another view of that northern lot line looking at the home that's adjacent.
Fence
and
needs to be fixed.
The fence could use fixing and
Yeah, can
yeah,
we also
sure.
show this?
And the landscaping really should be higher, so it's more of a buffer. You could use a resurfacing of your pavement, as you can see there.
So that's going to be done with the all new concrete. That's all going to be done.
And the landscaping and the rear also.
So this is, the drive-through is this way coming in towards, and then this wall is, so there's additional parking going back there. And just as an aside, this is where the community board wanted an additional sign saying additional parking in rear.
Because it definitely was not clear from the site visit.
It's actually behind that brick.
But is
so
it
you
part
can
of the
see it.
property or is it a shared
It's
common?
shared parking, it's not there.
Okay, I think those need to be much more clear.
Yes.
And how they have the rights to park there.
Okay. I can explain that.
Do we have a light meter plan?
No, that's one of the
That's what we need,
requirements.
because we've got
Yeah.
lighting on that property line with the home.
Right.
So it is higher. but
Very
we
high.
know
We
that
need a
light
lumen
spread.
study. We need-
Yeah, so I talked to the engineer about this point too. There was, he believes, a study that was performed when it was originally done, and the lighting hasn't changed. Do you still want an
Yes.
updated study? Okay.
Because lighting changes.
The technology has changed.
Well,
probably.
in addition to which, the fixtures, they move, the light bulbs get changed that are not consistent with whatever it was designed with. You just can't know until you do a study.
And it's a study for just like the lighting on the building and the...
No, it's a
the
lumen
lights.
spread diagram,
Okay.
which the engineer will understand, and the rule is that by the time it hits the property line, it must be zero.
Okay.
Not 5 feet over the property line, at the property line, it must be zero.
I just want to go back to the hours of operation. You said the hours of operations change during summertime. Is that what we had approved? I don't remember reading anywhere where we had allowed an hour for it to extend beyond 1 o'clock, so.
It's not past 1 o'clock.
You said summertime.
Summertime, I believe it's I know that the interior of the building
Well, I have
closes
concern about
before.
actually it going beyond 12 midnight.
Okay.
I mean, we typically never allow any of these drive-through next to residential beyond midnight, so I'm not sure why it's even going beyond that, regardless of summer, winter, fall.
Well, the resolution allows them to go to 1 a.m.
Oh, it
on
did?
Friday and Saturday only.
okay.
But it
Right,
does
it is
allow for
Friday,
it.
Okay,
Saturday
that I wasn't
only.
clear about.
I think it may be during winter, it's earlier, maybe, I'll confirm that. I know it's in here, but I don't want to waste your time looking for it, so I can write that in.
Last.
And I would suggest that the neighbors be notified, the residential neighbor be notified.
Good idea.
Sure.
Okay. So that means you're notifying yourself, right? Within, what do we say? It's a radius of the site. So you're notifying, and we're talking about residential neighbors, not the commercial neighbors. So about, say, 200 feet from each property line onto the residential properties.
That they could both come to the hearing or send a
Submit
letter
either.
that does not need to be notarized.
Yeah, exactly. Did you understand that? That's really
So
important.
giving them notice of the hearing as well as notice of our application generally, will I be provided some kind of notice from the board to give to them, or?
So it's really.
Yeah, we can provide a template
We can?
of
Okay.
because we have PCEs do it all the time, of
Okay.
continued hearings. So we can provide you a template. It basically says that this application is scheduled for a hearing on this date. You're entitled to come and give testimony or submit electronically.
Great.
So we can provide.
That would be
you with a
helpful,
template
thank
for
you.
that. I have one other comment, actually. Look at the parking spaces. You might want to check for ADA compliance, because it may actually require users to leave the site and cross the drive-through lane to get to the ADA spot in the front of the building, and that may
So the
not.
engineer has assured me that under the proposed, everything will be ADA accessible and compliant.
Okay.
So I'll have him put that in writing for you.
That would be super helpful,
Yeah.
thank you.
I think the way that's being achieved is they will use the city sidewalk to get to the entrance, because otherwise you're in the flow of the vehicular traffic.
A car would have to drive on the sidewalk?
No. Once you get out of the car, you will basically use the city street to go to the main entrance from the street. I don't think.
How do you park in that lot?
I don't think it's ADA.
I actually don't even understand how you park in that lot. How do you get your... Yeah, the maneuverability diagram has to show that you can physically get into all those spaces. I'm not sure you can get into those spaces. And once you park there, it's true, the natural reaction is going to be to cross in front of the drive-through. And then where's the front door? Where is the front door? It's on Francis Lewis, there's none on the side? What about on the side of the building?
No, these are all the pickups.
Okay.
It's from, there's an ADA.
So what
ramp
everyone's
also.
going to do is they're going to cross in front of the drive-through to go onto the sidewalk and then come to the front door. That's not very safe. That's actually what everyone's going to do, by the way. Everybody who parks will cross in front of the drive-through to come back onto the sidewalk.
And maybe that's why the community board is also recommending that there will be there be
bump.
additional speed bump and other monitoring devices to warn pedestrians. And
yeah, wow.
The problem is there isn't any other way, any other location to put the ADA
because
handicap parking spaces, because it is always going to conflict with the vehicular flow.
And that's why on all the other sites we see, the building is pushed all the way to the far right corner of the site, where there is no interaction between the drive and the parking. You come in, you park next to the building, you walk into to the side, just through the parking lot, the normal way, and the drive-through is happening on its own route. This is a confluence of pedestrians and drive-through constantly.
That could come to a disadvantage. If that would be the case on this property, there would be other issues with it, especially the type
No,
of...
this site isn't big enough to pull it all the way to the right side, far right. So, but that's the reason why it doesn't work. It's actually too small of a site for a drive-through, to tell you the truth.
It was probably also added after the building was already built.
Yes, correct. Okay. And then one thing that I saw in the photos, there's all of this kind of commercial storage on the outside of the building. That should be on the inside of the building, so.
I'll take a look.
Okay. All right. Did we already do a?
We did.
We did, and then we came back, so okay.
Okay, thank you.
Thank you. I think it's now just a 5-minute break.
Yes.
We've been at it for almost 2.5 hours, so we'll come back on the record at 12:26.
Have to make friends with the guy who's the sergeant or whatever he's called.
The guy who holds the attention.
We are back on the record.
Okay.
Item number 13, this is a new case, 209-04BZ, 109-09, 15th Avenue, Queens. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Thank you.
Thank you. Thank you.
Thank you. Thank you.
Elise Fullader from Eric Palatnik PC on behalf of the applicant. I would first like to say that this building complies with all the conditions of 2005 resolution and the DOB-approved plans, and I will go through the conditions. That the building shall contain a maximum of 134 units. Still has 134 units. That the total residential floor area ratio shall not exceed 1.29 FAR. It does not exceed 1.29 FAR. That there shall be a total of 139 accessory parking spaces located in a 2-cellar garage. It's a 1-cellar garage with 139 parking spaces because of the 2012 letter of substantial compliance, and that the total height of the building shall not exceed 67.4 with parapet. Building is built to 67.4 with parapet wall and it's from the flood base elevation. So what has changed is, in the notice of comments, I submitted a flood base elevation change.
Base flood elevation.
Oh, sorry. Base flood elevation. Confused word. A base flood elevation from FEMA, and they changed the base flood elevation. So the previous was, so the DFE, the previous DFE was at 11.3, and the new DFE is 14 plus 1 freeboard, so it's at 15 feet. So that is what changed. So all of the conditions are met, and the DOB-approved plans were changed in accordance with FEMA's new elevation.
So always measured a base above BFE, it didn't change?
Yes.
Okay.
So that is what you're seeing. And the building is 99.75% completed.
Before it was 97 point something percent?
Yeah, and now it's 99.75 completed. And per your request, I have attached the construction form that says the percentages, the AIA. And it's a big document, so it's on the last page of that, but behind that, stapled in the big packet, is also the current permits you asked for.
Okay, sorry. So the continuation, I'm just looking, continuation sheet, which is kind of like the third or fourth page of the, no, thank you.
It's a lot more than that.
Like the fifth page from the back.
Yes.
Says actually 99.75% completed.
Yes.
And that's what was paid, right? And so then you go to the beginning of that requisition form, now not known as it's an application and certification for payment form, which says, where? It says of the total contract amount with everything that of the 35,608,000, 34,307,000 was paid. So there's $1.3 million left to finish off the job out of a $35 million project.
And they said they're waiting for Con Ed to install gas meters, plumbing, standpipe work, and landscaping when the weather turns around.
Okay.
Okay.
And then the second sheet I gave you was the letter of satisfaction from OER.
From OER, okay. Letter of satisfaction. This site has satisfied the hazmat restrictive declaration requirements based upon review of the documents, certifying that the remedial action have been implemented and are protective of human health and environment. OER has no objection for the applicant to apply for a C of O. Good. And that's dated March 13th, 2018. So, great. Okay, thank you.
Have these materials already been submitted into the board's record?
I handed these out because I didn't know how this would go, but I have to go back to the office to give you another submission for another application.
Okay.
So if you want me to go back there and submit these into the record, I can.
Okay. So I just want to make sure in terms of everyone, since we were always measuring the height of the building off the base flood elevation, that this is not considered an amendment.
So what is this? This is filed as an extension of time to complete construction.
So I guess we would need to look at the drawings to see how it measured the buildings. Do Do you happen to have that material handy? So the drawings were measuring 67.4 off for the total height.
Yeah.
If the drawings were always measuring it off BFE,
Here's the 2012 drawing.
yeah.
But that's why I went through the conditions with you. just
Yeah,
so
yeah.
that We are meeting the conditions, even though in 2016.
Right. But I guess my question is, when base flood changes, do we normally consider that an amendment as opposed to an LSC?
Because we didn't change conditions.
You didn't, I understand.
Yeah, so that's
It's kind of
what-
like the target of what's the base changed by government.
Government, yeah, and there was
Right.
nothing we could do about it.
But the height of the building doesn't.
No, the height of the height from grade changes.
Height from grade changes.
Yeah, it's
But
like
the height from
3.7.
base flood doesn't change. And the height from grade changed a lot because base flood was at 11,
But
then it changed to 14.
if it's the same, just the base flood elevation changed.
We measured from base flood.
No,
so
I
yeah, yeah.
I understand, but the height of the building from base flood is still 67.4.
Right.
It's just that base flood changed.
Mhm.
So it's not that the applicant changed the design of the building.
No, the applicant apparently
Right.
did not, so
She just
It's-
noticed maybe the facade is different, but that's it.
unfortunately, there's just so little. Oh, I can see, 67.4 measured off of the first floor, which is elevation 11.3. So that number is the same. So there's no, right?
So, yeah, the question is, I guess, whether this, this vote, or if this was approved, would we have to approve new plans?
Right.
Essentially.
So the short answer is yes, because base flood went from 11.3, which it shows here, to 14. Or
that-
plus.
Plus the DF, so
freeboard,
plus
so
one freeboard,
15,
yeah.
Right.
But then for just sort of argument's sake, if they're looking at neighborhood character in an LSC review and seeing that the board discussed the height of the building with respect to other heights, and there was, for instance, a height study or something, and this is not discussing this particular case, but that could be an issue where an LSC might get tripped up.
Right. Right, so if we were looking at this as an LSC, and, you know, I see in the notice of comments that there was some discussion about whether you would come back for an LSC. Was that ever pursued?
No,
No.
because no, it just didn't make sense for us. And we provided you too, I don't know if it helps with DOB approved plans.
Right. So and part of the difference, one thing here is DOB, of course, let this proceed because the building's 97 and
Yeah.
7.75 complete. And frankly, I don't, so this was an enlargement of an existing building, but a very enormous enlargement of an existing building, right?
Yeah, but we followed here's the DOB.
So, yeah, so my question is, was the board, as evidenced by its resolution, concerned about the height of the building?
It seems like it, because it says the maximum
Yeah.
height will be 67.4 with parapet.
But we followed the.
I mean, more in the discussion section versus the bulk parameters that were being waived.
Good point. So
Like,
without
for
looking at-
instance, sometimes it'll say, whereas with respect to concerns about the height of the building, the applicant submitted a study indicating that the height meets neighborhood character, and that's obviously one of the findings of a variance.
Right.
But if this is an issue that maybe would warrant your looking into a little bit more, that could be done for the second call, and then
Yeah.
you could let us know.
That's a good idea.
At the second
So you
call.
want me to look at for second call if there's a whereas that talks about height beyond just measuring it from the 67.4?
Right.
Or a concern about height.
I would also just flag, Ms. Wildera, if you take a look at the approved plans versus the, I think it's the subsequently, or sorry, from the board's approved plans to the proposed or the existing plans, just confirm that the floor-to-floor heights haven't changed. It looks like they may have. So if they have changed or were constructed not according to or in some deviation from the board-approved plans, that would necessitate an amendment. So
So-
hone in on that change in particular.
Right.
Okay.
And so
Even if we
in
meet the
terms of the
condition?
effect of this, Sorry?
No, not in terms of a condition, but so on the, because if your floor-to-floor heights are different from what the board approved, that's just an amendment to your grant, right? Your building dimensions are somewhat.
No, but I don't understand that. I mean, let's say the floor-to-floor height changes, but the total height of the building is still within the purview of what was granted. How does it matter if the floor height went from 7 to 8?
In terms of accuracy of our records?
Yeah,
But,
so.
I mean, that's the conversation we're having about the BFE, right? It changed, so then our plans aren't accurately reflecting the height of this building.
So the standard for an LSC is if it requires a change, a substantive change to the drawings, then it's not an LSC, right? So, usually with LSCs come in for a really minor changes that are changes to the drawings, but extremely minor ones. So then we would be looking in an LSC about whether it's a minor change. It's possible, for argument's sake, that this could have been an LSC.
Yeah.
I don't know. Right, but they haven't applied for an LSC.
And they've applied for extension of time, so.
Right, so the question is, the drawings are different. So normally, when we do these extensions, the drawings can't be different. The drawings are different, so it's either an LSC or an amendment, but not nothing, because the drawings are different. And sometimes when they apply for an LSC and we review them, we say, well, it's not good for an LSC because too much changed on the drawing, so you have to come for an amendment.
So now you're saying we have to have an LSC or an amendment? There's no just extension?
We're saying that the drawings have changed, so it looks like you have to do one of those. We don't know which one it is.
Even though we meet the conditions and we have DOB approved?
But the drawings are different. That's the
Yeah, you submitted drawings that are different from the ones that were.
But we had to follow FEMA.
But that doesn't matter. So often the DOB will say, or fire department says, the bulkhead needs to move from here to here. Then the drawings are submitted to DOB with a fire department approved bulkhead, and DOB kicks it back to us and says, it looks different than what you approved. So either we decide on an amendment or we decide on an LSC depending on the scope of the proposed change.
So I would just note that the resolution states, whereas the board expressed concern regarding the scale of the proposed 6-story building as its height is close to 8 stories and its compatibility with the 2 to 3-story buildings in the surrounding area.
So I guess that
it sounds like an
amendment
LSC
is-
would not be appropriate for this.
Right.
Even though we meet all the conditions?
Yeah, but so it's a big part of the resolution, it seems like, had to do with height. So you're basically seeking to have an amendment because we have to change a substantial part of it.
Right.
It's not that can't be overcome. I think that the fact that it's FEMA, changing the base flood elevation is why you're here.
I think
We're here to get a C of O.
I think we're talking it's procedural more than, I think you're gonna have.
Yes, we're talking more procedural than anything you did wrong, which I don't know if you did.
Right.
I don't think it's going to be a difficult amendment to receive, considering why. But I think for us to maintain a certain procedure and for, I don't know, we couldn't just do it based on this because we're not extending those plans, we're changing the plans.
Right.
So I think it has to be an amendment so that we can conclude this quickly.
Yeah.
Okay.
So maybe instead of second call, we give you time to revise the application?
And just add the amendment to it and circle, and as I mentioned in the review session, bubble every change that was made to the drawings from the 2012 set, that's the LSC set, and not to bubble the entire plan because that doesn't tell us anything. And we're not talking about so the 2012 set was this classical building, so it's not relevant to us whether it's classical and now it's a modernist building. What's relevant is, did you add balconies? Did you do something on the new drawings that are different from the old drawings that would therefore make very simplistic version of the drawings look different?
Okay.
Right? Yeah, so, because we don't actually, I don't think in what you just gave us from the DOB set, it does include elevations. Okay, so there are differences in what's going on the roof line, for example, so that would be bubbled, but don't bubble the entire drawing because then we can't figure out what was changed. Actually, wish you'd come back because, that's the rear elevation, the north So I don't know which is rear and which is north-south. This, what you gave us is just north-south.
Sorry, I just,
It doesn't have east-west, so I don't know which is rear and which is front. This, in the 2012 set, they're labeled rear.
Okay. I'll get more complete.
Rear and front.
Plans. I think I
Which
submitted more
I think might be missing, because rear and front actually show the two separate parts, whereas what we have doesn't, just shows the sides.
Mm-hmm.
Okay? Okay.
So we need to.
Yeah.
Any speakers on this application? No. Okay. Also, because it'd be an amendment now, there'd have to be notice, right, of the next hearing.
And a community board meeting.
What's that?
And a community board meeting.
Yeah, so as a matter of process, this application wasn't referred out to any entities because it's just an extension of time.
So we'd have to give the community board the time to review it as well. Okay, that's 60 days, maybe 3 months.
Yeah.
Okay, I guess that's the best
I
we
mean,
can do.
sometimes community boards will waive, they already know this project, it's built. So that's up to you to find out whether they're willing to waive the hearing. Right.
Okay.
But in case they don't.
Yeah.
I've had like 1 or 2 waive in my life for a PCE.
Really? It's funny, for a PCE? Oh, in this district?
I mean, in my personal experience, I haven't been doing this for a million years, but I've had 1 or 2.
But it's funny because we have other applicants who seem to get every single one of their applications waived by their.
Maybe they're very convincing and I'm not.
I don't know.
Really know.
Okay, so how about a hearing on June 25th? That's in 3 months, with a submission on June 5th.
Okay.
Thank you.
Can you repeat the dates?
June 5th submission, June 25th hearing.
Thank you. You can keep all those materials and I will submit them with the next.
Great,
Okay,
thank you.
Appeals calendar, decision items, item number 14, 2017-316A, 95 Andrevet Street, Staten Island. You could sign in, but you don't need to be sworn in.
No, that's a short on this. On
22nd of March.
Yeah, yeah.
Good afternoon, Adam Rothberg.
All right, so we do actually have fire department sign off on this, right?
Thank you.
And we have our sign off on the RD, so there we go. So then I would like, are there any speakers on this one?
It's closed.
Oh, it's called closed, sorry. Okay, so then I'd like to make a motion to grant on condition, and the condition is the DEP conditions. So, which are the kind of standard ones we've seen. It says sanitary storm for the property will be discharged as per the site connection proposal. And this is just me summarizing it quickly because you can get it directly from the letter. All sanitary storm and water connections will be maintained by the owners and will not be maintained by the City of New York. And I don't think we had any. And of course, the restrictive declaration must be recorded prior to, what have we been saying? Prior to what?
There was someone who did prior to resolution.
Yeah, prior to resolution is usually the best.
Okay.
Okay, is prior to resolution. Issuance.
Okay, motion to vote?
To grant.
To grant?
Yeah.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Motion is granted.
Thank you.
Continued hearings, item number 15, 2018-23A through 2018-24A, 29 and 31 Herbert Street, Staten Island. Oh, you don't, it's an appeals case, you don't need to be sworn in.
Good afternoon, Adam Rothberg. We did have someone at the review session, so I understand we are still waiting for fire department to issue a letter?
Yeah. Still waiting. Okay. And we we also had at the last hearing a lot of discussion about the widening of the street bed in front of the entirety of Lot 1 because it's the same owner, and that's the only way of making that, ensuring that that street will be properly open. And then yesterday, there was a discussion about the issue of the decisions in Browse v. Smith and Brock Properties about whether common ownership with an adjoining lot that has frontage on a map street should be, meets the hardship finding, so you need to address that. Okay, so you need to read those two cases?
Well, I'm familiar with
okay. All right,
those cases, but those...
So you need to distinguish your case from those cases?
But those were based on fire department objecting to the, at least Brock Properties, fire department objecting to the access to the property.
Sure, that's in Brock Properties, but we can't ignore the portion of Brock Properties that discusses the adjoining property being at a map street. And the questions that the board was asking the applicant at the time that the applicant was not answering was, with this very, do you own any adjoining property? That is, any of the adjoining properties that do have frontage on a map street, are they in the same possession? And that's particularly relevant when reviewing Browse and the court's holding with regard to how one wouldn't have the need for a GCL 36 when an adjacent property has frontage. Now, I think that there's an argument that you can make saying that this is distinguished, but I do think that a careful review of those cases and a written response is in your interest.
Well, if these properties were transferred to another ownership, would that change the board's position on that?
So rather than negotiating with us like this, the instruction is really to describe the situation in Brock and in Browse and distinguish your site, your situation from those. And as opposed to trying to negotiate which way it would distinguish, right?
I don't think a straw purchase, I think that the courts have frowned on that. So I don't think that's a solution to circumvent the applicable case law. Would be something that I would recommend in any way.
Well, I'm not necessarily referring to a straw purchase. If these were sold to another developer who came to the board, these are legal subdivided lots, and then this would not be an issue. So it seems unfair to hold it against an owner who's not going through that process or doesn't want to sell off that property, that he should be held to a different standard.
I think the standard's quite clear. I don't think it's a different standard. I really, you stated that you may not be familiar with Browse. I think a good read of it might avail you to an argument that supports your position that you should be entitled to it.
Right. So, I can give you a hint, right? What's the configuration of your property? How would it be used if it wasn't allowed to have this kind of subdivision, et cetera? You need to take it down there.
The size of the amount that you're seeking for, and the type of development that's trying to be done, that's contemplated here. There are arguments there. But
but the whole, to be honest, the whole line of questioning doesn't really make sense to me. Again, I'm not as familiar with Browse as I am with Brock, which had completely different and distinguishable circumstances. But again, if these were under a different entity, be it a straw entity or a completely divorced entity of good faith sale at market value, these lines of questioning wouldn't be appropriate at all, and I don't think the board would have the right to go back against the prior owner and say they have to
So if you were familiar with Brock, as you suggested, you would know that this line of questioning is entirely upheld on appeal. The line of questioning of whether or not you own this property, adjacent properties, is entirely upheld. So your statement is inaccurate. this line of questioning is appropriate.
But if I could just reorient us a little bit. So
Sure.
the GCL 36 is about there being a hardship about your property not fronting on a mapped street. And I think what the commissioners are getting at is where you have an option by the way you orient your lot subdivision to have both lots front on a mapped street. Why aren't you availing yourself of that option? Why are you coming for an exception or waiver where there may be other ways to orient your property or your lot subdivision that would obviate the need for this waiver? I think that's the question. And the question is really about what's the hardship? Is it created? I know that a commissioner said he's not trying to import a self-created hardship finding from the variance, but in the cases in Browse, it suggests that this kind of hardship isn't the sort to be remedied with the GCL. So if that could be the kind of the focus of your response.
And I have to say, if you just thought about it a little, rather than fighting with this, you would find an easy way to distinguish your situation from the situation that was in Brock and Browse. You just have to look at it, and you do have to understand that the board is now looking at the text of GCL 36 and trying to follow its instructions, okay?
I understand.
Okay.
And again, I would just reiterate my point in my experience that if this is an alienable property and that these restrictions would not apply to a subsequent purchaser, then I don't think that that line of argument holds up. Now, that said, we'll go back and we'll address it the way the board likes, and hopefully we can resolve that. We also have a question or issue with regard to the potential improvement of the remainder of the sidewalk, which again is not subject to it's not subject to this application right now.
But it's the same owner, and it's the same owner.
I understand, but there's no application filed against the remainder of Lot 1
So I'm
now?
going to cut to the chase. We had this conversation at the last hearing. You're not going to get anywhere if you hold to this position. You just need to amend the builder's pavement plan to include the entirety of Lot 1, which is owned by the same property, to show that whenever Lot 1 is ultimately developed, the roadway will be opened so that you have continuity and consistency all the way from the intersection. And to push back on this, I don't even understand the purpose of
I
pushing
just want to
back.
be clear, so you said is when Lot 1 is developed, that's the sidewalk that would be improved?
No,
I mean,
the fire
DOT
department doesn't think that way.
DOT.
The fire department needs to get its trucks in there. Look at how narrow it is.
Well, we haven't gotten the fire department letter yet.
That's true. So maybe we can revisit that when we get.
And that's why I really didn't want to get too far into that issue
Let's-
right
yeah,
now.
let's
So,
wait until
but I
we-
would say the answer is that if the fire department says that they need the rest of that to be widened, and that can be done as a condition prior to obtaining a C of O so that we're not held up, because this would delay our project by several months, having to amend the BPP to do a filing on the other part of Lot 1, which hasn't been filed yet. And we're concerned that that would be probably a 6 or 8 month delay in our moving forward on the other project, which might be approved. So I think there is a middle ground there that we're
Right.
willing
Well,
to
again,
discuss.
because fire department has to weigh in, and they have to fight
Absolutely.
fires that are located on those two houses, heaven forfend, that they actually can't get there because it's not wide enough, et cetera, et cetera. So we'll let fire department decide on when that work needs to be done.
Absolutely.
Okay.
Okay. All right. Are there any speakers on this?
Okay, how much time would you need to respond?
Well, we're waiting for the fire department, so.
Mr. Daly, do you have any idea?
We're anxious to move forward.
Any estimated?
Monday.
Monday? Okay.
Monday. So if you want to give us an extra, I would say, 2 weeks to respond to the other Brock and.
Yeah, another 2 weeks. Oh,
No, I mean 2 weeks.
Yeah, 2 weeks.
Yeah.
So I have, that would be a submission approximately April 17th? It's about-
That'd be great.
Great. So that would be a hearing for May 7th.
Thank you very much.
Thank you.
Thank you. Thank you.
New cases. Item number 16,
I think March 26th, May 7th hearing.
2017-202A. 45 Cunard Avenue, Staten Island. Although you're not sworn in, you still have to sign in.
Angelic, could you sit closer to your mic? It may be picking up on the video, so I don't know.
Okay, I will recall this. New cases, item number 16, 2017-202A, 43 Cunard Avenue, Staten Island.
Good afternoon, Stephen Simisich for the applicant. At the outset, I wanted to speak about the threshold issue regarding the city planning letter. We spoke to city planning this morning, and were informed that the letter was based on general knowledge of the street and a site visit that had taken place. That we were told that they had limited documents and plans for the project, so they did not see the topographic lines or the steep slope areas. We can easily update the site plan to show the areas of steep slope that none of them are being impacted by the houses, and we'll share that with city planning so that they can see that this is an as of right, but for the GCL approval. So at this point, that can definitely be done on the plans, for the board.
Okay, so I would just have to say, until city planning gives us a letter that tells us that this is an as-of-right project, I think it's premature for us to be looking at this.
Well, if I could ask, did you get full DOB plan review that resulted in your objection?
Say again, sorry?
Did you undergo full plan review of DOB for your objection?
I mean, at this point, yeah, we had submitted notification to DOB, the community board, and the borough president.
No. But I mean, for your objection, did DOB review your plans for compliance with zoning?
I think so. Yeah.
You think so?
You don't.
I don't know is the better answer.
Okay.
Yeah. So you're saying
when you speak, you're a fact witness.
Yes.
You speak to the facts,
yes,
right?
That's okay.
If you know, you know.
It's
if
okay
you
to say
have
you
no
don't know.
exposure to
Yes.
the facts, just say you don't know.
Yes.
Okay.
I'll say it again. I do not know
Thank
if
you.
DOB
Okay.
had fully reviewed those plans.
Okay,
But-
I was just asking because you were.
But what I was
asking.
getting at is, it's very clear here, after speaking to city planning, because they were not given, the only reason I mentioned that they were not giving the full application to look over is because under the rules, they were not required to have been given that. So once they do see, like we were mentioning, that the plans will be revised, none of the homes are in the steep slope. So I don't see why we would have to refrain, as the GCL application here is just about access to the street. So whatever city planning is going to decide, the GCL can just proceed forward. and then-
Okay, so here's the thing. City planning, what we have on record right now is a letter from city planning saying, we ask that you hold off on considering this because we believe this is in the Special Hillside Preservation District and is subject to our special permit, right? And so, and because often city planning will have an opinion about projects on steep slope, where they might even, for example, as they mentioned in their letter, it's discretionary, so they might deny the right to build, right? Therefore, our review of it is premature. So until we have something from city planning that says our mistake, this is actually not under our purview because it's not on a steep slope or whatever it is that would make it not in their purview, I don't feel comfortable about going forward with the continuation of this review. But in addition to which, we had lots of comments, which you heard.
Yes.
Which you can prepare responses to if you want. And in the meantime, if we get something from city planning that says our mistake, not our purview, then we can continue with the review.
So we will not proceed with responding to those comments from yesterday and at least trying to submit.
No, I don't see the point, because if it's in city planning's purview.
But you just said that you had a lot of comments.
No, what I'm saying is,
in the meantime.
I think it's
he doesn't need to
today.
respond in the hearing right now to them.
I see.
I'm saying that if in the next
Okay.
month, we can put this on for a continued hearing, whatever.
And can I make
and-
revisions to documents to submit, or?
So let me just
Okay,
finish
yes.
the
Sorry.
sentence. So if in the next, say, 3 months, we find out from city planning, so we put it on for 3 months from now. City
Can we do
planning
it earlier than that?
finally, please let me finish speaking.
Yeah.
We find out from city planning that it's not in their purview, then you can submit the responses to our comments, and then we can continue, and we had a lot of comments, right?
Yes, which I
So,
was prepared to discuss.
including the finding about or let's say creating the hardship complained of, sort of where this property that arguably has frontage on a map street and you're subdividing it so it doesn't. Whether or not that's a case, I actually can't tell because one of my comments was, I can't tell where the site is relative to the entirety of Cunard, and the drawings indicate, are unclear about where the paved roadway stops. So it's so out of context, I actually don't know where this site is relative to Cunard. And I have to say, all of us know this roadway very well, because we have another application right around the corner from here. And this, we're acutely aware of the site.
Yeah, and sorry for speaking before when you were finishing up. I just wanted to mention that, I mean, respectfully, after the conversation that was had this morning, could the continued hearing just be scheduled not that far in advance? From what we had heard from city planning, once they see the plans, we're very confident that they're going to know that the houses are not on steep slope and all, and we would really like to bring this right back and respond to the meat of all of
So
these
the right
comments.
back has to do with our schedule?
Yes.
So if I say 3 months, it's because I don't know what our schedule is allowing. So, and it requires significant review on our part. So, and you need to respond, right, to the questions that were presented, right? So it's not a 2-week turnaround?
Oh, not 2 weeks, somewhere 2 weeks to 3 months.
Are there speakers on this, Leonard? Okay.
We could do 2 months.
2 months.
May 22nd submission, March, April, May. May 22nd submission for June 11th hearing.
Great, I appreciate that.
Great.
May 22nd?
May 22nd, May 22nd submission.
Submission.
June 11th hearing.
That's not one of the specials.
No, it's not one of the specials. But I guess so should Mr. Submission go ahead and submit
Yes.
his materials by May 22nd, and we'll independently look for verification from GCP that this is outside their purview?
Both. You should get, as soon as you can, something from city planning.
Yes.
And we'll try to do the
Something in
same.
writing. Great. Yeah.
Because the point is, obviously,
Yeah. Okay.
don't submit by May 22nd if
If-
city planning sends a
Yes,
letter
but I
saying
can
it is in our purview.
Be prepared to submit all of the responses to comments from yesterday, so that way everything's going at once.
Right.
Okay.
Great, so submit May 22nd for hearing June 11th.
Okay, thank you.
Thank you.
Thank you.
Item number 17, 2018-47A, 45 Case Avenue, Staten Island.
This is being adjourned.
Oh, right, this is being
adjourned.
postponed.
Oh, postponed.
So
Okay,
it was,
good.
they didn't serve DOB, but I don't know if there was any discussion as to what the next hearing should be, so I guess it's just at our discretion.
Yes. Well, they have to renotice.
They have to renotice, but it's a city agency, it shouldn't be. Like they have to go through community board.
Okay. So, but it's common law vesting, so it's a big.
It's common law
thing.
vesting, so it's a big application.
So it can't go on like.
It's not gonna go on one of the small ones, 29, 26, 18. I think Commissioner Sheeta should be here because it's vesting.
Yes.
May 21st is Target, June 4th is Frick. We could also do June 11th. There are 8 cases on it right now.
That's good.
Okay. So
June
it'll be postponed to June 11th?
Mm-hmm.
That will be the first
And
hearing.
notice to DOB is how much in advance?
Well, they were supposed to give notice to DOB with the filing, so that should be as soon as possible, so they can provide a submission in response. I'll ask Ms. Matias to get into DOB. But, okay, so June 11th will be the postponed date.
Zoning calendar, continued hearings. Item number 18, 2016-1208, BZ, 300 East 64th Street, Manhattan. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Okay, please sign in here. This applicant's representative.
Good afternoon, Frank St-Jacques Ackerman for the applicant. We attended yesterday's review session and yesterday evening submitted the Cerami report. after we had an opportunity to look over it. I'm here today with Tracy McIntosh. She's the Chief Development Officer of Barry's, who can speak to sort of the ongoing work at the studio. But I think per your comments yesterday, and I think, you know, how we move forward with this case is sort of largely contingent on what's I understand that there's one of the residents is here today to testify. Barry's has not heard directly from the residents since around the time that the board has. It's our understanding that.
But I thought they conducted testing.
Correct. I'm sorry. And just in terms of new issues or new complaints raised, new concerns since the testing, you're absolutely correct. The residents were involved in the testing. It occurred in their apartments. But as you know, based on the letter that our office submitted earlier this month, the testing occurred. And you see from the report that Cerami has not made new recommendations with respect to additional measures that were to be taken. Tracy has identified some additional changes that Barry's is going to undertake. They're waiting for the Cerami report to go ahead and start that work, but those changes involved isolating speakers in the studio, reinstalling fire protection materials on some of the beams in the rear of the studio, wrapping those beams with sheetrock, and then adding some additional sound attenuating materials. There's a rear door at the studio to sort of further attenuate that space.
I have a question about that. If Cerami made no recommendations for additional work, then what's that work based on?
That work is simply based on, so Tracy's been with Barry's for about 3.5 years. Those are just additional measures that she thought would be appropriate. These issues with sound happened after the studio had been in operation for a number of years. So I think this is intended to sort of further ensure that there's not going to be additional issues. You're right, though. They're not based on Cerami's recommendation in the report. That report does not recommend any further changes.
Okay, so you said it's been, when did this only opened fairly recently, right? When did this open?
No, it opened in, my notes.
January 2016.
Correct.
Oh, okay. All right.
So it's been in operation for about 3 years now.
I didn't have that in my notes. Okay. So one of the questions I have, is someone from Cerami here?
There's no one from Cerami here.
So one of the questions I have about the report that we only received at like 5 o'clock last night, is the ambient noise levels in the prior testing in December were 35 dBA. And were 32 dBA. And in this recent study, they were 35 dBA for ambient noise. So the analysis to overcome was less in the current testing. So if you've got an ambient noise of 35 dBA, and let's say noise levels are achieving 38 dBA, it's considered within tolerance, right? But if ambient noise levels are at 32 dBA and the readings are 38, it's not within tolerance because you're not supposed to have a 5 dBA change. So what Cerami did, for some reason that I don't understand, is it used a different base ambient noise between the testing in December and the testing in February, so it's not apples to apples. And maybe they tested that it was a little noisier that day, but that doesn't really make any sense because it's not apples to apples. So I'm kind of confused about that.
So I am not going to try to speak directly to that. I can ask Cerami to submit something in writing to explain, I guess, the difference between the testing in December that occurred during the afternoon and the testing that occurred at the end of February in the morning, to sort of just detail of what the difference is between those two testing environments.
So I know there's a difference between the two testing environments, but the resulting conclusion is that in December, there was audible noise because you're setting your ambient lower in December than you are in February when you retest. So their conclusion is in February that there is no impact, whereas if they had set their ambient at 32 in February, they would have come to the conclusion there is impact. So I'm not really that interested in why the ambient was 32 yesterday and 35 today. If you're going to make a comparison between annoyance and annoyance, you have to use the same ambient level. Can't shift it.
Again,
Okay,
I'm
that's
not
why
a sound
you needed to have
consultant, but
Cerami here,
Or
right?
at least use the more conservative number for the
yeah.
ambient. If you measure the ambient 5 times and it's different, when you pick a level that gives you the extra cushion, the maximum
Right.
protection.
The lowest one.
Right. And then the other part is, so we did get a submission, and we will hear from the neighbor, but we did get a submission from the neighbor, and I actually was going to play the little video, the little noise recording, that when the testing was done, only one weight was dropped. It wasn't a class where weights were dropped. Instead, it was a class where bands were used, and apparently there's also classes where, we know, there are classes where weights are used and everybody drops the weight at the same time, even if it's not from very much. So, and that in prior experiences, the thuds of the weight dropping were audible. So how can a test that's using one weight by one testing consultant as opposed to the class, like why wasn't the class one of the more aggressive classes during the testing? We see this done all the time when we're experiencing working with these gyms that are nuisances, right? So where the testing is skewed in favor of the gym. The testing has to be the most conservative kind of testing. The day when everyone comes and jumps up and down, or whatever the thing is, it's a step class where everyone jumps off of their elevated thing, whatever the thing is, right? And instead, this was a band class, apparently.
So I wasn't present at the testing.
Right.
Tracy was, and obviously Sarami was. We can speak, more to that in writing. But I again, as I was not there, I can't make any conclusions about the testing or the testing results. But we'll submit that in writing to the board. I'm happy to step down to let Dr. Dua testify, and then I'd like to be able to respond afterward.
I'm trying to. You're listening to the recording?
I'm trying to listen to the recording, but I can't really hear it.
So she sent
I need to, okay.
5 recordings.
No, I have the live recording, and I was trying to see if it would pick up, but it's my little speaker as opposed to headset, so it's not really working.
If I could be provided with a copy of the recording, that would be helpful.
Thank you.
Okay, are there speakers?
Okay, please sign in here. Put the timer.
So,
State your name, please.
Prachi Dua. So I was present during the sound testing. So that was like one of the most quiet mornings. So I knew that the sound testing was going to be like normal. So
when you say quietest, what do you mean? Like the ambient noise was quiet, or the class was quiet?
I didn't hear anything in the class. Nothing.
And that is
not even a single sound that morning.
And how is that different than other mornings? I hate to interrupt. But
Yeah. So at 5:40 that same morning, I heard the instructor. And then at 6 o'clock, I didn't hear any during that sound testing time. I didn't hear anything in my apartment. And so basically, since the installation of the floors, I just wanted to thank you guys. Like the weight dropping is at the minimum. So like once in a while, I'll hear the weights, at like 8 o'clock, 8:30, like at nighttime, but so much better than before. So thank you for that. And then basically, from time to time when I come back from work, like I'll hear, like there are 2 or 3 instructors that I can clearly hear. And I know it's my iPhone recording, so like the sound isn't that great, but if you actually put it against, maybe I can try to try it here. You can hear like the instructors say 5, 4, 3, 2, 1, and it just isn't one instructor. There are like 2 more that have the same sound. So we did make progress. I'm not saying that we didn't, but I still hear the instructors, and I requested that we need to do continuous sound testing, because just doing one class like for 1 hour it's not going to help. It's not reflective of what's actually happening. So that's where I stand like right now. Like I still hear the noise, so I'm not satisfied with where we are. We have made improvement, but I still think there's still room to improve.
Noise, what is this noise limited? Do you still hear weight dropping, or is that no longer an issue?
The weight dropping I hear once in a while, but not every day like I used to.
So what do you mean by once in a while?
Like I'll hear it like, so for example, like my recordings are from like 8 o'clock, so when the busiest classes, that's where I'll just sit in my living room, or I'll be there and I'll hear like the thudding.
And how often would that happen when you hear it?
I mean, like once every day, like while I'm in the apartment. Yeah.
Once every day? That's not once in a while. Okay.
Yeah. But it's not continuous. Like.
What is continuous?
What is continuous? As I said, like the voice of the instructors, that I hear like 2 to 3 times a week. Yeah.
Throughout the day, or just?
I'm not in my apartment all day. I'll hear it sometimes like early morning, like when I'm up, or like when I come home from work.
And is it fair to say that's your major concern, is the voice?
Yeah, my major concern is the voice control, because I think that the sound is controlled basically by berries, right? Like the sound is like controlled by berries. So that's my main concern. Like they did install the flooring, so the weight dropping is like much better. It's like tolerable, but it's just that like what I'm concerned about is that like if the control to the sound is like changed, then it's.
Or to the mic, I was.
Yeah, to the mic. Yeah, to the mic is changed, then we're back to square one, right? Like because.
I have a question. So you say there are a couple of instructors that you hear regularly.
Yeah.
Is it like the same class every week, and that instructor you just hear like clockwork? Like a particular 1 or 2 or 3 instructors that are louder than others?
Yeah.
Yeah. Mm-hmm. Have you communicated what those times are to Barry's bouquet? Maybe we can.
We can. I think it was communicated by my neighbor, who isn't here today, but she also said the same thing, that it was just a couple of instructors, which I don't understand, because if the mic is controlled, like why are we hearing some instructors and why aren't we not hearing
because
others?
At some limits, someone's voice can carry a lot further. Than,
different pitches, that's why. Yeah. So up until like February 19th, we were getting a log from you and from your neighbor.
Yeah.
And then the log stopped. So as a result, the Barrys didn't get any notification that there were problems. So I don't know whether you've been communicating to them or to the condo board about this issue, but if we don't have some kind of constant log that gets forwarded to them, because at a certain point you actually sent us texts that you had been sending to Barrys, right?
Yeah.
So if you can, when you hear this and you immediately send a text to them, then there's a record, first of all, then there's an announcement to them that there's still a problem, and then there's something that we can do about it, right? So if you let us know that you've just let them know that there's a problem, then we can contact them and say, there is a problem today, and you therefore need to do something right now, and not wait until, because what's happened is you've been experiencing these problems. Your recording is from March 5th. Here we all are, 21 days later, and nothing, we were unaware, they were apparently unaware, I'm not sure, and could have done something about it, right?
Yeah.
So I know it puts a lot of responsibility on you, but the only way that we can resolve this is by saying to them, it's not, whatever your efforts are only working somewhat.
Yeah, I know. It's just that like I was trying to. I have a log on my phone. It's just at random times. So like sometimes like, and I'm not in my apartment now, like because I'm working like full time. So it's I will give you like whatever I have, like whatever times I come home and then I hear it.
That's what it is.
Yeah.
It's whatever you experience. It doesn't have to be that you hire somebody to sit in your apartment to experience thuds, right?
Yeah.
That's okay.
Okay.
Thank you.
Thank you.
Okay, please.
I think I would like some clarification of the kind of classes that are held and the morning operation during which time the sound testing was done, what kind of class it was, and how is that a typical kind of class?
Sure, and I'll sorry to cut you.
Right, and as I think one of the commissioners mentioned, I think we should be using the most conservative base to determine what the noise level is.
Sure. So, and we'll just have Tracy McIntosh from Barry's come up for a moment. I will say, and she can clarify that no staff at Barry's was informed that the testing was going to occur the day that Sarami came on February 28th. So they were as real conditions as could be. I'll have her speak to the nature of those classes.
I'm not making any accusation. I just want to know what kind of class is typically held at that time, and was that representative of that? That's really what I'm saying.
No, just for the record, though, I want to be clear that there's, the testing was intended to be as pure and capture the circumstances that the residents have described as possible. I guess maybe there's no need to bring Tracy up to describe the specifics of the types of classes. They vary. Maybe we could submit in writing to the different types of activities that occur in the classes. I think what I'm hearing and what was attempted during the last testing was to use loud instructors, the types of potentially disturbing activities that to provide the most conservative testing environment.
Do you think there's a solution to the concerns you just heard?
I think so. We were under the impression that maybe we had reached that point, having not heard sort of real-time complaints from the residents. I'll just, again, for the record, state that both Tracy McIntosh and Matthew Schwartz of Barry's, the residents have their cell phone numbers, and they can also contact the Barry's desk in the event that they're experiencing issues. Barry's their goal is to provide real-time responses to these issues.
Don't you think that perhaps lowering the microphones would be something we can do today?
So that's something I'll have them look into. And again, for the record, the audio is not. It's controlled off-site essentially. There's no staff member at Barry's can adjust the volume either upward or downward. Mm-hmm. They'll call in their sound consultant to adjust the levels again. That measure is there to prevent issues with instructors turning things up and inadvertently causing issues with
it sounds like some people are picked up higher than others.
Right.
So
and I think that's something that can be addressed relatively easily and quickly.
That's our hope, and again, this is why I'm referring to sound levels rather than volume, because it appears to be, again, I'm not a sound consultant, but this appears, based on what we've heard today, if different voices are being picked up in a different way, the sound consultants hopefully can work to adjust the levels downward.
There are limiters they put on these, so they can't output more, so it sounds
Correct.
like the limiter is set too high.
We'll have 11 Audio look into that, but that's simply a matter of having someone come in, look at the system and adjust it downward or however, but that's absolutely something that Barry's can do.
But before you do that, I just want to add that in terms of the testing, if the issue of the dropping of weights is something where regularly the weights are heard, but the class that was held that morning of the testing didn't include weights, then it's kind of odd to have used that as the testing class. So though the instructors may not be informed that there's testing, you can always add, sort of schedule the testing at a time when the more annoying of the classes is, right?
Right.
So instead of doing it on a Tuesday, you do it on the Wednesday weight class as opposed to the Tuesday band class.
Sure.
Right?
So 5:40 is the time that it's loudest there. Is that? Sorry. Can you step up for a moment? What time is the loudest class?
She has to speak from the podium.
Sorry. What time is the loudest class in the morning?
I think it's like, so I leave my apartment at 7, so I start hearing at like 5:40, 5:45, like that morning,
Say
and
that's
then,
the worst time?
yeah, for me personally, because that's the only time I'm there. And then basically, when I come home at night, like at 8 o'clock, that's when like 8 to 9, I could still hear the instructors. But my neighbor, I think she's at home mostly during the day, so maybe she'll be able to give a better idea of.
She's not here today.
Yeah, she had a.
Okay.
I'm sorry, can I ask a question?
Sure, of course.
When you hear the voices, do you hear music? Is there music going on as well, or is it just the voice you're hearing?
So I can hear the voice, and then like the music, not to the equal degree as the voice, but you could still hear a little bit of it.
Okay. So you know, what makes sense about this is that 5:40 a.m., the city is very quiet, right? And of course, you're just kind of waking up and so on. And the same is true from 8 to 8 on. The city starts to get quiet. So that's why, if the testing is done at 7, where now we're into full commuter time and the trucks are rambling down, then you've got an ambient level of 35, which skews the analysis, right? Which is why the testing needs to take place at the 5:40 class and at the latest class in the evening, when the city is quiet and ambient levels are 32. It just makes obvious sense that that's why you're hearing it, because hardly anybody is awake at 5:40 in the morning besides you. So.
Yeah, like
okay.
Yeah.
And the people in the class, right? Yeah.
Yeah.
Okay.
Thank you. Thank you.
Yes. Okay. So what we understand is we still have a problem. More efforts have to be taken. Cerami's recommendations have to be to looking at the 32 dBA baseline, and the recommendations they'll make then to address these problems, because there clearly are problems when it's quiet. And then I'd ask that Ms. Dua keep a log, and also whenever she notices that there's a disturbance, to immediately text the gym to let them know that there's a disturbance, but also keep that log for us and send it to us, so that we know right away that there's a disturbance, and we'll contact the applicant and let them know that we're still not there. And then the other part of it is what?
Reconduct testing?
Yeah, reconduct testing once the measures have been put into place, because obviously it's not working right now. And the measures should not just be what's suggested by the gym owner based on their other experience at another gym or however that was based, but on Cerami recommendations for how to deal with a clear, continued problem. Okay.
Understood. So I will discuss with Cerami further testing. I'm hesitant to make any conclusions about their testing methodology and the baseline. I'm not a Southern consultant. I will ask them to explain and examine the methodology used here.
No, I don't need it explained. It didn't take place at 5:40 a.m. or 8 p.m., so it's pretty obvious that the ambient levels are higher when the city starts to really move. At 7 a.m., you've got traffic jams on the street and the trucks rambling along and all of that stuff. So clearly ambient levels are higher, and the competition with the ambient, therefore, is less, right?
The testing did occur from 6 to 7 a.m. though, so it's as close to 5:40 as can be. There's 2 classes that were.
Maybe you didn't hear.
I did hear.
There's a class that starts apparently at 5:30, I'm guessing, because 5:40 is sort of an odd time to start a class. So I'm just guessing the class started at 5:30, and that the neighbor is aware of noise coming from a class that starts at 5:30, which she notices at 5:40, because it probably takes 10 minutes to realize where you are that morning, right? also notices a class being annoying at 8 to 9 p.m. So clearly the testing needs to occur during the times when it's annoying, right? Okay, so let's just get past that, all right? And not try to defend, because if you're defending the testing, it's not going to get us anywhere. But just to
No,
clarify.
I understood. I just wanted to
Right.
clarify that, again, I'm not a sound consultant, but the sound consultants did perform testing from 6 to 7. And look, I'm not arguing with you, but we will conduct further testing earlier in the day with more conservative conditions, including finding a way to introduce weight dropping into the class without skewing the results in any meaningful way, or in any way, and take it from there. We'd also just like to, again, continue to be informed in real time if there continue to be issues.
But it might be helpful, because I just heard you say a way of incorporating weights to an extent that doesn't skew the results, but Ms. Dua is clearly experiencing something about a particular class at 5:40. So maybe if you can compare notes with her and find out what that class is
Sure,
at 8 o'clock, then you can just run the testing in
Right,
that class.
and I
You
think
don't have
that-
to introduce anything that's not already.
Do you have the same gym program every day?
No, I mean, I think that's
So
the
it
thing
varies
is,
from
it varies
day
from
to day?
instructor to instructor and class to class. So I think having real-time information about disturbances will help narrow down on particular instructors, particular classes, particular exercises even. Again, we're coming into this hearing with, not full knowledge of what the degree of complaint is. So we haven't been able to use this time since the last hearing to narrow this down. So it's we'll endeavor to do that now before the next hearing, and then get some testing in place to move forward.
I wasn't talking about within the same day you're repeating the same class. I was talking about, let's say today is Monday, tomorrow's Tuesday, Wednesday. On Monday, you do class 1, 2, 3, 4.
I believe
On
that
Tuesday, do you do the same?
I believe that the schedules are the same as far as the time of the classes of each class.
Excellent.
Probably different.
And the activities within the classes are
different.
Different.
Correct.
And the instructors aren't necessarily the same for the same class.
My thinking was if he gets ceramic, like on site for a full day, they can pick which time is like the most noisy time and they can perform testing during that. And it's going to be up to them to pick, test, give recommendations, and clear the issue.
I mean, I would guess that having a sound engineer on site for an entire day is quite expensive, but I think there's a way to get to it quicker, which we have neighbors who testify or who observe disturbing times. If we can just match what that schedule might be, then you can identify the times that way and not have to waste potentially the.
I agree.
Yeah, okay.
Okay.
I just wanted to
state your name, please.
Tracy McIntosh with Barry's. I just wanted to speak to the class schedule. So every day is a different body part, combination of body parts, and the schedules generally hour by hour are the same, but the exercises differ to address different body parts every day. And when we scheduled the test, we put some times out there. Those times were accepted. So
how about we just do it this way? How about for the next 2 weeks, you'll stay in contact with the tenant. You'll tell them the days that and what times is the most loud, and see if we can get that on that day. That maybe if after 2 weeks we find that's both on a Tuesday, we'll know that next Tuesday if we can schedule a sound testing for that day. I think that settles it. Sure, come on up.
I just want to note that that Prachi has my email and my cell phone number, and from that day, and I've heard nothing since that day.
We
So it's very
understand that. We
difficult
understand.
from
I
the business
appreciate
owner
that.
standpoint to
Understood.
address anything in real time, which we have begged for to make any adjustments or to understand where the problem might lie.
I have a question, Ms. McIntosh. So you just said that you put times out there and they were accepted. Who are they accepted by?
The building, the tenants. It was 6
So they're-
a.m. for a Tuesday. And just to note that the testing lasted so long that it bled into another class. So we did real class testing that was scheduled for 6 a.m. We did non-class testing which they did isolated weight drops, and then it bled into another class, which was what most people deem a louder instructor, and have test results from that class as well. So it spanned 3 different times of the day, and the ambient isn't set by anybody. The ambient is what it is. They test the ambient.
No, we know that.
So at 6 a.m. it's pretty, it is what it is at 6 a.m.
Right.
Happy to do it at 5 or whatever anybody wants, but
What's the
that's
class
that's
that you
the time
teach
that
at
was accepted.
5:40 or 5:30? What's that class?
It's so on Tuesday it's abs and tush, and so there are definitely weights in that class for squats, and so on Tuesday it can be different instructors throughout the day, but it's that program throughout the day. Wednesday is a different day, Thursday is full body, it just, the schedule is constant.
Yeah. Okay. But at 5:30 on a Tuesday, when you're doing abs and tush, what kind of class is it? Or is it change, that 5:30 class isn't the same class
It's
every?
the same as the 6:30, as the 7:30, as every Tuesday class throughout the day. So only
so
that.
it's the same exact class over and over, except with different instructors?
Yeah, and they program it a little differently, but the point of that class is abs and tush.
Mm-hmm. Okay, but it's using the same equipment throughout that day?
Yeah, somebody might use sand balls, somebody might use bands.
So on the
somebody might
days
use
when,
weights.
for argument's sake, it's legs, what is it using a different equipment that might be noisier somehow? Like, are you using?
So the treadmills should be the same at all the time, right? And one thing that I thought was interesting is that the treadmill, there's no vibration or anything getting through the structure with the treadmills, where they take them on an incline and everybody sprints, and there's a lot of impact there. So that none of that was picked up, which I have seen in the past and had to address. And then I think maybe like chest and arms day would be a good day to test, maybe, because maybe there are more guys using heavier weights, but
Okay, so which day of the week is chest, arms?
I do work for Barry's. I don't
Okay.
do the
Anyway,
workout.
so
I
to
just
keep
know
that
what
in
Tuesday
mind,
was.
so maybe
Yeah.
Tuesdays wasn't the best choice. Maybe it should have been.
I don't know what
a
the other
Thursday
one was.
for whatever the other day is, right?
I think the other test was on a Thursday, which, was a different program. So I think we were trying to mix it up. So we had 2 different programs, one with what we believed at 6 a.m. to be very low ambient noise, and which was accepted by everybody who we put it out there to. Could have done 5 a.m. very easily.
Okay. You have a class at 5 a.m.?
Yeah.
Well, obviously.
Oh,
Yeah.
no, I thought it was a class that starts at
5:30.
5:30, so it's a 5 a.m.
I don't
class.
know. I thought that she just said she heard it at 5:30, so it could be a
Yes, she
different
did.
part of the program.
But I'm asking when your earliest class is. Is
Yeah,
it 5?
5:15 is the start time, I believe.
Okay. Thank you. All right, so last time we heard this was a little over a month, was like 6 weeks ago. So can we maybe set this up for the same in 5 weeks ago? Yeah, 5 or 6 weeks.
We did have, there was an unanticipated delay in receiving the report. We thought we would have the report, probably a week sooner here. So I don't want to push this out too much further, but in the interest of everyone having all the information necessary before the next hearing, I just want to take that into account.
Okay, so maybe give you 7 weeks.
Well,
so
wait a
you
second.
can get the next
So
report.
you did testing on February 28th, and the report came in a month later.
Correct.
Right? So here we are on the 26th. Oh, and you got the testing done 10 days after our hearing, basically. 8 days after our hearing. So it takes like a week to schedule the testing, right?
Yeah, because it takes two guys.
Two sides, yeah.
Or just from a surrounding standpoint, it takes a couple of guys to be in different areas to do the testing. And they just have to.
So it seems like 6 or 7 weeks is ideal. Did you have, are you going to be out of town or something?
Is it okay if we do it for like 2 months? Because I just want, like, I want my, I don't want to do sound testing like prematurely this time around, because it's a waste of, like, I just want to make sure that we have a month or 6 weeks of good logs where we like match our my neighbors and my
Okay.
data too.
Oh, so prior to them doing testing, you
Yeah,
know what
because it's
classes
kind
to
of
do
it's
now?
kind of useless. Like it's
Yeah,
a waste
okay.
of money and resources. So
That's
I
fine.
rather just like just have the 2-month like data like in hand, and then I'll communicate with Ms.
Okay.
McIntosh.
So 2 months of data, therefore, we would put it on a little bit later than 2 months, right?
Yes, I'm just
But to
thinking aloud
balance the
here, but in
interest
the interest of
the
of not having you, or having the residents experience disturbances over the course of a
Well-
long time, I'm just trying to think of
So the idea is that you're supposed to be making modifications right now.
understood.
Right?
Right. It's fine. It's,
Okay.
if-
It's a good chance, actually, to look at conditions and pick the worst
understood.
condition. You got 2-month time window.
Right. I think if there's good communication and we're able to respond to issues in real time, make further adjustments to the audio, that seems to be that's fine. That's understood, and we'll set up some testing after we've have sufficient data to do so.
Okay. All right, then. So
I just
we're-
think the most important thing is the real time. It doesn't help me
Yes.
at all to get a log of what was potentially heard a month later. You know what I mean? It's where I'm trying to
No,
look
we've already
backwards.
discussed that Ms. Dua and her neighbor ideally will participate in this by sending text to you and copying us with them daily, right? Okay, thank you.
And I think the sound limiter is something that you can address now.
Right.
Right. After this hearing, we'll start to make those arrangements.
Okay. What are we talking about? 2 months?
2 months for submission or 2 months for hearing?
2 months for submission.
Okay, that puts us at May 22nd for submission, for a hearing on June 11th.
Just 1 second. Okay, May 22nd submission, June 11th here.
That's right.
Thank you.
Thank you.
Item number 19, 2016-4127BZ, 1547 East 26th Street, Brooklyn. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Thank you.
That's
Yes.
Good afternoon. Dennis Delangelo, I'm the applicant representing the owner. Apparently, there are solutions for all problems.
You see? You see how that works?
I think we...
It just
we
takes
made
an
it.
architect with some willingness.
Thank you.
Okay, so thank you very much for the corrections, the modifications, et cetera. So are there any speakers on this? I would like then to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition is the standard condition. Removal of existing exterior walls and joists in excess of that shown on the plans will void the special permit, which is already shown on the drawings.
Yes.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Motion is granted.
Thank you. And I would like to take a moment, as this may be my last appearance before this board. I would like to thank the chair, the board, and staff over many decades, not just the current board, but this agency has shown a professionalism and a courtesy to, I think, applicants and the public, which should be acknowledged. And I would like to note, in my own capacity, the sharp decline in applications on the calendar for these special permits in Community Boards 14 and 15. I would ask if the board might be open to a dialogue with the industry, the professionals, possibly the public, on any upcoming changes or administrative or procedural, not on specific jobs, but sort of a heads up to the industry, if the board is considering a change, maybe some input from the professionals and the community boards.
Always, we're always open to those kinds of dialogues. Someone just needs to reach out and request.
Are you retiring, Mr. Delangelo?
Yes, I am.
Congratulations on your retirement.
Yeah. I didn't think architects can retire. It's like not physically or emotionally possible.
It's a huge pipeline that is going to be with me probably in my retirement, but as far as active jobs, new jobs.
Oh, so you're not taking
No
on
more
any
new
new
work.
jobs?
No.
Okay, well, we really appreciate your comments. Thank you very much. And thank you for all of your appearances.
I wish you well.
And
Thank
all
you.
of your work.
And good luck.
Good luck.
Sure.
Item number 20, 2016-4240BZ, 1231 3rd Avenue, Manhattan.
Yeah.
Do you affirm to tell the truth, the
This
whole
is an
truth?
adjournment. He doesn't need to be sworn. Oh, you want to speak? Okay.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do. Good afternoon, Madam Chair, Commissioners, Frederick Becker. Again, my apologies as set forth in my letter to Mr. Costanza, which I believe you have a copy. The one outstanding item, we did the posting, there is no one here, was the issue of Longman-Lindsay sound report in relation to the acoustical measures that were undertaken at the space and whether the acoustical measures were in, I won't say compliance, but coordinated to what the recommendations were by Longman-Lindsay, correct?
It was administratively adjourned.
Right.
This is adjourned.
Okay,
We're not
so-
hearing the case,
Okay,
right?
so what I'm saying is, I spoke to them, they can get me those comments in a matter of days.
Oh, so you're just talking in
Right, I'm
terms
just,
of like
I'm
the
talking
next
about date,
hearing?
I'm not talking about, no,
Yeah,
it's not
yeah,
substance.
understood.
I'm
Okay,
talking about
okay.
time. I have a whole series of cases on April 23rd.
No.
29 cases on that day, unfortunately. Yeah.
Okay, well, I can get the report within a week, so we'd like to put this to bed, please.
So next day, it's 26th.
I mean, the first weekend in May would be nice, please.
April 17th submission. Can you get this to us by April 17th?
I can get to you by April 2nd, so yes, the
Great.
17th easily.
Okay.
So that would be a continued hearing for May 7th?
Fine. That's all I wanted to speak about, not subject,
Great.
yes. So it's 4/17/57.
Yes.
Thank you.
Thank you.
Thank you.
Thank you.
Call the next one, please.
Item number 21, 2016-4465BZ, 129 Anderson Street, Staten Island.
Right.
Oh.
Look who's here.
Hello.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Thank you. And you could just sign it.
It is, but I think he's going to say something.
Good afternoon, Ian Rasmussen, on behalf of the applicant Rothkrug Inspector. I believe an adjournment has been requested.
Yes.
I'm here to stand on behalf of the applicant as a courtesy to you.
So nice.
I believe the applicant may have known there are issues related to title and has told me to request 4 weeks.
Oh, 4 weeks.
Okay, for submission, I'm guessing.
Yes.
So that would be, oops. 1, 2, 3, that's around April 24th. Okay, this is a variance. Okay, I'll tell the board, May 21st hearing, there's Target, the Target appeal is on.
I don't, no.
June 4th is, the Frick is on. June 11th.
Yes.
Okay. So you're adjourned to June 11th with a submission on May 22nd.
Submitting May 22nd with a hearing on June 11th.
Right.
Thank you.
Thank you.
Thank you.
I think now the board's going to take its lunch break.
Yes, because the next one might be long.
Sorry, because the next one's going to be super long.
Or
We
might
take,
be.
a break every 2 hours.
So the break will end at what time?
We should.
The break will end. We'll come back on the record at 2:30.
We'll be back on the record at 2:30.
Thank you all for your patience.
We are back on the record. We will continue with the zoning calendar continued hearing items. Item number 22, 2017-246BZ, 6163 Crosby Street, Manhattan. Everyone who's part of the team that's going to speak should step up. And I'll swear you all in at the same time. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Thank you. You can start signing in here.
You mean on SharePoint?
The one that I downloaded this morning.
So up here, right?
Yep. You can also put it here. It's
Okay, if I
you're
go
part
ahead and
of
get
the team.
started?
Yeah.
While they're signing in? Great.
Well, actually, wait a second, because while they speak, it picks up on that mic.
Okay.
So just give it a second, okay? It's simply that being closer to the video, that's what the video defaults to.
Okay, so we were at the
I'm sorry, please state your name for the record.
Maria Papasevastos, Cybarth Shaw, on behalf of the applicant. We were at the review session yesterday, heard the board's comments. We have our full team here to address those comments. First, I did want to go through a bit of the A finding first and the uniqueness, and kind of summarize applicant's position on those points. We, of course, since the last hearing, provided a structural engineer's report that goes into the details of why the wall that we've been talking about so much cannot actually be removed. Not only because of the prohibitive costs, but because of the high risk to the structural integrity of the building, as well as other buildings around it, and the health and safety of the workers who will be working on the site. So I believe we've shown, based on that report, that the wall cannot actually be removed in its entirety. But what I wanted to make clear first at the outset here is that the wall is one of 3 unique physical conditions that applicant is claiming for this property that create applicant's hardship here. We have the building as a whole that is obsolete for a conforming use. We have the ground floor.
Are you going to go into more detail about that? Because this already was discussed in the review session. Are you just making this list, or are you going to go more into it? Because that was already discussed in the review session. If the building is obsolete, then why are you proposing to convert it back to a conforming use, as in use group 6 retail? Use group 6 offices on the upper floors.
Well, those are all permitted as of right. And
correct. Right. That's called a conforming use. And if the building were obsolete, and by the way, those uses existed in the 19th century up there. You know, the way these buildings were mostly used is the ground floors were used for some sort of either heavy or light industry, and somewhere on the upper floors it became the offices for whatever that industry was. And some of them were actually just offices. So, which is why in 1961 they decided that offices are the right uses for upstairs in this zoning district. So I'm not seeing how obsolescence works. When we see an obsolescence argument where the applicant tries to persuade us that the conforming uses will not absolutely work in the building because of whatever kind of physical conditions, something about the elevators or whatever. But this is the opposite in this case. That the owner has chosen to revert to a conforming use and leave what's also a conforming use, the joint live work for artists, but which was created under a kind of special circumstance about existing occupancy, right?
So our position is that regardless of how we were going to go forward with the building and use it, we needed to make these updates to the building. They included the elevator. We didn't have an elevator. There were the two separate staircases of the building on two separate stoops that went up.
So it might be up if you say why we needed to make these updates.
Why we needed to make the updates to the building. Well, I think David Greider can. Okay.
Also helping on the application, but I think Maria just
State
wanted to
your
give.
name,
I
please.
said Juan Reyes. I'm also an applicant with Maria. We do have our team that's going to go in more detail. I think Maria was just trying to summarize what was said in the hearing before and what we're going to go through. But we do have, like Maria started to say, we have our architect here. We have our financial consultant here. We have our consultant that did a uniqueness study. So we're going to address those issues, and then I think if there are questions after that, I think we can elaborate more.
Okay,
But if you'd let us do that.
Except I just want to say that this is hearing number what, 4?
3.
3. So we've heard a lot of this already, and so to the extent, and of course we've read your submission, and yesterday's review session was the various commissioners expressing their opinions about what we've read so far. So to go back over where we've been.
Well, I think we're going to address
won't
your questions.
So,
with our
okay, so
experts.
it really needs to be new information, not rehashing old, or, because I think at this point, I don't know what would persuade me that the obsolescence argument is working, because every building eventually needs to have repairs done to it, especially if it hasn't been upgraded in a long time, right? And this is in a very, very high-end zone, so naturally, eventually, the elevators either are installed because you've decided that you're going to install an elevator, because if this, as a joint live work quarters for artists, for instance, those occupants were willing to put up with the absence of an elevator, or maybe it was some kind of an elevator that's more typical of these buildings where it's in the front, and then it was made automatic because that's probably was part of the building code requirements. And the choice to either install one or remove one is business decision, when the business decision is to convert the use from a conforming joint live work to an office where the target market requires nice new elevators, for example, and where in this case you're adding a floor where the target market won't be willing to walk 6 flights of stairs to go into an office. So these are all business decisions. I don't see how this has anything to do with obsolescence.
I'm not an architect, as you are, but I think my architect can address those issues. So would you allow my architect to respond, because I'm not...
I just want to say that we've been through these same set of arguments several times already, and I believe we gave you one more chance to meet the threshold of having an A finding, and I don't see why we have to cycle through all of
Well, I think you're bringing up intelligent, new issues.
Please don't interrupt her.
Okay.
Let her.
Issues, because I didn't read any new issues.
I don't think we've actually addressed all of the unique updates that had to be done to the building. We're not talking about typical updates that would have to be done for any building in Soho. We're talking about specific issues for this building. For example, there were...
Because it hasn't been a settled fact that this is one building. You may keep insisting that it's one building, but there are members of this board who do not agree.
I mean, the certificate of occupancy says that it was built as an addition to one building.
No, it was built as a second building or joined. That's what the testimony says. It's a separate party wall. You don't, when you're doing an addition, you do not build another party wall and then knit it together. An addition is you continue the existing lines and you thread your joists into the existing bearing wall,
We don't
right?
understand that, how to explain it as well as our architect, so if he could discuss that with you.
Right, so I'm feeling like you're not hearing us. We said that we don't think the building is unique, that your upgrades are caused by the uniqueness right? So the idea of upgrading a building because a building must be upgraded, it's 150 years old or something, this building, right? And so, or 120, I don't know exactly the build date. And so I should think you would install an elevator 120 years later, or a better elevator after then, especially if you're choosing to change the use. So I think we need to move away from that, because a building must be upgraded. That's part of ownership of a piece of property. And if an owner decides in the process that the owner wants to change its use, then naturally you need to upgrade to meet the change in use. But an obsolescence argument is that the building no longer functions for any conforming use. And that's the opposite of what you're demonstrating. The building, not only did it function for a joint live work quarters for artists, but it also functions for a conforming use group 6 use. So we need to be done with the obsolescence argument, because you're proving it against yourself.
I'm just going to ask my architect to come up. David, could you please come up?
Are you arguing against that point, or?
I'm not. I'm going to ask him to respond to that, because I can't
But
respond to that.
you're asking the architect to make an obsolescence argument for you. Yeah, so, okay.
Yes, that's clear. Your name for the record, please?
I'm David Greider. I'm the architect for 6163 Crosby. I don't feel qualified really to talk. Well, let me explain myself. I don't feel qualified to talk specifically towards this question of uniqueness. I'll make a couple of observations. First, the building was built as an addition. We know that because it was, the second application was an alteration type 2 to the original building. And the construction of the wall is knitted together in a way that it's an integrated single building. And I won't say any more about that.
Okay.
The other thing I'll say is relative to the elevator, as others have noted, there was no elevator in the building. And when we first talked about this project, I made the observation that given that the building was totally vacant, it was taken over totally vacant, there was no viable way that ownership could reoccupy that building without leaving themselves open to a federal lawsuit under ADA, because there was no elevator and there was no accessible access to the building. So regardless of whether we had stayed with joint live work quarter or changed to conforming use like office space, we had to address the ADA question. Landmarks gives us an out. Landmarks language says you don't have to do that. But the reality is, the moment you get hit with a lawsuit, it's a federal lawsuit.
Sure, understood.
So I just want to mention those
Okay,
two
so I'm
points.
going to stay in the architecture world. Okay,
Please.
for you, because I know when you were called up to answer that, that was not fair, right? So, okay, in the architecture world, had this continued to be an occupied joint live work, would the ADA rules and laws have been invoked? Not to mention, they've been occupied that way since the late 70s.
It's a good question, and it's a hypothetical question.
Yeah.
Because the deal only happened because it was delivered vacant.
Vacant, sure,
The-
right.
The co-op.
But in your experience,
In my experience, that kind of situation gives us much different latitude. Because in that situation, you may not touch the building. You may renovate it on a unit-by-unit basis, depending on occupancy and lack of occupancy, right? And as you probably know, we have a building, let's say we have the building totally occupied, third floor goes vacant, then there's a chance to renovate it. But when the building's totally occupied, it's almost impossible to say put a new elevator in it or to bring the old egress up to current code.
right.
But that's sort of like our discussion about removing the bearing wall at the ground floor. It's a hypothetical exercise, but it's not one grounded in reality.
Right, but for our purposes, which is not your department, this is relevant to what we look at.
Right.
And the other, just one follow-up question with that. So if, for example, this building had a C of O for joint live work, right?
Correct. Yeah.
So that implies to me, and you can tell me if you think I'm wrong, that because it had a C of O for joint live work, it was originally an interim multiple dwelling, and it went through the loft board's review, and the loft board imposes on the landlord the requirements to make improvements so that it's an occupiable building. And so the loft board determined, in this case, no installation of an elevator was necessary. Does that make sense?
It makes sense, but keep in mind, that was before ADA.
Yeah, understood, but it wasn't before, it was before Local Law 58,
It was
probably.
1980, that's when the conversion
1980, so it was
happened.
before Local Law 58, okay.
Yeah.
So, right.
Right, but you mentioned that the sale occurred or the transfer because the building was delivered vacant, as if that was a condition of the present purchaser purchasing, which means the prior purchaser made a decision to vacate the building of its existing uses, which would then kick in the requirement to have an elevator because you now have an empty building. Is that what you're saying? Because then that's touching off the default.
Okay, so stay with the architecture stuff with the architect. When we talk about findings, we'll shift back to the lawyers,
All right,
okay?
I'm but a simple architect.
He's just,
No, look, I can't really speak to the legislation that led up to the conversion in 1980, because I don't know the history of that. What I know is that we have the drawings from 1980, and my understanding is that the co-op building that is legally established that as joint live work quarters in 1980, and I suspect, as you said, it was probably grandfathering a situation that had been going on for 10 or 15 years at least. My understanding is that that co-op owned the building until the time of the recent sale. And so, to your point, I don't think that there was an intermediate time, if I'm understanding you correctly, an intermediate time between 1980 and the present renovation where the building could have been, quote unquote, brought up to code. So it fell upon us. And I'll say it, I mean, it fell upon me as an advisor to ownership to say, these are the things that you need to do.
Sure, understood.
And so from my point of view, no matter what use we put in, whether we kept with joint live work quarter, we use a conforming office, some other use, we were going to have to do all of these things, including the elevator, the non-combustible stairs, you know, ADA access at the ground floor, landmarks, blah, blah, blah. I came in here today thinking that we would speak almost exclusively about the removal of the ground floor wall, because that's the new piece of information that my side of the equation delivered. But I did want to touch on those things. And as far as I can tell, in terms of how the building was originally built, every indication is it was just rag and cloth storage, all the floors. So it was, as far as I can tell, it was never actually used as an office space. You know, I just want to make that.
all right, that has to do with how this particular building was
Correct.
used. But in Soho in general, or in any of those industrial areas in general, buildings of this type were used for, maybe there was rag and cloth on the lower floors, and then upstairs was the counting room where they counted all the money from having made whatever it is they did with rag and cloth.
On the rag and cloth. Right, but I mean, you know, the office back then had a ceiling fan and that was it, and then they were surrounded by the rag and cloth. The reality is, I mean, it's another interesting facet to this building is that it actually was occupied by working artists. And so the space was very raw. So it's not like a lot of Soho buildings where it's called a loft building and it's joint live work quarters, but it's a $3 million condo. There were a couple of very high-end condos in the building, but there were a number of units that were very raw space. And so I just wanted to try to give a flavor of that. It wasn't the kind of building where we could take it and turn it over with a minimum amount of work.
Understood.
We had to do a lot of work.
I appreciate it, understood. But, you know, the fact that it was live-work meant that it had to have, at a minimum, multiple dwelling law compliant toilets and kitchens and, you know, bathrooms, because otherwise the loft board wouldn't have signed off and granted the C of O.
Well, what the loft board signed off on was a set of drawings that was done in 1980 that it didn't have a lot of conformance with what we found when we did the first walkthrough.
So those were back in the days when the loft board was brand new, and I guess it didn't quite do what it did much later, was not a grant, a C of O at all until every single toilet, you know, bathroom and kitchen complied with whatever the work letter was that was required by
Yeah,
them.
my distinct impression from those drawings was that it was a legalization effort, and it was a bare minimal legalization effort. The sprinkler system, for example, didn't look like it had been touched since it was installed in 1920 or 1930. As we said, there was no elevator.
Yes, we know this one.
You know, there was a variety of things that I would classify as defects.
No, he's not, don't take him there, he's the architect, right?
Well, no, I mean, I can talk to that. I think it is, the short answer is yes. And part of that answer is contingent upon the fact, and this gets back to an earlier question, that the building was vacant. There was no responsible way that we could take that vacant building and put it back out on the market as is. And like any of these old buildings, they're a ball of string. The moment you start pulling at one thing, you have to do the whole thing. And ADA accessibility was a big factor here, and creating proper means of egress. There are so many buildings in Soho that depend on old fire escapes as a second means of egress. And one of these days, that's not going to be allowed anymore. We just haven't had that accident yet. But that accident will come. I couldn't.
Triangle shirtwaist factory.
Yeah, I mean, there will come a time when the fire escape is proven to be a poor means of egress in Soho. We're not there yet, but we had the opportunity here, which is admittedly rare because the building was unoccupied. We had the opportunity to bring the egress system up to modern code, which we did.
So because it had fire escapes before, you were allowed to take the fire escapes off because it was unoccupied?
It wasn't so much that we could take the fire escapes off because we were in a position to build new stairs because
Right.
it was unoccupied.
But then the result of that was being able to take off the fire
Exactly.
escapes, which is
Exactly.
a better looking building ultimately.
Yeah, because the fire escapes were destroying the brownstone. You know, the brownstone dates from 1870.
it's an
And, you know, as an interesting sidebar, I could not tell, but I think it's the fire, I think the brownstone was all put on at one time. I find it hard to believe that they put it on a facade 2 years prior and then in the addition. It looks to me like it was all done at.
So wait, 1870 is the first and the second part is when?
1873 is the new building application. And again, all this comes from the designation
Right.
report. And then in 1875, there's an alteration type 2, architecture of additions. Paul Byard was one of my old bosses, so they built the southern half of it in 1875 as an addition, and the way those, as I talked about earlier, the way the arches are built, it's clearly stitched together into a single building. In any event, we because it was unoccupied, we were able to put in a modern vertical transportation system, modern egress, and as a result of that, in our public hearing with landmarks, we were able to remove the fire escapes, which is great. I mean, because now that you can get in and out of the building via non-combustible, appropriately sized stairs, and I feel that's something that we would have had to do if we had kept the joint of work order as well.
Okay, great, thank you very much. Other questions for the architect? No, thank you
Okay,
very much.
thank you.
Okay. All right, so I think, so actually this gives me a little more information. So what I'm thinking now is, it's not the current owner, but it's the prior owner, the condo board, who got all together and said, wow, we can make a lot of money by selling this building in Soho that we bought from the owner in the 80s or maybe even the 70s. And I happen to know how much those buildings sold in the 70s. It was really a yay if you could get one of those, right? And so then comes a new developer who says, I will pay you quantities of millions. And each co-op board, condo board member says, each one of us gets, and then we can all, whatever, move to Florida, buy a very fancy apartment somewhere else, et cetera. So it sounds to me like that's called self-created hardship by a predecessor in title when they decide to empty the building as opposed to slowly make the renovations one by one, which then opens them up to 88, basically bringing it up to code, to contemporary code, because if they'd done it slowly, they could have done it according to the 68 code, right? And if they put in an elevator, maybe that would have been more complicated. We see elevators put in loft buildings after the fact, and, you know, they work things out.
But also, I have a question for Ms. Papasavestas.
Perfect.
So the architect just said that these are improvements that would be made anyway. So I guess my question is, you started with saying some of the improvements were unique.
Correct.
So I guess where's that?
David, could I have you come up for that also? Just to discuss what about these conditions and the updates to the building were not what you would normally expect of a Soho building that you're renovating. Is that the question?
Well,
The 1870 Soho building.
1870
Yeah.
Soho building. So Mr. Greider just said that these were updating systems were something that you would need to do regardless of the occupancy of the building, whether it was conforming, non-conforming, whether you're coming here or going straight to DOB and pursuing an as-of-right permit. And so my question was, the applicant, what were the improvements specifically that you were alluding to in your statement, that there were improvements being made to the building that were unique to this 1870 Soho building?
So there were improvements with the wall, that the wall required certain renovations based on the condition of the wall, and the arches being interlaced that required additional construction and work that would normally not be expected of a building.
Maybe we should let the architect speak to this, because this is actually architecture.
Back to his department.
Exactly.
I have been in a number of Soho lofts that meet modern code because they're occupied by people who have paid millions of dollars for the units. And went on a walk through one over on West Broadway a couple of months ago, where there would be no issue. It's currently ADA accessible. Ground floor unit has an ADA access. Sprinkler systems in conformance, fire alarms in conformance, has vertical transportation, everything. This one wasn't like that. This one was like a holdover from 1980 in all its charm, but it meant that the sprinkler system wasn't currently compliant with code, didn't have a fire alarm system that was compliant with code, didn't have vertical transportation at all, didn't have ADA accessibility at all, and the electrical system was undersized and not appropriately installed in the concrete vault. List goes on.
Can you speak to the egress that had to be accomplished and what you had to do specifically with the walls?
Well, I think we actually know that. So my question is, if you had a client, which I'm sure you've had, who had a building that hasn't been upgraded since, we can even exaggerate it, since like the 1950s, or the last time the building code forced owners to do things, like 1938, it forced owners to do things. Arguably 68, it forced owners to do certain things. If you had a client whose last time they renovated their building was the last time they were forced to, wouldn't you then, what would you be doing if asked to bring the building up to code? Because they're changing the use, they're emptying the building, and they want to change the use. What would you have to do?
Well, hypothetically?
Hypothetically.
Yeah, my counsel, the first counsel would be anything, correct any conditions that were non-conforming with code and address ADA. Because owners can always be, if the building is not compliant with ADA, and I'll note here that 6163 Crosby was designed under 68 code per the limitations of 2014 building code. There are a number of ways that you can work around ADA per New York City construction codes and per landmarks, but none of them hold up under a lawsuit.
Yeah.
And so the building, as we took it, was not ADA compatible. And so even if we talked about an incremental renovation, we would have to address ADA, right? And we would have to address vertical transportation.
But we're just talking about a hypothetical building, not
Hypothetically,
this one.
the difficult
Right.
with the hypothetical case is that there were plenty of buildings that were built in 1950, 1920.
No,
that
I mean a 19th century building that
Okay.
clearly wasn't built according to those standards.
Then it would probably be a scope of work very similar to what we ended up doing at Crosby. However, in the end, it would probably be formulated in terms of a master plan or something like that. But the ADA question would force consideration and any life safety questions. Vertical transport might or might not be an option depending on what they're trying to do. But we would have to address ADA and any life safety
Okay, and
sprinkler
when you say a
bylaw.
master plan, what do you mean by that?
I mean over a long-term period of time.
Because the building is current, under your hypothetical, the building is occupied, so kind of little by little doing the work.
Right.
Right. Okay. Okay. Any other questions for the architect? No. Okay. All right, thank you very much, very helpful. Okay.
Barbara Cohen, real estate and planning consultant. Just to follow up on the two scenarios you're sort of have been kind of alluding to is, one, what if it wasn't occupied with joint live work? In fact, this scenario would be one in which those rents would be what they are, would create a burden on the financial performance of the building, and you'd basically be right back here seeking exactly that.
Sorry, I'm missing.
I don't think we should be
So-
discussing
yeah,
B
okay.
at all.
Right,
Because you
okay.
really have to get through A first.
Okay.
Otherwise, you're making a market argument.
Okay.
And
No,
that's-
it was just the idea of, this discussion about joint live work, right? And what it would be if it was fully occupied, and I was just going to add what the financial impact would be. And at the same time, if it was empty and putting back joint live work, and it was some of the comments from yesterday about suggesting that you'd be able to get the same residential rents because it would be considered a market residential when in fact it isn't.
No,
due to the
no, but so,
just
I was
wanted to-
working on the assumption that it was joint live work up until the day that the developer decided to empty it out of the joint live work tenancy, not realizing it was a condo. And so that's a business decision to not continue owning a building with joint live work tenants who are arguably paying market rents by that point, right? So I didn't know that we had what was an emptied building purchased by a new developer where the predecessor in title decided to empty itself out and then creates this vacant building, which now exposes it to all of the 2014, if that's what year we're looking at, 2014 building codes, which requires, as the architect stated, ADA and fire codes and all of that sort of stuff. Yeah.
And which also applies evenly to every other building in Soho.
Yes.
And the city of New York. And so, not unique.
Right. And to this point, these buildings are, and when we say Soho, really, almost every single building in Soho is of this period. So none of them were built, or few of them were built pursuant to the 1938 building code. And had they stayed in that sort of state of kind of code neglect by the property owners, there's lots of them, they would eventually have to be brought up to code if they ever changed use, right? And every once in a while, our codes force the owners to insert fire safety and so things like that, like it did in 1938, which had enormous effect on property owners and what they could do with their buildings. And the 68 code did the same, and the 2008 code did the same. So I don't think 2014 did anything more extreme. Elevators, okay. So, but it didn't make you rip out your elevator and put in a new one. And 1938, it made you, in a lot of cases, abandon the upstairs of your building because you couldn't afford to bring the upstairs of the buildings up to code. So it's a, yeah, it's a different situation. For me, now I have another so I never had a problem with this, considering this as one building. So whether or not it was built first and then added to, or built as two buildings and treated as 2 equals 1, that's actually not the reason that I don't think you have a unique condition. I stated all the reasons in the review session yesterday why I didn't think any of those points about uniqueness were actually hit. And now understanding about the vacancy history, there's a self-created hardship finding, which is all the way at the end of the analysis. So I don't think you hit it on the A, and I don't think you hit it all the way at the end of the story. That's the E. So I don't know what everybody else thinks.
I think what I had stated yesterday, and that is as I had understood, and which has been confirmed here, is that this was a building that was going through all the changes that would have been permitted to do as of right. And in the process of trying to address all the AD and the life safety measures and verticality, I think it affected their ability to use the whatever space that they have that permitted use group 6 as of right, not in a viable way. So in order to make the remaining space to work together in tandem, which was going to be also compromised by the additional vertical circulation, which also does not work by itself as a viable use for any of the uses that are permitted, combining extending the use group 6 seem viable. And to me, that uniqueness, that is unique in this building, because we don't come across buildings where you have this load-bearing wall right in the middle in a manner that's occupying such a large amount of the floor area. Typically, you'll see columns, but here you have pretty significant walls and archways. I have not come across, I have not seen any yet. So I was very convinced with the uniqueness finding.
So tenement buildings are always the mom store on the one side and the pop store on the other side of a central corridor.
We have seen those, and that's, I remember the one that was on Spring Street, a vet's office, and it had a staircase in the middle that led upstairs with one unit on one side and one unit on the other side, very defined. But here, you have to have 2 separate set of staircases, you have to have an elevator, you have to also have the, I just think the layout and configuration of this building so far I've come across has been the most unique one, and I was quite satisfied unless I can be convinced otherwise.
Can I just, so there was, when you started, you talked about the obsolescence of the building, which then the commissioners questioned. If it's obsolete, then how is there conforming use on the above floors? If you could provide an answer to that, but also, Vice Chair Tonda, it sounds like you're saying the layout is unique.
I think the fact that you have a load-bearing wall right through the middle makes it a very difficult site to work with. And while you have one portion of the load-bearing wall to have a use group 6 and the other portion you don't, and you're trying to maximize the space individually, doesn't lend itself to a reasonable amount of floor area for any one of the users to be viable. So combining them to makes a reasonable space for a use. That's how I see it, and I'm convinced by that.
Okay. So on the point about having a conforming use now on the upper floors, the reason why we can have it is because we did the required updates to make it no longer obsolete. So they were required to be able to use the space. That's our argument.
So the thing about variances goes like this. I wouldn't do it unless I get the variance because the building isn't viable absent the variance. And we've talked about this before. where I asked the applicant, what was your plan B? And their response, if they don't get this variance, and the response was, we'll take the loss. So as Commissioner Shetta said yesterday, you only take a loss if you can afford to. And so that sounds like it's a viable project because you can afford to take a loss on not making the amount of money that you claim you need to make from that other non-retail space. But, and then, you know, the other kind of reality of this is knowing that just up the street, we have PCE, and we see a lot of gyms that are small ones like a Soul Cycle or private training gyms and things like that, where they want a storefront entrance because that's how they market, and then they exit the storefront and they go down into the cellar and they have more workout studios down in the cellar. This building is ideally suited to actually that use, and that's a use group 9, easily achieved through, eventually, ideally, this will not even require a special permit, but it's something that's easily achieved. And so to say that it's not an available option is disingenuous because there's one right down the street, and there's something like 15 PCEs that I know of in the M15B and M15A. So why wouldn't that be a viable use for not just the side in question, but the other side to combine the use?
I mean, just to address that PCE point, it's not a use that would be permitted as of right, though. So,
but it's a use easily an easily achievable use, right?
Right.
No. So what do you mean? They're addressing the ADA issue.
By putting a PCE on.
No, it's not about the ADA.
It's not about the use. It's about the elevator, the access to all the floors of the building. They'd have to install, like the architect just said, they have to install the elevators and do all those things.
Anyway,
regardless.
So it is what any building, as I said 1,000 times, would have to do to modernize to keep pace with everybody else in the city.
Right.
You can't build a building in 1870 and not lift a finger, and here we are in 2019, and the expectation is that this building is still going to be perfect and beautiful. After 120 years, things fall apart.
but this isn't just a typical building that needs to be renovated.
No,
this is a building with a central load-bearing wall with interlacing brick that divides spaces into 2 narrow spaces. We are not able to use the southern unit as a conforming use.
You're not able to use the southern unit as retail use, but you can use it for conforming use, as I just said.
No, we
Where
can't.
there are other uses that are allowed in the district that can There are other uses that are permitted in the district, either by the very easily obtained PCE. We see many PCEs that come here where they install the PCE, they're rented, they're open, and then they come to us to legalize, by the way.
Does the board want to request a lesser variance with a PCE? I don't know where
No,
we're
because
going.
I don't see an A finding, so I don't see why we even have to take this any further
Yes,
yet again.
I don't see one either.
I actually don't, I'm not quite following the argument of pushing one particular use, and that seems like the only use that is
I'm not pushing a particular
viable
use, it's just an example of a viable use.
I think but it so far seems like the only viable use for a portion of the building, that is the smallest portion of the building.
No, it's the largest portion of the building.
southern.
It's the long portion.
The southern is the longest one?
Yes.
It's longer, but it's still narrow.
But I still think it's just, there's only so far we have been able to identify one viable use, and I think that's almost
that's one viable use. There are many conforming uses. The chair is just suggesting what she feels is the most lucrative of the possible conforming uses. They could put anything in there that's a conforming use. Now, whether or not they can get a tenant, as far as I'm concerned, is not an issue of a unique hardship that's worthy of a variance. That is a market argument. Conforming uses do not pay as well as the non-conforming retail, plain and simple. However, the chair has identified one use that might possibly pay as much as the non-conforming retail, and that's why she suggested it. Other than that, I mean, I think it's actually nice of her to suggest it, because the board doesn't have to make any suggestions. The board just has to say, we are not convinced of the A finding, goodbye.
I would just respectfully disagree that it doesn't matter if we can't get a tenant in the space. I think that's the basis of an obsolete argument.
it's not.
If we're not
It's-
able to have a tenant and there's no tenant available to fit in the space, it's an obsolete use.
Well, so I actually,
No,
I
that's
also
a
want to
different
point out
argument.
that there is available a very easily obtained special permit from city planning to allow use group 6 in this location, and had the applicant applied for it when they first submitted here, they would have received it already. It simply requires that you make an advertising effort for, I don't remember which zoning district this one is for this, or whether it meets the requirements, either 6 months or a year, deciding, depending on the size of the zoning lot. So it's not that you're precluded from pursuing alternate routes. The question before us is, did you make the A finding? Is the building unique? Is the situation unique? And does the uniqueness cause a hardship? I think we've done this long enough. So unless you want to just add something,
Is your argument that obsolescence is in and of itself a uniqueness?
I believe that there is case law to support that argument, but that is not the sole argument we are making
You're also
here.
saying that you have a unique building in and of itself as well?
That's correct.
So those are two separate arguments?
That's correct.
And do you have any information as to how this building became vacated? Was it vacated solely for the sale? Do you have any?
I could follow up and I could
No, we don't need to
bring that
follow up. No,
information.
it doesn't really matter. The condo decided to dissolve and sell. It's common. It's done all the time these days, right? Because there's some serious cash to be made. So I don't think we actually need to go into the history of how it became vacant. That it was vacant just adds to another one of the findings, but I don't think we even need to go to self-created if we don't have A. And I think I would just like to ask if there are any speakers on this.
Well, if the board isn't recognizing that first part of our uniqueness argument, I would just ask that we be able to show the other aspects of the uniqueness, including the central load-bearing wall and the split uses on the ground floor. I would ask that we
already
be
looked at this many times. This is the third hearing where we've gone through the split, we've gone through the uniqueness study. We appreciate the update in the uniqueness study, but that for me just underscored the opportunities to rent this to a conforming use. And we all read the materials, so we don't, and that's why we were able to comment on them. I think that the information about the bearing wall was very helpful, but it didn't persuade me that you can't use a space that's subdivided, because we see them all the time voluntarily subdivided. And
But
so
for retail uses, not for conforming uses.
that wasn't demonstrated. Well, again, I'm going to go again to the same thing, that there are a lot of conforming uses that can fit in small spaces, and I just happen to name one. And there are many others that also can do that. And we're talking about a conforming use, and your choice to hold one use as non-conforming and the other as conforming is a business decision. Because you could also say, just for argument's sake, there is a conforming use out there that would take the entire floor and the cellar, and you're opting to say, no, we only want to rent you half. That's a business decision. That's not a unique physical condition.
But that would put us in a worse position than we're in now. If we were to get rid of the retail space and open it up to a conforming use, hypothetically, if we could find one that wanted to take a divided space that has very limited 10-foot openings, hypothetically, if we wanted to do that, and we could certainly analyze that as well, whether there would be a conforming use that would fit in the space with the divided arches, we would argue that there are very limited, if any, that would fit in that space and would want that.
So Commissioner Otley Brown already spoke to this point. If your entire ground floor were only allowed to be used for a conforming use, you would be worse off. So in this case, you're in a better position than others with an entire floor of a non-conforming use. Half of your floor is allowed to be non-conforming, so that puts you in a better position than your neighbors who have an entire floor that doesn't permit that use.
Our neighbors would have an entire open floor that was non-conforming.
Not
We have
necessarily.
half
Okay.
of a building
Okay, I
that's
think we've
retail.
gone around, please, we've gone around, we've done this. Okay. I
Just
would
on
like to,
the-
actually, I would like to close the hearing and have the commissioners vote, and they can explain their vote?
Chair, we did bring a broker to talk about the market, and we
We've
haven't had him
already-
at any other hearing, and we'd appreciate it if you let him talk about
I don't
what
think that a
uses.
broker is necessary in this case, because then it would simply be, without an A finding, a market argument, which
Well,
is
you're talking
very
about what
easy
what
to
can
do.
fit in there and what can't fit in there.
No,
if you could let the commissioner
that's
finish.
all a market economical argument that has nothing to do with the variance process when it is isolated like that. That's why we're not going to B, because without A, a unique hardship, then there's no need to talk about the market and the interplay of the market, because otherwise what you are is what anybody else is that somebody who would prefer to have retail because you could get 3 times the income per month in the retail space, which could cover your modernization, your expansion upstairs, and anything else you need to do.
If we could just have the broker speak on only the A finding aspect, only whether a conforming use would work.
That's not an A finding.
No, that's not an A finding. That's a
Sorry.
B finding. That's born of the A finding. If you could prove that you have a unique situation that poses an economic hardship to you, then you could have the broker talk about the economics.
Ian Rasmussen from Urban Cartographics, who prepared the uniqueness studies. I would just respectfully disagree. We're trying to establish whether or not we have an economic hardship in having to put a conforming use in the 25-foot space.
No, you have to be unique before you talk about an economic hardship, because what if your economic hardship is one that's borne by everybody else on the block or in the neighborhood? That's the whole point of the variance situation, is that what you have is unique and puts you behind everybody else in the neighborhood. Not, we have something unique, well, we have a hardship, but the other 20 people on this block also have a similar hardship, and so then I should give a variance to every single person on the block.
I think we have demonstrated that we are the only one with the 25-foot wide space that can't be enlarged absent a major structural alteration, and that therefore we're the only one stuck putting the conforming use in
Okay,
the
so
space.
you've made your position clear, you've submitted your materials, and some of the board members were not persuaded. So what I would like to do is not vote on it today, but to close. If you want to make additional submissions, you may make additional submissions, but we're going to close this. And I already asked if there are any speakers.
Would
Okay.
it be possible to keep it open?
Can we keep it open?
And then we submit?
So we're going to close.
Close to public testimony, it would be open for future submissions from you.
You can submit, but
I think the concern is if it's closed and the repercussions of withdrawal would have.
Is that the question? Is that the issue?
What's
I'd
your-
rather the commissioner not speak.
Hypothetically, that was the issue.
Hypothetically, that's the issue. Okay, so.
Could you keep it open?
We can keep it open if that's,
What?
if the issue is. because.
No, and it doesn't make any sense.
So the
We have
issue is
vote
whether or
today.
not they can withdraw once it's closed. It can't be
Without
withdrawn
prejudice.
without prejudice unless it's for cause. So they want the opportunity to ask for withdrawal without prejudice before the hearing is closed, which I think is legitimate.
I think that all things considered, I think that's fair.
Do you have a concern, Commissioner?
I agree with Commissioner Shibata.
No, if
I
that's what the
think
board
that's
wants
more
to do.
like a procedural issue.
It's just a
But-
procedural issue in
But
terms of
but
our
the
rules.
point is, I don't want to have more of this litigated. So then in that case, I don't want any more submissions. If we're going to leave it open to allow an opportunity for potential withdrawal without prejudice, then there's no reason for additional submissions. We've read a lot of submissions, all right? So we'll just close it.
No, not
I mean,
close.
sorry, not close it.
Continue hearing.
We'll just continue it, no additional submissions, and
I think either way, if they're submitting additional submissions,
I
they're
don't-
not going to withdraw it.
No, right, exactly, but I don't want under any circumstances additional submissions. There's no other information that we need. We've already seen, right?
So could we set a continued hearing and have a close and vote on that day? It will just be a close and vote.
Let's leave it.
Yeah.
We already
So
voted.
there's no other submissions. So yes,
Okay.
we'll schedule for continued hearing, at which point it'll be closed and voted.
Yes, okay.
Thank you.
Thank you.
When would you like that next hearing to be?
Next month?
Next month might be challenging. Okay, so the earliest, I think.
Earliest available.
I think the earliest we have available, we're down one. Commissioner Shida is not here on May 7th. Is that?
Yeah, we probably need a full.
Okay. Then, should we just go on either the target or the Frick? No? Okay. Earliest is June 11th.
Okay.
So any submission would be of a request to withdraw would be by May 22nd. May 22nd.
Thank you.
Thank you.
Thank you.
Item number 23, 2017-272BZ, 10-1946 Road, Queens.
You're right.
Good afternoon.
Excuse me, sir.
Oh,
You
sorry.
also have to come up.
Yes.
Item number 23, 2017-272BZ, 10-1946 Road, Queens. Oh, I'm sorry, this is not the correct form, please. This is the form. Please raise your right hand when you're ready. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Thank you.
Afternoon, Board, Chair people.
Hello.
Council.
Your name for the record?
Harry Callion.
Thank you.
I'm the attorney for the applicant. In our last, in our first hearing, we had been asked to submit some things. I'll just review those again.
Just a second.
Yes.
Did you listen to the review session video?
Yesterday.
Yesterday?
No, I did not. No.
Okay, so let's cut to the chase here.
Okay, that's fine. Yeah. I
You
apologize.
submitted something on March 5th, but didn't explain what it was you were submitting, and what was attached to that submission, unless it was an error, was a January 7th cover letter and drawings that had the most recent date of 2017, and no explanation for what was being submitted, like what was new on those drawings. So actually, though we got them, we didn't know what we were looking at that was different.
So I apologize, that must have been an error. The last the comments we got before the last hearing were to add, there were ADA compliance notes, there's an ADA compliance note, there was a signage note, and then there was a revision to the statement of facts and findings that we were asked to incorporate by the FDNY. They had submitted a letter waiving the fire suppression or confirming that the fire suppression was not required, and also confirming that the sprinkler system would be inspected by them. So that's what was submitted.
But that didn't fully answer our questions. We had a question, something about the total floor area.
Yes.
And then the other question was, you are expanding, well, the use is located on an adjacent property. And we asked you to explain what that is, because what's before us is a PCE located on property A, and it seems like some of it, the shower rooms, are in property B.
So the clarification on that is the PCE itself, this building is, you had asked about the square footage of this building, and this building is 5,063 square feet. There's a 50.63 square foot frontage and then 100-foot width. That accessory is just an annex. That's not part of this PCE that's being...
Well, what is it part of then?
There's a fire door that separates that. It's part of a different building. It had to be included on these plans. My understanding, I know you guys hate this, but I'm not an architect. My understanding is that portion had to be included for approval by DOB but not for the purposes of the PCE. So
this isn't going to work. You have a PCE function, i.e. the showers. It's not like it's a closet you could not use, right? It's the showers for the PCE located in someone else's building that is not part of this application. So it's an illegal use.
Well, actual restrooms that are used are actually at the front of the PCE. This is just an accessory use that's not part of this PCE. Now,
Sorry,
we could...
What is the use accessory to?
Well, the use is accessory to this, but it's part of a different building.
Right,
I understand what you're...
that's the issue.
I understand
right?
what you're saying,
Yeah.
so...
But even, I'm sorry.
Yes.
Just to clarify, so just the fact that it's an accessory to this use, it's not permitted even in that building?
So the architect was, we need to clarify for the architect how to not include these in the drawing.
No.
What I mean is not
Just take
include
it
these
off
in
the drawing, it
take it off
can't
the
be
PCE
used.
That's what I mean.
Cannot be used.
Yes.
So that bump out thing cannot be located in the adjacent building because at the moment, it's an illegal use in the adjacent building. Now, if you want to involve the adjacent building owner somehow or other in this application, which is a little confusing, but two buildings under one PCE, you're not allowed to do.
It'd have to be, so if the adjoining building is a separate zoning lot, it would require its own application.
It may be the same zoning lot.
It's one contiguous building, but it's part of, you know what? I don't want to speculate.
Yeah.
I don't want to say what I understand.
So this is the same
Only what I factually
conversation we had last time, which is one reason for my frustration that you didn't find out and answer this question. So your submission, in addition to being very confusing because it had a cover letter that said January 7th, you didn't explain what was in there, and then you didn't do your homework about that use, where, is it one building? Is it two buildings adjacent on two separate tax lots? Is it, right? And if you're going to continue to have the showers there, I don't really know how to solve this. It's maybe a conversation with staff to have them figure out how to do it. And then you need to make the changes to your application, and maybe even the adjoining tax lot owner, if it's a separate tax lot, has to apply with you, like two parallel applications. And it's a very odd thing, but nonetheless, and hoping that they're both on one zoning lot because a building cannot span two zoning lots.
Well, could we request a June hearing to find out this exact information?
Yes.
To work with staff to find out how my guess is this cannot be included as part of the BCE, which is, to work with the.
Change in this application?
Yes.
Yeah. So, and if it's done by the next hearing, so we can move forward, that would.
We're going to need some time on this.
Sure.
If we could
Not a problem.
have until the June 11th hearing.
I could give you more time.
You need a little more time just in case?
If you need it.
Sure, yes,
How about we do June 25th?
that's great.
So that's a June 5th submission.
And we can also find out why the date was wrong on the.
Oh, yeah.
That's of
Go
less
ahead.
consequence, honestly.
Yeah, sir,
I think
you
there was
may
just-
want to check, sometimes what the architects
Yes.
do is when they submit their plans, you're looking at our clock date. But where their information is, they may not make the changes here.
That's right, yep, okay.
So that's what needs to be
Understood.
focused on.
Okay.
And you may want to watch yesterday's
Sure.
John Daly,
Yes.
Fire Department. I'm familiar with this property. At one point, used to be 3 buildings as one.
Oh.
Yeah. Then, over the years, it was sold off. So now, instead of 1 building, now we have 3. The reason I had to go there was just to survey the sprinkler system and to find out where all the water service was going. So I have 1 sprinkler system that's covering 3 different buildings. So I just wanted to kind of clarify that.
So, can you just say, so it was one building that got divided into 3 buildings?
Correct.
Okay.
Don't know how that.
That's so confusing. Okay.
It is. So I mean, tracing all the sprinkler piping wasn't easy, but
Oh my
got
God,
it
so
done.
the sprinkler is running from building A to building B?
And building C.
C.
And C.
And C, yep.
Okay.
Okay. All right, so.
Oh, and there's speakers.
Are there any speakers on this? Thank you. So you need to work with the architect, and I would recommend you bring the architect here for the next hearing so
Okay.
that you don't say I'm not an architect, because that never works out well.
Yes.
Okay? So, So you need to work with the architect to uncover sort of the mystery of this building, and if the buildings, and if the two buildings are owned separately, and the PCE operator, right, is the applicant here, right? If they want to continue to have that extension in there, then they're going to have to work out something with the owner of Building 2, right? Because Building 2 owner has to allow for an application in their building to allow a very strange portion of a PCE in their building.
This is not speculation, that building where that annex is owned by the same, it's the same property.
Well, that'll make it a lot easier, right?
Yeah, so, I suggest you could reach out to me.
Okay.
Yes.
Because it's a matter of procedure. It's not that it can't be done, it's just, what is it? We first have to figure out what it is, and then we can provide some guidance.
Right. Because it doesn't mean you have to take out this thing. And by the way, the last thing we want is for you to pretend to take out the thing.
Oh, yes, of course.
Okay?
Please don't.
Okay, good.
Okay,
And
so we have
submission date is
June 5th.
June 5th, okay.
For June 25th.
Thank you.
Thank you so much.
Thank you.
Item number 24, 2017-288BZ, 1710 Whitestone Expressway, Queens. This is adjourned.
This is the one we picked the date.
Yes, we did, because Ms. Arante was here earlier, but rather than taking this out of order, we just communicated what our adjournment date would be.
May 7th.
Yes, that was May 7th hearing and April 17th submission.
Item number 25, 2017-298BZ, 14 White Street, Manhattan. Everyone who's going to speak, please come on, be sworn in. So whenever you're ready, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Thank you. And then everyone else can just sign in, please.
Good afternoon, Chair Promoter Commissioners. We really don't anticipate having all those speakers speak.
Good.
But just in case, we thought we should be sworn in. Sort of like one of these discovery motions. Okay. My name is Jay Siegel. I'm attorney with Greenberg Traurig, along with my colleague Ali Carreri, and we represent the applicant. At the review session yesterday, we heard Commissioner Shetta's conclusion that based upon the Musa Relatives report, that he's concluded that our site our soil conditions in our site is such that piles would be required even if we were not adjacent to the subway. We understand that matters of these type, as Chair explained to us last time, the board will rely upon Commissioner Shetta's expertise, and the rest of my comments assume that that's the case, and that that if we were not near a subway, our soil conditions would require piles. But Commissioner Shetta also concluded that based upon that, he didn't believe we had any hardship that resulted from unique conditions. That we don't agree with, and we want to explain why we believe that if our site were regularly shaped and not near a subway, and had piles, there still would be significant unique conditions that cause hardship.
I'm sorry to interrupt you. I didn't say you don't have unique conditions because of the shape. I said you don't have hardship because of the adjacent to the
subway.
That's what I said.
Well, we think we have some, based upon it, and I'll...
And I just want to add to what the parameters are.
Yes.
Because Commissioner Shetta's analysis about whether or not piles would have been required, no matter what, is something new that he deduced from the materials that were submitted, as opposed to something that's been discussed at prior hearing. you're not precluded from talking about that if you have your engineer here, right? So I wanted to make that clear, that he's deducing it from materials submitted, but if your engineers have other materials, we'll consider
I
them.
appreciate that.
Okay.
Thank you. But my remarks today will be, even assuming that that's correct, and that piles would be required because of the soil conditions, we think we still have unique site conditions as compared with a regularly shaped parcel not near the subway. We think there's at least 4 of them, and we'd like an opportunity. I'll summarize them now, and I'd like an opportunity to submit it in writing. One of them you've seen before, and that is the vibration isolation system. And I just want to summarize it. You've heard it before, and we have somebody from Cerami here to speak if the board thinks it's useful.
On that issue, is the board?
Yes, I am open to this.
You're open, okay.
Could I just?
Especially the structural engineers.
On the vibration.
On the vibration.
Okay.
So could I just say something about what you said? That when you talked about how you do suffer some kind of a hardship from being next to the subway, but that it may not be unique.
No, what I said is that
Was that the end of your?
both the shape, the fact that we're triangular and next to the subway, and those are what I think are unique conditions that cause hardship. We used to say one of the big unique conditions were we wouldn't need piles if we weren't near the subway. And I'm saying even assuming that's not so, and we need piles away from the subway, even if we're regularly shaped, I still think there are unique conditions that I was about to list. 4 unique conditions.
First, outline the uniqueness of the site, and then let's go over them one by one. And if there is one of them is related to engineering, such as vibration monitoring, I would be more than happy to discuss that.
Thank you, appreciate that. The vibration one, I'm just quickly summarizing because you've heard it before, is that 100 Franklin, in its application to the board, included vibration monitoring, and they installed the vibration monitoring system in their building. Consequently, our client was concerned that they would need vibration monitoring, and they hired Cerami, one of the city's recognized experts, to do testing. Cerami did testing, and Cerami's here today, if board would find useful to hear from him directly. An engineer at Cerami, not Mr. Cerami. I don't know if there is such a person. And they advised the client that they get a vibration isolation system. They gave them a couple of potential vendors. The clients, none of which Cerami has an interest in. This Cerami just rendered its scientific opinion. They interviewed them, and they decided to choose the same vendor that had been chosen by 100 Franklin. And I know there was a question raised at the review session as to whether the design of an earthquake prevention system that is supposed to prevent buildings from suffering structural damage and falling down for earthquakes up to a magnitude of 5.7 would also serve to mute the subway's vibration. And the Cerami person is here.
That wasn't my point. You misunderstood. Let me explain. I forgive you. I know you're not an engineer. Probably if they listened to what I said yesterday, they got it. I'm talking about the engineer. What I said yesterday is that, yes, the train is passing by. It's causing some vibrations. These vibrations are traveling into your property. I agree. But the effect, the impact, the negative impacts of these vibrations on your buildings are not comparable to the effect of a design earthquake from the New York City building. That's what I said. If one of your engineers believes that this statement is inaccurate, he's more than welcome to explain why.
Well, I don't know if that is, the fact is that the conclusion was that these vibrations would not be the type of situation that people who are paying the $2,000 a square foot plus for condominiums would be satisfied with. And in order to be able to get those prices that we've included in our pro forma, we would need to moot those vibrations. That was the conclusion by Cerami.
Are we talking about noise or vibrations?
Vibration.
Vibrations are dynamic force. When they hit a building, they cause forces and stresses in that building. And same does an earthquake. When we design something, engineers, when they design this bottle, they look at the load that is coming to the bottle. And if there's like 5 loading conditions, we pick what is called the design condition, which hits this bottle at most, like with the maximum stress. My point is the maximum stress coming from an earthquake or coming from the vibrations from the tree? If it's coming from the vibrations from the tree, which I like 99% sure that it's not the case, then you could include in your uniqueness or hardship the difference between the design for an earthquake and the design for the vibrations. If the vibrations coming from the tree are not comparable to an earthquake, then it's done deal.
I think-
design for the earthquake and you don't have.
So I think my question in this context to Commissioner Shaita really is that if you design for an earthquake that prevents, I'm assuming kind of a smallish tremor, that prevents people from really remarking on the tremor, right? So that maybe you're seeing water glasses moving, but that's about it, but it's 5.7 tremor, right? That the vibration from the subway, let's just say it's 2, the equivalent of a 2. You shouldn't see your glass move, because the water in your glass move in a 2, because the building's been designed to resist the movement in a 5.7, right?
I think at this point, it might make sense for me to ask the ceramic expert to come up to
Okay.
respond.
But another question, just to this point, because I actually thought the subject of vibration was put to bed. I thought that the submission by Muser Rutledge indicated that the structure was far enough away from the tunnel so that there wouldn't be transfer of the vibration to the structure of the building or the other way around.
No, they said, based on the lateral demand that the structure engineer called for, the building is not gonna hit the tunnel. So the tunnel is secured now, based on the submission from Muser.
Right.
The opposite is not addressed by Muser Rutledge at all. It is
Whether or
addressed
not
by
the-
Ceramic. And they said they believe that the vibrations coming from the train are not gonna impact the building. And what the last hearing, I questioned the need for the vibration monitoring, but for the vibration isolation, because the building is founded on piles. And what they said in this submission, actually the piles increase the surface area for the contact between the building and the surrounding soil mass. And this increase would impose additional vibration. That's what they said in their submission. My response to that is the top 15 feet of the pile are cased. The TA requires that throughout the top 15 feet, until 5 feet below the influence line of the train, which is 5 feet at the bottom of the tunnel, it shouldn't be any transfer for shear forces or stresses from the soil mass to the pile. So the pile is receiving nothing laterally within this zone. Beyond that, the vibrations were not measured. Nobody can claim that it's going to be significant vibrations at 40 feet below grade, for example. So this is out of the scope of all the submissions made so far. So and the other thing is, they are talking about the vibrations hitting 2 elements. One of them is the foundation wall, the sides of the building. The other one is that concrete mat, the bottom of the concrete mat. And what I said yesterday is because this site contains silty clay material that's almost very soft. Once they put the structural slab in, the slab sheds its load to the piles, not to the subgrade. And probably in 6 months, if they go there and they make hole, they will see a separation between the soil material and the concrete slab. And what I said literally yesterday, I said that soil is not gonna jump up because of the vibrations to hit the slab from the bottom. So it's not gonna happen.
Okay, so that's what we need to hear on whether, how in light of what Commissioner Shida just said, there could actually be vibrations actually from the tunnel in this situation?
Yes, I'm Matt Scheffler from Ceramic. So the vibration from the train tunnel that vibration is energy, and it radiates from every surface, and it goes to the sidewalk and down. That vibration enters into a structure with very little impedance. There's very little loss from the subway to the actual structure.
But if the structure's far away, doesn't the structure have to be touching?
It does not.
So,
because it's making contact through the soil. So the soil is the means of the transmission.
but isn't there, like, at some point, let's just say for argument's sake, the soil is 50 feet away, the tunnel's 50 feet away from the structure. You wouldn't feel the vibration 50 feet away as the same as you would feel it if it was right up against it, right?
That's correct. So there is a loss.
There's a loss.
There is a loss.
So
yes.
what's the rate of loss? And wouldn't that depend also on the material that it's traveling through?
It does. So most soils, they're fairly similar when it comes to how much loss you have. And there isn't...
That's incorrect.
Well, there isn't a agreed upon method to predict the loss. It really has to be measured. And that's why we took our measurements in the location of where the structure will be.
Where did you take those measurements? Above grade, below grade?
So
how far below grade?
the industry standard to measure in this instance is to drive a rebar, a piece of metal, down into the earth, and then an accelerometer is placed on top of that, and that measures the vibration or the acceleration in the X direction.
Beautiful. How much acceleration?
So,
by the way, they did the measurement at the surface plates.
Well,
so almost at the sidewalk level.
But because the rebar is driven in, we're measuring
that
the
makes,
rebar.
That makes the rebar part of the medium. That
Of the
is
soil.
connected to. It's like a
Right.
rigid body moving together.
Yes.
That's why you put this bar in the ground, let's say, probably a foot or two.
Yes.
But, yes, how much acceleration did you make?
We measured, let me just check the notes here. I believe it was 85 VDB.
Can you translate
86
this
VDB.
Can you translate this into meter per second?
Not off the top of my head. It's micro inches per second. It's
micro inches.
Yeah.
So what you measured in, you want to Google it?
It's not going to make any difference to me, but...
I just want
So what does that...
I want to prove it to him that what he's measuring is not comparable with what structural engineers / geotechnical engineers designed for.
But I also want to understand, you inserted a rebar. How long was the rebar? How deep was it inserted, et cetera, et cetera?
I would say the rebar was about 3 feet in.
3 feet?
3 feet.
But the piles go down 20 feet?
Correct, and there's...
20 feet after the cellar?
Yes, but I'm okay with, so far with what he did.
Okay.
Yes, you put it 3 feet in. That makes it like one piece integrated with the soil net.
Correct.
You measured how much?
It is 86 VDB, which is a velocity.
VDB?
Correct.
VDB stands for what?
It's velocity in decibels.
So
And
this is velocity, it's not acceleration.
it's converted into velocity, yes. That's
What is the acceleration?
the I don't know. It goes through there's a transfer function between acceleration to velocity, and it goes by frequency.
Okay, do you know how much is the gravitational acceleration? The G?
Is it?
In micro Gs, I don't have that number in
It's
front of me.
9.8 meter per second.
Oh, right, yes.
82 meter per second, I keep saying second, I'm sorry.
Yeah.
It's 9.8 meter per second.
Correct.
32 foot
Yes.
per second.
Yes.
Take the number that you got, acceleration, and switch this into meter per second. And the geotechnical engineer and the structural engineer are aware that we the geotechnical and structural engineers, design buildings for probably 10 to 15, sometimes 20.
Right.
In California, probably 30% of the G. It's not micro inch.
Yes.
15% of the G.
Yes, that's for...
Means that 0.15 times 10.
Yes.
1.5 meter per second squared. This is, what you got is nothing compared to what we designed for. That's why I was like, no, you don't need it. If you want to put it, put it.
So
it's up to you, it's your decision, but it's not needed from the engineering perspective.
So from FTA, they recommend an acceleration level of 72 VDB in residential units for frequent transit events.
What is FTA? Sorry.
The Federal Transit Authority. So they have a manual of how to predict noise and vibration, human impact from trains.
For noise?
Yeah.
For noise and vibration. So the vibration, when it enters into a structure, it re-radiates as sound.
Don't you believe that traffic on one street
Yes. Yep.
is imposing vibrations
So yes.
that are compatible to?
No. Comparable to trains? Absolutely not. They do. Roadways will generate vibration, yes, but it's not to the same degree
Are you
as.
certain that all the vibration that it generated was coming from the train?
Yeah, so when you look at the data of when you're measuring it, it's a live readout, and you see a clear spike that goes with the train pass as the train goes by in the
There was
site.
someone there who was witnessing this,
Mhm.
clocking the time.
Yes, and subjectively, you're on the ground and you can feel it.
So the contact area between the building element and the surrounding media that convey these vibrations to the building are minimal. It's like nothing. You just have the perimeter wall, and that's it. For the pile is extremely rigid in the vertical edge. For the horizontal edge, you don't have any load transfer from that material to the pile, because again, it's cased. It's a requirement from the TA that this pile is coated sometimes with epoxy to make it like glass, so there is no actually any interfacial shear transfer from the soil to the pipe. So I don't see like any reason for that. And again, that for the bottom of the mat slab,
Right. So
when we put this in, the load is not going to the underlying soil; it's going to the pipe.
So the vibration enters into the structure just in that manner. It does.
Through what?
Through the soil. It's radiating from the tunnel, it goes through the soil, and it enters into the structure.
No, into the pile.
Contact with the
The piles are making contact with the mat slab.
Around it with a capping that has this glazing on the interior that prevents the transfer because the cap is, there's
It doesn't
space.
prevent the vibration transfer. For something to reduce the vibration, it has to be like viscous or like smushy. Like this is all rigid materials.
The shear transfer, again, look, this is the pipe, and this is the mat slab. Underneath here, you have a cavity. So there is no contact between the soil here and this guy. Nothing. It's gonna settle, I promise you, believe me on that. And for the pipe, it's like this. It's a steel pipe that is coated with practically glass. When the soil is like, if you put a pile in water and you hit the water with something, you start making waves.
Yes.
The only force that gets transmitted to the pile is because of the drag. It's not because of the shear transfer from that fluid to the pile.
I mean,
in this case, you have a fluid-like material.
It's rigid. There is a loss. The mass, it doesn't really matter that much. It doesn't take into account here. If I hit something here, it's still going to move here. There's a vibration coming in through the wood, hitting here. I can feel it here.
Because it's connected all to each other. There's no space between, like a cap creates a space.
If there was a huge airspace, yes, there would be a,
What's
there would be a
huge?
further
Usually
reduction.
you need an inch for vibration isolation, right?
It's going to all be connected. It'll.
So I have a question without being an engineer, and I'm always trying to follow along, and my general counsel knows physics way better than I do, apparently, so she's following along even better. But for instance, I've been, I'm sure all of us have been, in buildings located right there on 6th Avenue and on 7th Avenue where the subway is traveling. And last I looked, standing inside of an apartment on the 2nd floor, which is what we're concerned about, the 2,000 square foot apartment, I never had to like hold my martini to make sure it's not like rattling off the table.
Right, these
I
aren't
didn't even
seismic
notice,
events.
right? And it's true that occasionally in a store, you notice the noise of the subway because it's coming up from the grates. But it's, again, if they offered a martini in the store, you wouldn't have to hold it. So I'm a little confused. So those tenement buildings that were built all along 6th Avenue, which were built before 6th Avenue was cut, which then got modified in strange ways, they weren't built with any isolation. They didn't even know about earthquakes back then,
I would
right?
imagine you can hear the trains in there.
You mean the people who are on the second floor?
I think
Not here, it's not here.
hearing and vibration are two
We're
things.
talking about vibration. I'm talking about holding my martini.
Right, and we're not going to get to levels that high that something is going to shake from the train, I don't think. So the FTA defines, let me just get the number for you. Well, 72 is the standard and for residential, and that is defined as, just give me 1 second to find it.
72 what?
72 VDB, excuse me.
So, and you measured 86?
86.
So we're
yeah.
only talking about a step down of 10? 14? 14, sorry.
We don't know what that 10 reflects. It could be, that 10, I'm not familiar, at least I'm not familiar with those units of measurement to say that if that's the difference, it could be very well be the difference between miles and inches.
No, but we're talking about a step down as if there's no structure there. There's a structure, there's all of the stuff that's happening in the way. It seems like a natural step down.
So 72 is defined as vibration not feelable, but ground-borne noise may be audible.
86, you say.
86 is what
Let's
we
go back
measured
to
in the ground.
You know something called free field movement, right?
Yes.
What you measured is the free field velocities and accelerations. Do you agree?
Yes.
When you put the building in, don't you think that this building has some sort of stiffness?
Yes.
Rigidity?
Yes.
Would that like introduce to the equation some impedance?
Yes.
That's it.
So yes, you do lose vibration energy, but then there's actually an amplification of when it goes into the structure and onto a suspended slab. The slab acts as a drum. And
Again,
so the vibration...
slab is not part of the equation. The slab has a gap between the, you know what? Instead of, this is a free consultation to you. Instead of putting this vibration isolation thing, put 1 inch of styrofoam. You don't have contact between the soil and the slab. Done.
Well, that's the building isolation element that we're
I'm not saying this
proposing.
is a vibration isolation. I'm saying it's a solution to eliminate the contact between the subgrade.
No, but so that's,
and the
they're
slab.
arguing that's what they need and it's costing $1 million or whatever it is to put in vibration isolation.
No, put the styrofoam from Lowe's.
So
You don't have to put this-
the building isolation, I mean, it's essentially like Mr. Clean pads. It's a Solmer product. It's
Mr. Clean.
I know what you want to put, but trust me, I just built a building before joining this board. It's 18 inches from double cut on intersection like this. 18 inch from this side, 10 feet from that side. And the tunnel size over there is huge, like 5 feet.
so I mean,
And we didn't put that.
the amount of vibration that is generated, it varies on track condition and train design. It varies on a lot of different, you have to take a lot of different items into account. And then for a commercial building, the requirements are much, they're not as stringent.
So what is it for commercial?
It's 5 more.
It's 5 more, so 76?
Yeah, that's what we said. Okay, so I think we've talked about this enough. I appreciate that you came and that the two of you had this conversation. So, yeah, so I think we can move on to the next
Yeah,
thing.
I'm
Okay.
done with it.
Okay, good, thank you.
If we can start with the cost, because honestly.
Wait, we need the A finding, not the cost. Stay in the A.
Okay, but
We don't have an A, we don't have a B.
answers regardless.
Sure.
I need answers to the numbers that went up.
Sure.
Okay, that's later, let's stay with the A, okay? Because what we're trying to do here is to see whether there's still a unique physical condition that would go to any waiver other than the setbacks, right? Because I don't disagree that the shape of the site presents some kind of hardship where the setback waivers might be appropriate, but based on what we were talking about, the no need for piles, I mean, the piles required no matter what, it seems to be eliminating most of your cost hardship, which is going towards your 1 FAR, which is what we're really talking
Well, the
about here.
vibration isolation cost, should you board end up finding it persuasive. And Cerami is, I think, the leading sound consultant in the city who've concluded, based on the information you heard, that we need the system, is $307,000. Next is still the cost of piles, meaning this, that at our site, for those piles, at least 16 of them that are close to the subway, we have to go down 35 feet to get below the zone of influence of the subway.
No.
No?
You don't have to. No matter what, the top portion of your subsurface, which is underneath the film, you have a very soft material that's not gonna help you out. So even if you have very dense sand and the TA is,
Well, can I just finish,
if you have
Commissioner?
very dense sand and the TA is asking you to put the casing to eliminate the gain in the strength of the pile, I would agree with you. But because you have a almost zero strength material within that portion,
No, we're going, first let me make, what I understand the case, then we can have our experts come in. I just wanted to summarize it first.
Okay.
I certainly can't, debate you on engineering issues, but my understanding was that we have to go down 35 feet before we can allow the pile to bond with the soil, but if the same soil were present not near the subway, we'd only have to go down 10 feet before we allowed the bonding. So the net result is we have to go an extra 25 feet because of our proximity to the subway. And that results in extra linear feet of pile insertion into the ground, which has a cost to it. And we wanted to be able to calculate, it's not as much as not having piles, but it's a significant cost. And we'd like to be able to show you that this is a rectangular site, which may have a little savings itself, but we're not sure yet. Between last night and today, we weren't able to do the full calculation. But the fact that on a site not near the subway, we could have the pile start bonding only 10 feet below the ground, as opposed to those piles on our site that can't bond till they're 35 feet below the ground, because you have to get below the subway line of influence. There is an extra cost of having piles go 25 feet further down in our site.
How many piles do you happen to know?
It's about, I'm told about 16 of them would be affected by this.
And do you happen to know what the cost differential is?
Well, we may also be saving some piles by having fewer of them. I don't know the answer yet.
Okay.
We'll be able to submit something showing that.
Okay. Well,
Well, it's at least 16 times 25. That's a start, and I don't know what.
16 times 25 feet.
Yeah.
Okay.
Now we're talking engineering. It's not 25, it's the height of the tunnel plus 5 feet. I'm looking at.
Okay, well, but he's just summarizing. Just a second. He's just summarizing, and the engineer will talk to that specifically, right? So, do you have more?
I think at this point, yes, there is more, but the engineer will submit a writing.
Well, maybe we're not going to submit it.
This back and forth, I'm not.
No. So the thing is, we've had a lot of hearings on this, right?
No.
And remember at the last hearing, you said something like, give me one more chance, right? So this was kind of it, right? So we need you to address Commissioner Sheta's issues. And then, as I said, our expert decides whether he agrees with your expert, and then that's how we move, right? But at the last hearing, we were skeptical of this A finding with respect to the structure, and we had directed you to provide us with the lesser variance, which was without the floor area waiver, right? And we didn't get that. What we got instead was a submission just very recently that said we didn't even try because we know if we bring it down by 0.25 FAR, it's not a viable project. Well, but that's not actually what we're finding, because we're finding that the as-of-right and the proposed are in the same, the as-of-right absent the tunnel and the proposed with the tunnel are kind of in the same domain, or let's say the as-of-right with the tunnel are in the same domain.
Well, we are responding to the new information, which is we have to compare piles to piles. You know, that the, so we think there are, our estimate is we're going to have about $1 million of costs. Our as-of-right scenario, the 5.0 scenario, produced a return of about 1.1%. And I know there were some questions about costs, but there weren't that many questions about cost to increase that percentage. I appreciate that unless we have unique hardship, that's not a relevant consideration of the board, but I think we have enough unique hardship so to justify a floor area variance, and I apologize for not understanding. If I understood that the board expected us to submit something seeking only the setback variance, I know that's how it started, but I thought we moved it off that line, and instead you were looking for us to provide engineering responses as to why we were entitled to the whole 6. That's what I thought, and if I wouldn't deliberately do something, not do something I thought that would. Evidently, we weren't.
Our recollection, or even I think Commissioner Sheta listened to the video from last time, so. Okay, it doesn't matter, but we really have had a lot of hearings on this.
I agree with that.
Lots of opportunity to make your case. New information that was provided for this last hearing, which Commissioner Sheta analyzed, and that's all we should be focusing on.
And I want to just respond on the fly to this new point that 16 piles would have less bond if the T is not there. You know what? I would agree with you. You got 16 piles times 20 feet extra. And you know what? I'm going to use the linear footage rate that you submitted. $200, not even $190. $200 per foot. 200 times 16 times 20. This is 64,000. You know what? Last hearing, we concluded that the reduction in the cost for the excavation support because of the TA is beyond 400,000. So the TA is causing you loss of 64,000, but it's causing you gain of about 400,000. It's a good deal.
I don't think that was the number, your 400, and we were comparing triangular sites, one close and one non-close. I think when you compare the triangular site close to the subway and their supportive excavation costs to a rectangular site not near the subway, our information is that they're not saving anything with the TA.
I'm not talking my numbers, I'm talking your numbers. The numbers I just mentioned are here in your submission. I didn't alter them.
So sorry, what is the cost on piles?
If you look, Chair, if you look at the last submission, the excavation support, the foundation cost comparison, look at the actual site. The cost is on the order of 140 grand.
Tell us again.
For the SOE.
140.
It was a dispute from my side questioning the unit price for the buttons, for the concrete, for the buttons. And I said 1,500 is too much. And they promised to fix this. I believe a fair price to a plain concrete element is probably 200-300. Let's say 300. If you take the differential out of the concrete buttons, out of the 140 grand for the SOE, the resulting cost for the SOE with the TA in the equation is on the order of $100,000. Okay. If you eliminate the TA and you consider that you don't have the TA in place, pair their submission before October 18, it's on the order of 400. So the difference is 300,000, 400,000.
Okay.
Something big compared to 64.
So let me see if I can just say that again so that I understand. So just to cut to the chase, the actual site with the tunnel has an SOE cost of 140,000.
Yes.
And the SOE without the tunnel has has a cost of 400,000, independent of the buttons and all this stuff.
Yes.
Right? Okay.
Yes.
Okay, just so, the savings because of the tunnel is 300.
So my point is the
208.
savings because of the tunnel, let's say 300,000.
Yeah.
The loss because of the tunnel on the pile side
Is in the
65
60.
grand.
And where did you get the 65 grand from?
16 piles, as they mentioned, times 20 feet, times the unit price per linear foot, which I took from their submission.
Which is?
190, I said 200. So 200 times 20 times 16. This is
$200.
Yeah, $200 per foot times 320 linear foot total for 16 piles. So this is 65 grand. Still.
That's just too much, quick calculations. I knew there were 16 piles that would be directly affected, exactly as I described. There may be further calculations we'd like to submit. This is something we heard yesterday afternoon.
So this is the 5th hearing on this
Fourth.
applicant. Fourth?
One was adjourned.
No, but I actually see.
Yeah, it actually wasn't marked on the calendar, but the last hearing was adjourned.
No, wait.
Well, right now, we're talking about making a submission to respond to the information that we
No, sorry.
heard yesterday.
I'm sorry. Yeah.
To explain the cost differential between our site and a rectangular site not next to the subway that has piles. Now, if you don't think it's appropriate to give us another hearing, I think
So here's what I think really needs to happen. You can hear clear skepticism from our expert, right, in the direction of the expertise that's been expressed so far, right? When he does what you call the quick calculations, he's actually not doing quick calculations. This is a result of reviewing the materials and doing the calculations separately, and now just reading what he's discovered from the materials that were actually submitted by your consultants that told him that it's $200 a foot or 400,000 and so on. It's actually on the materials. But so what I'm saying is his calculations are not quick. They may be fast for you to process,
I
right?
can follow his math all right.
Yeah. So what I'd like to say is I would like to, therefore, because we talked about we don't want to close, or can we close this? What I would like to do is say, we have skepticism about the A. We did before and before and before that. So the direction is you need to remove the one FAR because we don't believe you've made a finding for a floor area variance. If you, in addition, want to submit materials to support some amount of FAR increase, because it certainly can't be one, that's supported directly by these new things that we've talked about. So let's just throwing out an FAR increase that might give you a little penthouse or something like. I don't actually know what it would give you, right? And we're very aware that there's extra floor area to play with because you have this elevator that doesn't count because it's parking. So there's floor area to add to the roof that you are entitled to. I think what I'm trying to do is give you an opportunity to at least get some amount of waiver, because we do see the hardship related to the site configuration, which was the case in Franklin, and we're reminding again that Franklin asked for almost nothing. They asked for height and setback waivers. If Commissioner Sheta buys any of your argument that there's even any additional cost associated, you need to hear him, because we're relying on his analysis. And if it says, just for argument's sake, it's costing you $500,000 more to be adjacent to the tunnel, and Commissioner Sheta buys it, then $500,000 is worth some consideration, but it's certainly not one FAR.
I understand.
Right?
Yeah.
So, I would have to say that at the next hearing, we just close and vote it. And I'm trying to avoid, because we want to give you the opportunity to make a submission, I'm avoiding a closing.
I
But I
appreciate
don't
that.
want to have any more discussion back and forth about this, okay? Because
I believe, based on my view, the FAR waiver need to be entirely removed.
Okay.
I don't think it's going to be any room from the TA or from the subsurface to contribute to the hardship. the opposite is correct. I believe the subsurface conduct adjacency to the TA is helping out with the excavation support.
Well, we will submit, I know you read it very thoroughly, and we will submit, I think you may feel persuaded when you read Cerami's report. I mean, it's logical. Nobody puts in one of these systems if they don't need it. 100 Franklin didn't spend, I don't know, $500,000. I don't know.
Last hearing, I did ask you, structural engineer, how many times did you put such a system next to a TA tunnel? And the only cases he recognized was to protect the TA, not the building.
Oh, this was not a request from the TA. This is the building.
No, yes, that's what I'm saying. The structural engineer said the only cases that he can recall where he did this vibration isolation thing was to protect the TA from the building because the building was put on top of the TA. This is not the case here.
I understand.
And this is, believe me, this is sincere engineering advice, suggestion, you name it. You don't need that.
Okay. Well, I hear you. We will make a submission, and I hear what you said.
Okay. Please don't make a submission explaining why you can't make a submission. That's not going to go over well. That means we just close and vote based on no drawings, right?
No, we of course make a submission.
Okay, okay.
Within whatever time schedule you give us, we'll make a submission.
Okay, good. All right. What I meant to say by that is don't make a submission about the lesser variance that doesn't include the lesser variance, like just happened.
Oh, like the last submission.
Right. Understood. Should have drawn, unless you don't want to, in which case that's the project, right? Okay. Okay. So are there any speakers on this? All right.
Okay, so when would you like to submit?
3 weeks? Which way is that?
I don't think we have room on April calendars to take a submission in 3 weeks. Oh, we have, actually, no, submission in 4 weeks. Actually, no, submission in 3 weeks, sorry. April 17th would be your submission. Oh, but Commissioner Sheet is not here on that date.
Well,
I think we should have him here.
Obviously.
And then this is Target, and then this is Frick.
Could we handle this on one of those days?
If we're not having a conversation, we certainly could.
Yeah.
Yeah, if we don't have an argument regarding the hardship.
Okay,
again,
yeah,
yes,
that's
why
so, just to put this in perspective, in order to accommodate a schedule like this, we would be putting you on a day when we're hearing two of the most controversial cases, one of the most controversial cases in Manhattan at the moment. So, in other words.
This one's in Queens.
The other one's in Queens, so maybe, so that one maybe is not as, maybe the targets.
I thought you already decided 200.
No, we actually have other applications.
No, the current applications.
Currently, most.
Yeah, 200 's arguably
Yeah.
done.
So we could do May 1st submission for May 21st.
Okay, May 1st for May 21?
Yes.
Okay,
Okay.
thank you.
Thank you.
Mr. Siegel, just,
Thank
Mr.
you.
Siegel.
So
Mr. Siegel?
No,
Mr.
it's okay.
Jay.
Just a reminder that any revisions to the project, that all the documents need to be revised, like EASs and so forth.
Yes, good
thanks,
point.
Carl.
Good point.
So we just.
Okay, we're going to take a 10-minute break. The
we're
next
back.
one's
Yeah,
adjourned.
we'll be back on the record in 10 minutes.
Thank you.
The next one is adjourned, this one?
Yeah, we're going to let him, just telling you, next drunken dinner. Telling you.
We are back on the record. Item number 26, 2018-33BZ, 31-41 97th Street, Queens.
Okay. I don't think anyone's here for this, right?
Yes, he's not, the applicant
He's
is
not here. So the applicant heard our comments and realized that the application has to be modified because we talked a lot about other non-compliances that need to be corrected. So he basically asked to adjourn the hearing, which is fine.
So will we mark this as adjourned even though you had a discussion in the review session?
Yeah, we mark because we didn't hold a hearing. So it is
Okay.
adjourned, but everybody will just make notes in their notes that it was reviewed already, so you're not reviewing old stuff. But anyway, you're going to be receiving another submission. So that's responsive, really, so it's almost like having had a hearing. But, so when? Did
How
he?
much time did he say? Did he say?
He didn't give me the time frame.
All right, at our leisure, but it can't be on one of those little
Yeah.
days.
What about June 25th? Submission, June 5th.
Okay. Item number 27, 2018-106BZ, 124 Hastings Street, Brooklyn. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Elise Fullader from Eric Polanic PC on behalf of the applicant. I submitted to as many people as I could think of the revised plans, and on the proposed plans, we added the notes you requested. Removal of more than 50% of existing exterior walls and/or more than 50% of existing floor joists in excess of that shown on the BSA-approved floor plans will void the special permit, and existing joists to be lifted and retained.
Okay, can we get a submission? So it was supposed to be just, not just the note, but the actual proposed plans needed to show what was being retained. So there's a set of demo drawings that make it clear.
Okay,
the demo drawings are not normally submitted to DOB. It's the plans, right? So DOB doesn't have anything to rely on except for the plans. So you have to see what's the retention of the walls.
Okay, because I understood it from the comment yesterday that you wanted the notes, so I said
No.
to submit, and I made sure you put the note on everything.
No, it's not, because you don't know what walls are being retained from that drawing, do you?
It says existing walls to remain, new interior walls constructed.
Let me see.
The legend.
No.
So the comment yesterday was existing walls and joists to be maintained must be on both proposed and demo plans.
So I don't see which walls are to be retained on this drawing, does it?
But then she said, and the note regarding no moving.
So wait a second, let me just see, because this is a cleaner drawing than what you can see on the PDF. So existing wall to remain is on the, it's just not dimensioned. There's a code that doesn't, that's the other problem. So the code for new exterior wall and existing wall to, the legend, sorry, thank you, is different than what you actually see on the drawings. So there's a sort of gridded hatch line on the drawing itself, and there's a, let's say a diagonal hatching and a vertical hatching. So they don't look, and there's a gray.
And you guys
So the
don't-
legend doesn't match the drawing.
That wasn't.
In addition to which, it doesn't measure, which is the important part, the extent of the wall to remain.
But that's why I thought the demo plans were for that, and usually we add those notes to each of the plans.
No, because, okay, so just to be clear, this is what DOB looks at, right? So when, from the BSA approval. So they need to know when they go to the job site, what they're looking for as retention.
And you don't stamp the demo?
I don't know if the demo, we could start doing.
The two. We could,
Because we prepared those to clarify that, you know?
yeah, we could include that in the approved set.
We could.
Good.
Okay, but only in the interest of not putting this off, but I don't want this to become a standard, right? So only in the interest of not putting this off.
Yeah.
that will include the demo set, but I don't want this to be a standard. I want always on
So
the
your-
drawings.
So your new standard is on
It's
each-
not a new standard. Everything has been like this on the other applications. That's why I noticed it on this one.
Okay, because I was just used to putting it on the demo plans, the calculations on the demo plans. And
No,
then-
no, no, that's a calculations. I'm talking about the length of the
Legend
walls,
about the
and the walls don't, the legend doesn't match the drawings. See, the drawings have this kind of hatchy thing.
Oh,
and
so there's kind
a-
of like a grid hatching in the walls that doesn't match any of the legend on the top left, which
Right.
are all diagonal or vertical lines. That's the issue.
That's one issue. And then the other is that you're not dimensioning how much of existing walls to be retained. So if an examiner, if an inspector comes and looks at those drawings as opposed to the demo drawings, they won't have any information on that. Yeah. Okay, so, all right, so please, I just don't want to hold this up anymore. But, so please, going forward, make sure always that that information is on both sets and that your legends match the drawings. Okay? Please?
Yep.
Okay.
I'm just looking at.
Okay, so are there any speakers on this? Okay, so then I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition with our standard note that removal of existing joists and exterior walls in excess of that on the approved demolition plans.
Got it.
Will void the special permit.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta? Commissioner Shabeta? Motion is granted.
Thank you.
Zoning calendar, new cases. Item number 1, 2018-108BZ, 1 Wall Street, Manhattan. Yeah, this is it. Are you the only one speaking?
Elise.
When you're ready, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Good afternoon, Chair Perlmutter and Commissioners. Jeff Mulligan from Kramer 11 for the applicant, LTF Club Operations. For the PC at 1 Wall Street, we attended the review session yesterday, listened to your comments. The one comment was from Vice Chair Chanda about providing the noise attenuation measures on the plan, so we did submit this morning. And I have hard copies.
So you submitted about what time?
It was about 9.
It was 9, and I sent it over, I emailed all of you. Yeah.
Oh, you emailed us.
I just didn't get the chance
Oh, I
to
see it, I see
review
it.
Okay.
Okay.
I did receive.
So hard copies are coming.
Is it just one sheet?
It's just one sheet each. So what we've done is on the lowest level, so 3 levels, 3 cellar levels down where we've got the free weights, we're providing the Plytech matte flooring and the sound insulation on the walls. And I think as was noted at the hearing, the residential units don't start until the 4th floor and above. So this is pretty far down in what the chair referred to as a very hefty building.
Okay, this is, subcellar 2 is the 3rd level down?
Yes.
Okay, so you have 1st floor.
You got basement, then subcellar, just take a look at the section. Basement, then subcellar ABC, I think.
Okay, and so this is the only place where there's like a potential noise source?
Exactly.
Okay. All right, and so, and the only efforts, if I'm understanding it, is that the flooring material is changed. I thought you also had other kinds of activity, other kinds of acoustical measures.
So we're putting the sound insulation in the walls as well. And then the statement also identified a suspended ceiling, and we're still negotiating with the landlord where exactly that will go, because they do need to put the ductwork and other building, base building equipment attached to the beams within portions of the subcellar. So we didn't note exactly where it's going to go, because we don't know yet.
Okay. What do the little boxes mean? Is that supposed to be the outline of the Plytech flooring?
Exactly.
Okay. Sort of a clunky graphic, but all right. All right, I'm fine with this. Everybody okay?
Was
Sorry.
submitted into the record?
Yes, it's here.
Yes.
It was submitted. It was in submit, or Veronica, you sent it to submit,
yes,
right?
it's in pre-process,
Good, okay. Good, so then I'd like to make a motion to, oh, are there any speakers on this? Motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Thank you.
We just
Oh,
closed.
no, we just
Just
closed.
Not done yet.
You should know.
And a motion to
How quickly they forget, okay.
Closed.
And a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
All right, now I'll say thank
Now
you.
you can go.
Item number 2, 2018-141BZ, 110-50 68th Drive, Queens. Raise your right hand when you're ready. Are you going to be speaking?
Yeah.
Then I need you to raise your hand.
He's not
Oh, he's a community member? Oh, I'm sorry, sir. Okay, sorry about that. Yeah.
Wherever you want.
Anywhere you want.
No.
No. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Sorry, I thought he was reminded.
Elise Fullader from Eric Palatnik PC on behalf of the applicant. I have with me today from the architect's office, Sandy Agnostu. Did I pronounce her name right? Yes. I also would just like to say that this says it's a two-family home on the, but it's a single-family home.
Right.
And I just want to clarify that because I know neighbors were upset about the two-family home, but it's...
They seem to not be up to date with the application, is that?
It's a single-family home. There was a typo on the first application form that said somewhere two-family, and then we changed it, but then it got carried over to the hearing notice. But, so, firstly, in terms of, I have a handout. Do you want to hand it out? Thank you very much. I need one for myself. For whether this is an existing home and counts as an existing home, we are handing out a Bulletin 2016, and we'd like to point out that this home is compliant with this building Bulletin 2016, and we can go to get an AI1 verifying the existing home, because you mentioned about the home swallowing the other home.
Yes, but you know that this bulletin is not a standard that the BSA uses, nor are we required to use it. The rule is that 50% of the exterior walls need to be retained on the exterior, along with 50% of the existing floor joists. We've discussed this about 4 years ago. I don't want to go into it again.
Do you want to add anything, Sandy, or? Yeah, we'll revise, okay.
Yes, indeed.
The hatching can be provided.
It's our mic.
Okay.
You want to fix it?
No.
I guess it needs to be. Okay. Wow. Okay.
The hatching will be provided to show the floor area increase as of right, where the 10% is, and the existing home, the differences as requested. In terms of the sky exposure plane, we'd like to know which specific drawing you're referring to.
The elevations show the sky exposure plane penetrated.
So So, okay.
So
'cause it looks
I'll
like-
get to the, hold a second, I'll just get to the drawing. Oh, here's the sections. Sections. Where it is, there we go. Section P11. There's only one section, there should be more sections.
Yeah, we will provide more sections.
Right, so P11 shows it penetrating the sky exposure plane. Not only is it penetrating, it's penetrating it way under the roof line. So you have these rafters, and then there's a roof above it. It's quite a confusing situation.
We'll clarify that and then
Okay.
discuss whether it's permitted obstruction or how it.
Yeah, so one of the reasons we need an axonometric
Yeah.
and a rendering is to understand how the roof line is actually working, because you might be arguing that it's the dormers that are penetrating, but that's the fault of only providing one section and not showing us how the section complies.
That's not a problem. So multiple more sections and an axiometric.
And a rendering. So there's two issues. The axonometric is to show how the roof line works.
Yep.
And the rendering is to show that the building is compatible with the neighborhood character.
Yeah, and I was going to get to that.
Okay, but
later.
that's why there's a rendering, right?
For base plane calculations, we're going to check the survey and make sure that they're consistent.
They're not. Consistent
Yeah.
with what?
With the
They're not
survey
consistent with
and
each other.
So we're going
Right.
to clarify that with the survey and make sure they're all
Okay.
For the attic, it's not the grand stair going all the way up. It's a separate staircase that goes just to the attic.
That begins where?
Sandy, do you want to point that out to them?
It's the continuation of the grand stair that goes all the way up.
It's not, and it's not intended to be that way, so we can somehow clarify that more in the drawings for you, but it's not the intention for the grand stair to go all the way up to the attic.
Oh, there it is.
And you can come to the podium.
I mean,
Yeah,
I
if you
see,
speak,
I
you
see
need
the
to be-
argument you're saying that it's a separate one, but it's a continuation of that grand stair gesture. I mean, yes, from the second floor, you have these two set of staircases that are leading down, and you have one that's leading up, but it is very much a part of the entire staircase system. I think that's how it's being read, and unless you're planning to propose something much less, that's a different.
So the point is, we've had an application almost identical to this one before, where the board was quite upset that this little tiny special permit that's supposed to be limiting the enlargement to 10% was actually overtaking a tiny little house and then treating the attic as if it were an attic when it was really effectively a ballroom. In that case, it was an enormous lot. So it really was a ballroom with 7-foot, 11.5-inch ceilings. So in this case, it's exactly the same design concept. It even is the same design of the building. It's just on a smaller lot. So we're not here to facilitate, I mean, if you want to pursue this kind of thing on your own at the DOB, be my guest. But once you come here for a 10% increase in floor area, we don't want to facilitate these gigantic houses that are really not what this little special permit was intended for.
I would like to point out that we talked about yesterday how the homes on either side, and we can show this in the 3D rendering.
That's a different question.
Okay.
So those homes arguably are as of right, because I don't know how they got there, right? And this little 10% increase isn't, you know, if we look in reality about how much floor area it's giving you very little floor area. What makes this house look so enormous is the fact that you have this gigantic attic in there. If you were to take out your 10% increase, you'd still have an enormous house because you're taking advantage of the 10% attic. And then you wouldn't have to worry about maintaining, which is what I said on that other house, then you wouldn't have to worry about maintaining 50% of the exterior walls and all that stuff. You'd still get a big square house. It would just be a teeny bit smaller than this big square house. So I'd recommend that you, if you don't like the results of maintaining the exterior walls on the exterior, because it's going to mess up your big square house, that you not pursue this special permit. It is going to mess up your big square house, which is the grand, symmetrical, big round staircase, all that stuff, because the existing house doesn't have that form. I'm just giving you a little design advice, that's all.
The 10% isn't asking, it's not like the other special permit where you ask for much more, it's 10%. It's not.
I know, but we're not seeing a 10% increase here. We're seeing an enormous house engulfing a smaller house, a very modest house, and being made more enormous by taking advantage of this strange attic phenomenon. Right? And I'm just telling you that when you put the house back in here, you're probably not going to like what the result is, because you're going to need to keep a lot of exterior wall on the exterior, which none of which, as far as I can tell, you're keeping right now. Just advice. I actually have no idea where the existing house is relative to, that's why I asked. You need to show where the existing house is, and as far as I can tell, there's about 20 feet of it maybe floating on the two sides, and the rest is gone.
Right, so I heard the comment yesterday. We'll provide a drawing that shows the outline of this existing home and then the proposed enlargement and where that 10% is located.
Okay. And, you know, the other part of what's making it enormous is the base plane changed by, I forget what number, 8 feet or something like that, from the existing house to the new house.
I believe those numbers, there's an error in the numbers. It's not really a change, but we're going to verify it with the surveys. We have 2 surveys, so we have to verify where those numbers came from and correct the drawings.
Okay. Okay. Anything else? Neighborhood character study you're going to work on?
Oh, there was a comment about the planting area. We comply with, in the front yard, we comply with the planting requirements for an R12A district, and that's on the zoning calculations sheet.
Which is
on the drawing.
On drawing P1?
Yeah, P1, the site plan.
Where do we see the calculation?
Planting requirements for section 23-451.
Okay.
And for neighborhood care,
950 square feet, but you don't show the areas of your planting.
We can revise the site plan to show it. Oh, actually, it's hatched here. It might be hard to read, but it's like that hatched area in the front, planting area, planting area.
But it doesn't tell you the square footage unless it's overprinted. I don't see any square footage.
Okay, so we can provide, we've done it on other applications, like a breakdown with the square footage and the dimensions and a little diagram showing that. We can do that.
There's a standard, right? Okay. And then?
And I gave a lot coverage diagram and a floor area diagram in my original submission, but I can provide more on neighborhood character.
More on the what? Sorry?
You said neighborhood character study?
Yeah, so this isn't about lot coverage and it's only about that. It's also, it's a gigantic house.
I did a floor area diagram and
a floor, you did a.
showing all the neighborhood floor area.
Right, but so then we're putting in this very large, very tall house into the neighborhood.
Yeah.
What does it look like? That's
So then
why,
we'll
that's.
also do the 3D to
That's what I mean,
back up
that's
those
what the
two.
rendering is for.
Okay.
Okay. Yeah.
To show the proposed in context with the other homes adjacent to it.
Correct. And normally we get streetscape studies, right?
Yes, we'll do that.
Yeah, okay. All right, that's it. Are there any speakers on this? I think there are. Yes, okay, please. You have to come.
Come to the mic.
They're building one family?
State your name, please.
Isaac Yonatanov.
Okay, Isaac Yonatan?
Yonatan, yeah.
Okay, they're building a one-family house.
I'm not building anything. I just want to know, are they building one family? This is my neighbors. Are they building one family house or two family
They're
house?
building a one-family house.
Okay.
That's all you want to know?
Yeah.
Okay. One family.
Because the letter said, when we got the letter, it says they're building two family house.
Okay.
That was an error. Ms. Bolder said that was an error in their papers. It's actually a one-family home.
No, okay.
Yeah, we corrected in the papers with the hearing.
Yeah, but I did.
It's true, it still says two-family on
It says
our-
two family. I got the letter.
Yeah.
That letter says two family.
It's a mistake.
It's a mistake.
No, no, no.
It's a
I
mistake.
had the hard
Okay.
Okay, sign in. Excuse me, sir, can you please sign in?
Yes, please.
Okay.
Okay. All right, how much time?
No, nothing. I mean, I'm not opposition.
He's not in opposition.
But I did send the.
But he spoke, so he has to sign.
Notarized, I can. I have a-
Objection?
Objection, but
Okay.
Since it's not family, I don't want to, I want to be good neighbor, it's one family.
Okay,
So
so
what I
just,
do?
so you don't have to do
But you
anything.
do have to sign in just for the records. Yeah, that's all.
No, because they sent me the letter with saying that's two family.
Ms. Pringle, just put a little note next to
And I
it.
notarized it,
That
I
he-
sent it to you.
He's not in
I want
opposition,
to be
just.
that neighbor too.
Thank you coming for coming.
Thank you, sir.
Oops, don't trip.
Okay. How much time do you need to make a submission?
5 weeks. All right, 5 weeks, please.
Oh, okay. That's almost 3. That is 1, 2, 3, 4, 5. It's May 1st. Can you do this on the target day?
Just give us the next one after that.
It's Frick Day, though.
Well, you know.
It'd be better.
No more special hearings.
Okay, so the closest we can do is June 11th will be the next hearing with a submission on May 22nd.
That's fine.
Thank you.
Maybe we'll add a special.
Yeah.
Item number 3, 2018-156BZ, 80-97 Cypress Avenue, Queens.
This is the team who's signing in, right?
Yeah, this
Who's
is the whole
swearing in.
team. And anyone who plans to speak on the team.
Only who's planned to speak on the team, right? Not from the neighborhood.
Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Yeah.
So, we're right.
Richard LaBelle of Sheldon LaBelle PC for the applicant. Almost, yeah, good evening, I guess. Chair, Commissioners, it's a pleasure for us to be presenting today with regards to Well Life. Well Life is an experienced and longstanding developer of both affordable and supportive housing. And with us today, we have representatives from Well Life, as well as from the entire development team, to answer some of the points that were raised yesterday in the chair and the commissioner's comments in the executive session. So very briefly, commissioners, this is application under 7221, and as a variance application, we feel that the application meets the findings with regards to the relief that's requested. The site is an 18,500, roughly 18,500 square foot site. It is located on Cypress Avenue in Queens Community District 5. It is adjacent to the Mount Judah Cemetery and directly across from Cemetery of the Evergreens. The proposal at the site would be for a 6-story, 100% low-income affordable housing development with 66 units, 40 of which would be for supportive housing for homeless or formerly homeless individuals and families, one of whom has suffered from a debilitating mental or other condition, and the remaining 26 units would be for low-income affordable housing. By way of background, this application has been to Community Board 5, both in terms of their land use and full board committees. We've appeared before them a total of 3 times. The Community Board, in a rather lengthy letter to the board, has issued an approval of this application by a vote of 33-2. And we're very happy with the level of community involvement to date, which is why we're happy to be before the board to answer these questions that were raised and others. The bulk waivers derive in part from the trapezoidal nature of the lot. The lot is adjacent to an unmapped but unopened street, and is also, again, suffers from somewhat irregular shapes and dimensions. However, most of the application, of course, derives from the nature of the applicant, which, as a provider of affordable housing, is what we feel providing a necessary and important role in providing something which goes to a fundamental interest of the state, which has been previously demonstrated in prior cases before the board, and one which furthers the public safety, health, morals, and welfare, as has been previously set forth before the board in cases as well as in case law. I know that the chair and the commissioners had many questions with regards to the program and particularly the financial aspects of the program. I think at this point I would probably introduce the project team, in particular representatives of WellLife, who can talk a little bit about the history at the site as well as the nature of the funding and the population to be served by the premises.
Hi, my name is Crystal John. I'm the Vice President of Behavioral Health Services at WellLife, and I'm here to talk about the program and the history of our agency. We have been in existence since 1980, and we serve over 1,000 residents within our residential program, some in scattered site and some also in buildings. We developed 2 mixed-use buildings. The one that we'll be talking about today will be our 3rd. One in Brooklyn, which that was in 2007 in the East New York section of Brooklyn. And we have one in the Bronx on 165th Street in the Bronx.
Do you have an address for Brooklyn?
The Brooklyn is, it's on DeWitt. You want the exact address?
Yes, you want the exact address.
Okay, I'll get you the exact address, definitely. But it's on DeWitt Street in Brooklyn, and that is also the low income with special needs, that population. The latest is 2016, we developed the one in the Bronx on 165th Street in the South Bronx. I'll also get you the exact address on that too, please. Okay, and that's with the low income, with families, and with special, the low income and also with families. We have approximately 15 children in that building, and we have on-site case management. We also have enhanced services coming into the building, working with our special need population. I want to say both buildings, since this project, it's been very, very successful. Both populations coming together with the low income and the special needs, they come together. We have group meetings, we have landlord-tenant meetings in our community room. We have the backyard for the children to go out and play. We have different events where we have the van come and pick up our consumers and take them to picnics and holiday parties. It's been extremely successful, very little incidents, basically none.
So you have a bus that comes and picks them up and takes them someplace else for an event? Is that what you're saying?
We have a van, yes.
A van.
We have a van within our program. As far as their daytime activity, a lot of them are working. They have employment, supportive employment, and they also go to some type of daytime activity, some type of program. A lot of them are using public transportation, the train or bus. They also using Uber, and they have Medicaid taxi service that will come and pick them up. Very few drive. I can count on my hand how many really own a car and drive. And for, like I said, the special events, we have a van that will come and pick them up.
So the people who work, how do they get to work? This is from the Bronx location you're talking
From the
about?
Bronx location, a lot of them are using public transportation.
How far away are you from the subway?
Approximately 3 blocks away from the subway. And a lot of them also are using Uber, and they use the Medicaid taxi.
So,
I'm sorry, were you asking about employees, how they get to the site?
No, I'm asking about residents.
The
people in the residents who work, they walk 3 blocks to their
Yes,
subway to go to work.
correct.
So, and how do they pay for Uber? That's expensive.
A lot of them are working, they're employed, they pay for the Uber, and with the Medicaid, they pay for, with the Medicaid taxi, they pay through Medicaid. Medicaid will reimburse them, or will pay for it.
But that's a special kind of Medicaid?
That's a special kind, yes.
So, and how about your Brooklyn location?
Our Brooklyn location is similar. As far as public transportation, it's approximately 2 blocks away, and a lot of them are using public transportation more so than Uber. We also have bikes, and a lot of them are riding bikes to and from. We have a bike station in each of our the new
You have your own
developments.
bikes as opposed to city bikes?
Our own bikes, correct, yes.
How many bikes do you have?
In one site, we have 5 bikes, and the other one, we have, I believe, 7.
So, sorry, the van is a Medicaid, what is it? It's a Medicaid Uber? It's a Medicaid what?
Our van that we use within our facilities are the vans that the agency owns.
No, you said there's a Medicaid something.
It's a Medicaid taxi, yes.
What is that?
It's a taxi that the clients with their Medicaid, it's built into their benefits, where the Medicaid will pay for the taxi service. A lot of them are
But who is
using
the taxi service? In other words, you go out on the street and you hail a taxi and they give you a
No,
receipt?
it's a certain number that the Medicaid recipients are given to call this taxi, and Medicaid will cover it. And that's for like medical appointments. They just can't go to the taxi for recreation. But for medical appointments, for daytime activities, like a drop-in program or some type of day program.
Okay, so you can't use it to go to work, for example?
Right.
Okay. So, so in this location, you're outside what's known as a transit zone. You're really far away from subways. How? What was the plan in this location?
For this location, we are approximately 7, I Googled it, we're approximately 7 blocks away from the train, from the bus. And we
Sorry,
also,
the train from the bus?
From the bus, I'm sorry.
From the bus.
From the bus. And we also, like I said, we have a van that we can utilize within our program to pick up individuals, or even for doctor's appointments. We have it's called peer support, and it's individuals that are getting treatment, mental health individuals that are working with other clients in our program. And a lot of them are travel training our individuals, and also staff are picking them up in vans and taking them to and from. So if it's a doctor's appointment, say, and the individual cannot travel on his or her own, then the staff will pick them up in the van and take them. Because of the population that we're talking about today is going to be the frail and elderly population. So we will provide some form of transportation for that population.
So this group won't be working? This will be different from the other 2 sites?
Right, from the other 2 sites. I'll talk about this group right here. This group, we're going to have the Cypress group. It's 66 beds, it's 40 special needs, and within that special needs, we have 14 mentally ill individuals, 13 homeless, and 13 frail elderly seniors. So I'm assuming that the frail elderly seniors will need some type of assistance getting to and from doctor's appointments, or even to visit loved ones, or even to socialize. Our agency will provide the van service to take them to and from, or give them some type of assistance. If they're not reimbursed with the cab service, or if they cannot travel by public transportation, we will give them that assistance.
What about the other 28 or whatever the number is?
The other 14, which is the serious mentally ill, if they can travel train, then a lot of them actually prefer to go independently to off-site places. If it's for recreation, if it's to visit a loved one, they prefer to travel independently.
Right, but how are they going to? They're 7 blocks away from the nearest bus stop.
If they prefer to go on their own, or if they prefer for some type of assistance, then that's when the staff will give them that assistance. We're there to give them that assistance as far as traveling.
So you don't think walking 7 blocks to the nearest bus is... So I read in the papers that the people who were living here, for the most part, other than the elderly, which could also, well, if it's frail elderly, it's a different thing, but that they would be working. Because that's the whole idea of integrating people back into society and getting them into the workforce, right?
Correct.
So this location is far from public transportation, so how do they get integrated into the workforce is my question.
Chair, I just wanted to raise, because this was a subject which was discussed further with the community board, who, while supportive, raised similar concerns. And Crystal, we spoke with the community board much like we're discussing now about the fact that there was a combination of transportation options. But I think probably we could give you some more specifics with regards to like a breakdown of exactly what transportation would be utilized by members of the population, and this was based on prior experience. The community board also of themselves discussed the potential for discussing an extension of existing bus routes with the city. This is something that they had actually been interested in for a longer time than merely our application. So we can also consult with them on that, but we would love to have the opportunity to flesh this out and give you a little bit more specific information.
Okay. Okay. It's just that it's a statement that's in the materials that this is a group to be integrated into the workforce. How do you work if you can't get to work?
Understood.
Right? So that's something that has to be.
Okay.
And in terms, so what is it that you do actually for this organization?
Okay, so I oversee all of the residential housing. I supervise the managers. I also developed a lot of these projects. Not only the projects, but scattered site housing too.
Okay, so do you frequently visit these 2 locations?
I frequently visit. I'm involved in all of the type of activities that take place on site and off site. If it's if it's a Christmas party, a holiday party, excuse me. If it's a picnic, I'm part of that. Involvement. I'm part of some of their treatment as far as making decisions, as far as if it's as simple as where they will be receiving their clinical services, part of that team of making that decision.
Okay.
This wouldn't be 437 Dewitt Avenue?
Yes.
It is?
Yes.
Okay. So what's the difference between these 3 sites that were this proposed site and the other 2, and there's many sites that on your website that say that are hubs. What's the major difference between these?
The major difference between those 3 sites, it's mixed use. So you have special needs and you have the low income in one facility, in one building.
Sorry, the difference between this site and the other sites is special needs plus low income and the others are not?
We have other sites on you're saying you have other sites on our site, right? As far as...
There seems to be...
Right, so we have other community residents, they call community residents, and those are this for individuals coming out of a lot from psych centers, and they reside in this facility with 24-hour staffing, and it's not with the community. This is just strictly consumers living in one building. So we have that on our site. We have 5 of those buildings, and then we have what they call the mixed use population. So that's with the special needs and the low income coming together, living in with the tax incentive in one building. So we have 2 right now, and then this development of Cypress will make 3.
Okay. I think one of the reasons that she was addressing these 2 sites is because I wanted to know what their development experience is, because this special permit is for those who are experienced at developing low-income housing.
It's not a special permit.
I'm sorry, a variance. The deference had very strict criteria that one of the tests was that it's an experienced low-income housing development group, because I'm very concerned about, as I said yesterday, facilitating failures. So to that point, you're not one of the people who worked on development, though. Is somebody here who, in your group, who was one of the developers? Who worked on development in your organization?
Good evening. I am Willie Scott. I'm the Vice President of Public Affairs for the Wildlife Network. The building, as it currently stands, was developed more than 15, 20 years ago under the first president of PSCH. The material that was used by that developer was substandard, it was porous, and the building was not usable.
So let's just go back. So PSCH, which is your...
PSCH is our former name. We have rebranded. We've rebranded. We are now the Wildlife Network.
Right.
Now, we are now 2 presidents since that president. When I came on board in 2004, we had a new president in 2006. He told me, he said, we need to get this building up and running. So I went to HUD and I asked HUD to let us take over the property again. They said, well, it was a failed project and you couldn't do it. So we explained to them after 4 meetings, we have a new president and an entire new staff, and no one that worked on that project is currently at Wildlife. So HUD said, all right, you can have it back, and that's how we got it back to get to this point, after proving ourselves.
In 2006?
No, we received the building back in 2015 or 16. It took us that long to get it.
And what did you do to prove yourself? What was the, just?
We showed them our track record for our new president, Alan Weinstock. We showed them what we had developed, and
we're talking about the other 2 locations that you had developed.
And other things that we were doing, yes.
And there are other...
Yes, those are not, the other places are not affordable, so we don't, but we have done other developments.
What? The other places are not?
They're not affordable housing, so we didn't count that. They are, like she was talking about earlier, when she was talking about supportive housing and all that, that's why we were talking about these 2 buildings here, these 3 projects.
So I think it would be helpful if you can give us a very clear chart of what all kinds of programs you provide over the years, and that could include a category that is supportive housing, affordable housing.
Okay.
But I think we need to get an understanding of the level of experience you have dealing with supportive housing residents and very low income, or even elders, I would say. So give us that breakdown. It's possible that you may have individual buckets of residents, but we all, and you may have them all in one. We want to review all the possibilities.
And the good news is it sounds like you have a pretty decent start on everything that you gave up. Right.
So, but my main concern is scattered sites are somebody else's building, right? That's an apartment in somebody else's building, so that doesn't require any development expertise.
Right.
The thing I'm very concerned about is what happened to you in 2006, that money is given by the government because of a grant from us, and then because you don't have development experience, it fails. And I don't want to be a part of there are too many not-for-profit housing developers in the city who should benefit from this, and I don't want, and I do have to say, I used to do low-income housing as an architect, and I walked through so many failed projects, and that was very sad. That represented millions and millions and millions of government dollars wasted, and I don't want to be a part of that.
But as I'm saying, as I'm stating, that was not us. We are the ones that turned this whole project around.
Okay, but you need to demonstrate that to us because you have this, what we call kind of a cloud on your record, which you recognize by changing the name of your organization, even though the names are sort of still traveling in tandem.
Well, we changed the name not because of that. We changed the name because the original name of the company was PSCH, which stood for Professional Service Centers for the Handicapped. That word became archaic. So then we changed the name to PSCH. So you'd go to a meeting and they'd say, PSCH, what does that mean?
And
PSCH. So the new president, Alan Weinstock, he came, he said, I'm tired of people asking me, what does that mean? And there's no meaning. So we rebranded. That's why we rebranded.
Oh, okay, fair.
And I think to Chair's point, we do want you to list the development that you have been involved in, not just providing the services. That's one bucket. The other one is the development that you provide under the new leadership.
Understood. And we'll be happy to do that. And just again, because I think we all benefited on the team from going back to the community board 3 times, but they also were quite interested in the history of this building and this site, and to ensure that that this would not happen again. I mean, they really, they did question us on this, and there was a very thorough discussion, and so we're happy to provide the additional information.
On that same note,
Yes.
Have you met with HPD?
So I think at this time I'd probably defer
The
to...
reason I'm asking that
Sure.
question is because, from what I remember, when HPD does review a potential application, they're always looking at the track record
Sure.
of the developer, and that is a critical point in securing your 9% tax
Absolutely.
credit, since it's a competitive program. And I just want to know to what extent that has been weighed in by HPD, and has there been any issues on that? And how many recently have you gotten
So, Vice Chair,
HPD funding?
I would introduce Michael Newman from CSD, who is a development consultant on the project, and have him address some of the HPD background.
Good evening, everybody. We've been talking, for the record, my name is Mike Newman. I work for CSD Housing. We've been talking to HPD about developing this particular, or redeveloping this particular site for several years. The initial response from HPD, in all honesty, was get out from under the HUD lane and come and talk to us. Welllife was able to do that fairly recently. And we've been in to talk to HPD several times. We talked to them about going through the BSA process. It's going to take a while. We talked to them about helping us to figure out the unit mix, the number of units, the type of financing that would best work with this project. And they've been very supportive. Now that we're out from under the HUD lane, they've been very supportive. They know we have to get through the BSA process here, which, take a little bit of time, and then we can get more serious with them about design and financing and numbers and budgets, that sort of thing. So everything's been conceptual. I'm sure if you haven't already done so, you will reach out to HPD. Our contact there is Teresa. Okay, so CSD Housing is a for-profit housing development consulting firm. The only thing that we do is work with nonprofits who need our assistance to develop affordable/special needs housing, the mixed-use model that Crystal talked about. Most of our work currently happens to be downstate, but we've done projects from Buffalo to the Bronx. We have never used HPD financing. The vast majority of our financing for our existing projects has been through the state, but we've been talking to HPD. We'd like to work with them. They seem real interested in working with us, And depending on how this process goes, hopefully it'll be positive. This will be our first formal submission to HPD. Ideally, we'd like to get in this fall if schedule allows. So the firm has vast experience developing affordable special needs housing. The firm is owned by a lawyer and an engineer. Both are successful developers in their own right. My history is I was a housing director at State OMH for 17 years. And that's where I met the folks from Welllife. All of the single-site projects that we're going to put on the list to give to you was probably done under my tenure at OMH. And we look forward to working with you.
So you're a turnkey developer effectively, right?
We do not take title. We do not have an ownership stake.
Okay.
We just provide consulting services. We introduced Welllife to Richard LaBelle. We brought in the architect. We have connections in the industry, both upstate and downstate. We've complete the financial applications. So we're kind of a jack of all trades, depending on what our nonprofit partners' clients' needs. But we don't want to take title in properties. If we have to, we could. We don't want to manage. We could, but we don't want to manage. We just want to provide our consulting services as needed.
So I have to admit that having worked with a lot of not-for-profits doing low-income housing development, I'm a little concerned here because the last one project they did was 12 years ago, and the other one in 2006, well, they said 2006, 10, whatever.
2007 in East New York and 2016 in the Bronx.
Right, so 2016, I haven't heard how that was developed, so I don't know. But what I'm concerned about is that these are not, unlike many of the other not-for-profits we see, regular developers of housing. You know, a lot of these groups build a building every couple of years, right? And it's kind of like they do it in their sleep, and they don't have a problem with doing it. So here I'm concerned about who's the person on the team who make sure the drawings are done properly, who make sure all the right engineers are hired, who make sure the drawings are coordinated, who make sure that HPD and DHCR and all those agencies sign off on the drawings, who make sure that the mortgage financing is in place, who make sure that once construction starts, it's moving according to plans and you don't get a project that was built with substandard materials, who make sure, et cetera, et cetera, et cetera, which is done by an experienced developer person.
Okay.
Right?
Yep. Yep. We will help in virtually all of those areas that you just mentioned. As you probably know, Welllife is a fairly large agency. They have a facility staff, multiple people on the staff that are involved, that work hand in hand with us to not only locate sites, but to work with the design team. We feel we have an awesome architectural team. We work with them on the East 165th Street project. It was a very difficult site. It was a brownfield site. We had to go to the office of, the mayor's office of remediation. It was very complicated, and it was a very, very smooth project once it all came together, from a design, construction, remediation, financing, not a problem.
So your organization worked with Welllife on developing that 165th Street project?
We did,
okay.
Yes.
So maybe you could give us some more information about how that project was structured. I'm just being honest. I'm very concerned that they're not low-income housing developers. And unless, which is not the purpose of this variance, right? I didn't want novices to be the applicants. So I need to know that somebody really, really experienced is actually running this show. Otherwise, I'm super concerned.
Okay. Maybe I was a little bit brief on the background of one of the principals. I said he was a lawyer.
I'm sorry. I think it's something that it is a really big concern of ours.
Mm-hmm.
So it's something we're going to need a submission on.
Okay, that's probably best. It works for me.
While you were talking, I just did a Google search on CSD housing, and based on the map, there are a couple of projects that it seems they're in New York City. They're listed as current projects. So I think it would be helpful in your discussion. You can refer to what those are, how far along, who's, because going to the questions, we're trying to understand the strength of the team.
Yes.
Okay.
And I'm just going to reiterate to Mr. Lobel, those findings are findings, right? The finding of it being an experienced not-for-profit housing developer, you need to persuade me, right? The last applicant we had has been building low-income housing for the last 100 years.
44.
44?
44 years, correct.
Well, maybe it was
3,900 units.
3,900 years, okay.
No, 3,900
Units.
Unit, 39 units.
All of time.
Half of charities would be 3,900 years.
So, no, Chair,
3,900 units over
Over 44 years, correct. So we, because this is to say, we don't take this lightly, and we understand these are findings, and we have confidence in this applicant, we have confidence in the development team, we have confidence in CSD, which, brings to the table a tremendous amount of insight and ability to, and they have previously successfully paired on development projects in this regard. So we understand, this is it's not something to be taken lightly, but we do feel that the ability to provide these units in these locations is not only represents a satisfaction of a fundamental interest, but is one which can be addressed and handled by this developer. And we will meet our findings and do that.
But so because we know each other.
Of course.
I don't want this to be used to bring in somebody who wishes they were a housing developer tomorrow and is going to try it out now because you just opened a door.
I know I can't do that.
Door's not opening,
yes.
right?
Precedent for us is of as important as it is to the board because we rely on it as well. And so
I know, that's my point.
Yes. But I mean, look, as much as I'm flattered that Mike mentioned the fact that he introduced me to Well Life. The truth is that I've grown to know them over the last year and a half, 2 years, and this is an organization which does not merely have a sincere interest, but one which has, in my opinion, the ability to do this. It's a matter of evidence and proof. We appreciate the Vice Chair's discussion with regards to providing a discussion of all the buckets in which they are involved. This is an agency which runs deep, and there are thousands of individuals who are provided services and affected. And the interesting thing about the standards set forth by the board was it says that the experienced affordable housing developer has developed and managed. And so to that extent, we look forward to providing all this evidence with regards to the fact that there are many people that are managed by this agency and provided services. They're the real thing.
Now, I'm not questioning their excellent program. That's not it at all. It's just, what do I do for a living?
Yes, Chair.
Do I develop low-income housing? The answer needs to be yes.
Yes, Chair. I understand.
Okay. All right. All right. So that we had a lot of other questions. You want to go on to those?
Sure. Is there
any order you want to take it in, or I'll just ask you questions?
I think I know that there were a number of questions with regards to the architectural choices of the building.
Let's stay at the more A level questions, okay? Or the initial understanding of the project questions. So one of the things that I pointed out is that this application is requesting a lot of waivers.
Right.
And what about using, so this is the minimum variance necessary, combining this with a 73-623 special permit? Has a lot of opportunities, open space.
Sure.
Not parking, but open space, heightened setback.
Yeah, essentially those bulk waivers other than parking and floor area.
Yeah, that would be really helpful.
Well, Chair, I think that's something we'd like to look at then. I know that from a legal standpoint, the board has the authority to grant all of the waivers requested under 7221. So I think that, L'Oreal, give me a moment.
Sure.
I think that
waiting
So I think that to the extent that we were able to satisfy the findings, that administratively, we would choose to do that. However, we've been through the special permit process numerous times, and to the extent that it would relieve some of the burden on the applicant, we'd be happy to look at that and as an administrative matter, proceed on both applications. Thank you. We try really hard.
Okay. All right, then there's this mysterious easement running along the demarcation line. What is that?
Yeah, I think upon consultation with the project architect, we can provide more information, but I don't think that that actually is, I think it's noted incorrectly on the maps, but we can again, provide
You need a
evidence.
title search.
Yes, correct.
To know what that is.
Correct.
Okay. Then, sorry, I'm just going to keep scrolling. You heard my comment about the trapezoid not being a
Yes.
particular hardship. It's
Thank you,
just a
Chair.
very nice trapezoid. Sorry. Oh, yeah. So now I'm going to get into a little bit of the program, but I'm going a little bit out of order also, because one of my big questions was about the 59th, is it Avenue or Street?
Street.
59th Street. So the plan shows a portion, the northern portion of 59th Street being opened. I think that's the northern portion. Maybe it's the southern portion. Which way is that? The northern portion of 59th Street being opened there, where it isn't open. Why does it need to be opened? And why is there a drive-through?
Good evening. My name is Utkalika Panda. I'm representing UAI. We are the architects for this project. On the survey, a portion of 59, there is a dead end on 59th Street. That's where the driveway meets the dead end on 59th Street. The rest of it is undeveloped or unmapped.
Why is the driveway meeting the dead end?
We have a vehicular entry on Cypress Avenue and then a vehicular exit on 59th Street.
Why?
Because we were told, like this Cypress Avenue being a very busy street, initially we had like entry and exit on Cypress Avenue, but then we were advised and as per the traffic of this area, we decided to have a through traffic entry on Cypress and exit. It was also at the request of the community board.
Community board wanted a drive-through?
Correct.
You can speak, Richard.
So yeah, they requested a reconfiguration of the site so that there would be a drive-through. They felt that that would work better with the traffic pattern.
Because what that's doing is, for one, it's only for 19 cars in a parking lot, and for two, it's putting pressure on the houses, you know, on this little road to be, who knows, we don't know what kind of activities are going on there. So if you treat it as a loop, they'll come down Cypress and go back up 59th, or the other way around, whichever way 59th runs. Not really understanding why you would want to put pressure on residents of little houses on 59th.
Yeah, it was the plans as originally proposed did not have that drive-through, and it was later added. To the extent that the chair and the commissioners feel that it makes less circulation sense to configure it in that way, we can explore turning it back, and then looping in the community board as well.
I just want to point out one thing. The Cypress Road, there is, just trying to get a map which shows the bigger picture. There isn't any traffic light until I think one comes almost to the site. There is a traffic light. So a lot of the vehicles that are coming onto Cypress northbound are exiting the Jackie Robinson Parkway. So there's a certain amount of vehicular speed that these vehicles are exiting from and continuing on Cypress. So maybe, I think that may be the reason why the community board wanted, and there's a little bit of a turn that's happening. So maybe that is the reason they probably wanted to minimize the conflict of vehicles entering into the traffic flow of Cypress. I mean, this is what I experienced when I was going to the site, because you come out of the Jackie Robinson and the first traffic light you come to is pretty much close to the site, and the next one is at the intersection, I think, of Clove Place or a little further down up of that. So it almost is like, acts like an exit ramp from Jackie Robinson. So I'm just conjecturing that may be the reason why the community board wanted to minimize that conflict.
But you don't know the actual reason? So they didn't discuss it at the hearing or at the committee meetings?
They requested the change, and after we made that, they basically removed that from their list of potential objections to the project.
Oh, so weird. Okay. Maybe you could find out what they were getting at, because it's pretty mysterious. And it's having, well, one of the reasons that I'm concerned, well, I'm concerned for a lot of reasons. It means that there's lots and lots of asphalt on the site instead of greenery, because you've got this roadway going all the way through. It's also having an impact on the floor plate of the building, because there's this roadway running all the way through. And then I'm actually concerned from the fire department's point of view, because it's an existing dead end, but what you're doing is now you're extending the dead end in front of your building, so that's where the fire department comes in, and often they say, well, you can't just have a dead end that is rectangular, our trucks need to turn around. So then that starts into a whole thing about however the turning radius is for the fire truck. So it opens up a lot of issues that you might want to actually avoid. So that was one question. Sorry, I need to scroll back to my question file. Then another is, sorry. Sorry. Oh, yeah. So in terms of the financing, so I'm going back and forth. So, so we have as the possibilities of financing the low-income housing tax credits and the supportive housing loans. I'd like to understand if there are any other subsidies sought, because I saw there's a mortgage that's figured in there. And I'm wondering, you know, what happens if you don't obtain these subsidies in the face of, let's say we were to grant?
Mike Newman again, CSD Housing. We anticipate low-income housing tax credits 9%, which would be probably cover about 65 to 70% of total project costs, and a grant from the Supportive Housing Loan Program. At this point in time, again, it's kind of preliminary. I'm not sure there needs to be a mortgage. I know on the state side, very often they'll say based on the net operating income, you can afford some debt, so take it. So I'm not sure what HPD will do here, but we'll just work together to make the numbers work.
But if the scale of the low-income housing tax credit is, as Commissioner Shanda suggested, based on track record, to get you to 9%, because we've worked on other ones where they only end up giving like 4%.
4% is as of right. 9% is a competitive, so you're almost going to get the 4%. It's to get to the 9%, you have to prove your track record, the deeper subsidy you provide, the number of units you provide, and all of those things count in your favor. And I know for a fact that typically supportive housing programs always start off with a plus, because they're providing supportive housing.
Yeah, so they get a little
bump
boost.
up.
Yeah. So, but let's just say, because you as the development consultant don't have experience with HPD, the group that you're representing may or may not be seen by HPD as having adequate experience. Why assume the 9%?
Well, I'm only hesitating because I'm representing my financial person who had an accident last night and got stitches, so she couldn't be here today.
Okay.
But if we did not use the 9% program, we would have to bring in another competitive funding source. Mm-hmm. So it makes everybody's lives easier just to keep it simple with HPD resources.
What would be that? Sorry, go ahead.
Sorry. That's assuming the best case scenario, that you get the 9%.
Wait a minute, we didn't finish. Let's finish with we didn't get the 9%.
Yeah.
So what were you saying? Yeah, you were saying if you didn't get the 9%, you'd have to go through another source.
We'd have to bring in another funding source.
What is the typical matching funding source that goes with supportive housing loan program and with a 4% tax credit?
It would be the Homeless Housing and Assistance Program, New York State Office of Temporary and Disability Assistance. It's
That's a state?
It's a state program, yes.
So have you and that's managed by DHCR?
It's managed by the Office of Temporary and Disability Assistance, different state agency.
Yeah, I seem to remember.
But they all talk to each other, and so.
Right, but does HPD handle the analysis for all of them, or you have to submit your drawings, your project, your underwriting, all of that to the Homeless Housing Assistance Program?
Yes, the latter.
So
It'd be a
have
separate
you reached
application.
out to them to see whether, in the event that you don't get 9%, they would be interested in this project?
We have not reached out specifically about this project, but I can tell you that they are oversubscribed roughly 3-to-1. I'm working on a couple projects now, and I have those grants, so it's not new to us to get them, but I'm just trying to be realistic and not trying to worsen an already competitive situation there. I mean, the advocates have been pushing very hard to get their annual allocation increased once again this year. I understand that's not going to happen once again this year. But for instance, in 2018, they came out with their RFP in May, started accepting applications in June, and by September, they turned off the spigot and say, no more, we're oversubscribed. So we're sensitive to that. So all of our projects, we don't want to send them all to HHAP. We're trying to do it a different way, probably a more efficient way would be to go to HPD. And again, we've been talking to them, and it's premature for them to make any final decisions, obviously, but indications are they're interested in this project. So,
so as part of the way this particular application process works, is that we need much more certainty about these projects. So we reach out to HPD, but we expect you also to reach out to HPD and do more than talk about your wish list. We expect you to actually show them this project and work with them to understand whether in their next pipeline they would more than, let's say, be happy to have your application, but really be serious about having this be a project. And, to the extent we can get further commitments from them, that would be the goal, but we know how they work. But at the moment, as I mentioned in my comments about the design of the building, I don't even know whether they would be okay with the design of this building, because it's not superficially meeting some of the guidelines. So, and having never shown them the drawings, because I used to be an architect submitting drawings to HPD, and they would take a piece of yellow trace and lay them on top of my drawings and redesign my entire building. So, because they had a certain way of designing everything, right? And this doesn't look like it. So I just don't know whether it would need to be redesigned in order to meet HPD's ideas for very efficient design, because the relationship between the core and the program is quite inefficient. And that's actually something that, where's the architect in this story? Oh, yeah, okay, yes. So what we need is also an analysis of your core, so circulation and core area to the building, let's say the dwelling units, to the
residential
occupiable.
area?
Yeah.
The residential area? Okay.
Right, so the actual occupiable versus the circulation and core.
We had done a quick calculation of the efficiency for the typical floor from second to the fourth, where just the net residential area, the unit area, versus the whole gross floor plate, it came to like 75%.
Wow, that's pretty. I'm just saying that because from my days at city planning, at HPD in the architecture unit, we used to see much lower percentage for supportive housing. So.
Supposed to be 10 to 15%, right?
No. The residential, it's a good percentage. That's what I'm saying.
Yes.
Generally, we have seen a lot more wastage of these core spaces in circulation and hangout areas and things like that. And this is just tightly just circulation and core. This is 75% is a.
This is for second to
Yeah.
second, third, and fourth, where we have the
Right.
full
It's only
floor
the
plate.
residential floors.
Yeah,
Surprises
that's-
me because it doesn't look like
That's pretty impressive.
I would like to add that UAI has done a lot of affordable housing and supportive housing projects, and we are very fairly experienced in terms of like doing these type of units with deeper floor plates, and we always do HPD funded projects, and we are very familiar with the multifamily family housing construction guidelines and the supportive housing program guidelines. So.
Okay, so, but that's one of the things we want to make sure that we're designing a building that HPD is approving of, otherwise it's back to the drawing board, which wouldn't be very good. It wouldn't be good at all. For argument's sake, we approve exactly what we're seeing here, HPD hates it, you have to come right back here. Quite expensive, very slow, et cetera, et cetera.
We understand that. We will definitely look at the comments. Whatever is possible, we'll try and test it out, and whatever is viable, we'll try to revise it as per that.
Okay. So, kind of going back to the very pleasant response by Mr. Lobel about mixing this with a special permit request, a lot of my sort of pushback on why can't you give more front yards and so on has to do with, this has to be the minimum variance necessary. But I would say that I don't see why, in the interest of more open space, the design can't focus on having more planted areas, a complying front yard along Cypress, and then also to reach out to DOT. So that would be done, I think, with, is this Jello's case? Yeah, with Ms. Prenga, to reach out to DOT to find out whether they have a plan to open 59th Street there.
Right, it's our current understanding that there's no plan to open the street?
Right, but we need a letter. from
Okay,
them.
oh, like a 10-year letter?
No capital
Right.
improvement project,
Oh, okay,
right?
sure.
Because that would, if you were actually building in the bed of a street that you own, but you don't because New York City owns this.
Right.
That would entitle you to build in the bed of the street, for example, right? So then, building all the way up to the street line would be reasonable, because
Sure.
it's never going to open, and you're next to a cemetery, how much green space does a person want, right? And you might even get New York City to say, why don't you plant some bushes,
Right.
right? So that could be really nice, or maybe the cemetery wants to plant some bushes, or.
And we did have a conversation that, of course, depended on the results of the conversation with transportation, that, we talked about alternatives which would involve a shift in the building. So again, we're with the program and happy to look at that.
Okay, great, because you could just slide it, and
Sure.
then it's the same floor plate, only you're sliding it.
We love that.
We love it, okay. All right, then, supportive housing, okay. And then finally, the unit numbers, right?
Right.
So there was a little discussion yesterday, which was very interesting, to learn that the supportive housing program apparently either favors or requires, which we're not sure.
Yeah, I was just looking at the loan term sheet, and where did it go? Where did it go? So according to the loan term sheet,
we're on their website talking about.
I'm looking at the HPD website, which lists the supportive housing loan program. It says a 50-unit minimum is preferred.
Okay.
One unit
preferred.
should be provided on site for a building superintendent.
Okay.
Mike Newman again, CSD Housing. We have had some discussions with HPD about unit count. One, I guess I can quote and say that the cost per unit would estimated to be much more reasonable at 66 than 50. But what we're going to do in the meantime, we're going to look at the funding both operationally and development from 50, 55, and 60, in addition to the 66, so we can show the board the results.
Excellent. That's really good. And, initially, we had talked about that you needed to start at 40 units, but when we read that there's a preference for 50, at least we know there's a preference for 50, so we don't have to do 40, right?
Right.
Or 45 even. Okay.
And I didn't look at the term, I was looking at the QAP for the 9%. It's QAP. This is part of qualification, application program for the low-income tax credit, the competitive one. And I just quickly glanced through it. If you can also kind of help us kind of understand whether I know they don't have a minimum unit requirement, but they look for more number of supportive units, more number of low-income, deeper affordable units, and how that also will affect your financing and ability to secure 9% tax credit and also the 4% tax credit, which is as of right. Are there any minimum requirements of 4% tax credit and affiliated with the number of units? So if you can kind of clarify those.
We'll clarify, we'll definitely clarify that.
Yeah.
Okay.
Okay. Yeah, so I guess to make it so I understand what you just said, it's sort of to sweeten the offer to HPD so that you get bumped up to 9 because you're offering something that very few housing developers offer. And this is one of the reasons that I am in favor of these kinds of applications. This is very low income. Hardly any housing developers are willing to develop very low income, and in the case of management, and support those very low income people with the kinds of caseworker services that your group provides. So that ties it together, like Catholic Charities, where we had very low income seniors who needed support by the organization that actually does that for a living, right? So that's the combination that's so great about this application, that you've got extremely needy people where you're providing them with such necessary housing, and you have the skill set to take care of them, right? That, by the way, Richard, is the argument I need beefed. Okay. Okay. All right. Are there speakers, please? Yes, please come.
You get 3 minutes each. If you have separate things to say, you can come up individually. But if you're like just standing in support, I guess you could come up together. It's up to you. It's 3 minutes per person. So if you want to sign in.
I guess.
Actually, so are you in favor or opposed? Okay, so this is the in favor.
Oh, no, don't rip it out.
Hold on, you don't.
I don't want that.
So, here, let's cross it out. And yeah, so it's okay. Opposed, just under this column, if you're opposed, but if anyone who's in favor can write in the other column.
If you signed in, you can start. Right.
Yeah, just please come to the microphone, state your name.
You don't have to sign.
Valerio, I'm one of the residents.
Please, just a second, people are talking still. Yeah, okay. All right, go ahead.
Judy Cancel Valerio. I'm one of the residents on 59th Street, and we heard from this very, very last minute. I know the community board was mentioned numerous times. We were not informed. We were told that only residents within 400 feet need to be notified, which seems a bit unfair.
Within that.
That's for our rules.
Right, and I understand we can't rewrite the rules, but it is a little unfair to those of us who are still impacted, even though we're 405
so you mean you live
feet away.
outside of 400
We're on the
feet?
dead-end street that the opening was kind of mentioned, which I could see people cutting through, like they cut through a gas station, because if I can ask what time of day you went to visit the site?
I actually was there this Saturday at around 10 o'clock, and I stand corrected. There are those yellow lines that were hanging on Cypress. In my mind, I saw those as lights, but they were not. The first light is on 80th Street.
It's on Cooper Avenue, and then the Jackie Robinson exit.
Yeah, so there's nothing in between. So there are vehicles that are actually making that turn, and it's a fast turn that they're making along that.
So it's
right by the property.
It's a two-way avenue.
It's a two-way.
No parking pretty much on either side. I leave for work at 6:30 in the morning, and from 6:30 in the morning till about 10 a.m. on days I don't go to work, there's just traffic backed up.
On Cypress.
On Cypress. God forbid there's sanitation trying to do their job. There's just a pileup. And on Cypress, like maybe about 6 or 7 houses away, because they're next to a cemetery, but the property goes up into a house, and then the back of the property goes to our dead-end street. So their homes up attached to the property. A few homes away, there's a facility that also is, I believe, a day program for physically and mentally disabled. So buses come up in the morning and in the afternoon, and they're dropping off, people receiving services during the day in wheelchairs. Across the street, across the street from the gas station, a little closer to Clover Place, there's another facility that was proposed to be a nursing home. So it just seems like just getting home is a challenge, just getting to work is a challenge, and that doesn't even begin to touch on all the other impacts I think it's going to have on us as a community, how it's going to impact the environment with the litter, with more foot traffic, because as mentioned, the bus stop is about 7 blocks away, the nearest bus stop. The nearest train station from that facility is about 11, 12 blocks. So it's not a short distance to public transportation, and we're talking super low income. If people are not working, then we're considered about people wandering around and loitering, and if there are people with mental health issues, we're concerned for safety also. It's a huge space. I mean, 66 families, if there's 3 people per apartment, that's about 200 people in one facility.
It's mostly studios. There are only a couple of them that are 1 and 2.
No, it's a bigger mix than that. So hold on a
It's
second.
pretty big.
It's 66 units, 40 studios, 12 1-bedrooms, and 14 2-bedrooms.
14
Yeah. So
And that's
it's-
what we see on paper, quite honestly. We all know somebody who rents a studio and has, 3
No,
people
but
living in it. like-
but in this case, because this is managed by an organization, they know exactly who's living in it. It's different than just a regular apartment building where whoever rents. They're managing because they're supporting the 40, I think it's 40 units of
40
supportive, right? It's the non-supportive, it's the other 26 that are affordable units that are, that are, that are a mix. Those are
And-
like everybody, whatever it is you live in, but that's 26 units.
And quite honestly, this has nothing to do with the organization that's running it because I don't know of their history. But I too worked in a nonprofit before. Once funding is cut, then you have a trickle effect and services are impacted. I mean, just looking at the proposed scheme, one social worker for 66 families who may need, services, that doesn't even sound as sufficient to me, I work in a high school, I'm a school counselor, and I know when you have to serve a population, you should not have a huge caseload because what you can provide is impacted. So even that is, I think, of concern.
Okay, that's fair. Okay, thank you. We'll find out more about that. We'll find out more about the support.
My name is Jose Valerio. I also live on 59th Street. She kind of covered most of the stuff I wanted to say, but it is that. I think it's just a big structure for such a small area. Transportation, public transportation is very far. Also, what are these people going to do in the daytime? They talk about programs. Some people, everybody's not interested in these programs. They're going to just wander off. I don't want to do that today. Walk around to do what? There's nothing to do in that area. It's all residential, nowhere to go. So, all you're going to see is people loitering in this area. Litter, we already have a problem in Cypress because with the litter, I'm constantly calling 311 about people, litter just all along Cypress. Traffic is insane on Cypress.
Why is the litter so bad?
It's people,
From their cars?
From the cars, number one, and now you're going to have people just walking. There's only one way out and one way into this place. This is Cypress. That's it. You can't go anywhere. Either you go that way or you go into Highland Park. Other than that, the only way you're going to walk out is through there. And if you open up 59th Street, then we're going to have them walking through 59th Street, And like she said, people are going to want to cut through there. If they see themselves stuck in traffic on Cypress, it's a little easy way out going this way. And everybody's impatient. That neighborhood, a lot of aggression in there, poor neighborhood, And that's what's going to happen. People racing down the block because they want to get, trying to get out of traffic. A lot of, and just that. It's just a small, the area is not for that. Our neighborhood already contributed to something like this with we have the facility similar to this one with, with the physical place, physically challenged people. Like she said, vans pull up. We got the car dealer across the street that stops there sometimes with these tractor trailers to unload cars right on Cypress. Adds to the problem. We also have the nursing home, and it's not good. It's just a terrible, terrible, terrible area for that. Thank you.
Where are the other two facilities? Could you just tell me the intersection?
One is a few.
I know the address. 89.
Come from the mic, because I'm afraid I won't get picked up.
8049 and 8051. It's like two buildings that are attached, Cypress Avenue, and one is 8010 Cypress Avenue.
So, sorry, 8049.
Yes, and 8051, yeah. It's two.
Okay.
And also, the community board, Community Board 5 voted yes to this project. We wasn't even informed about this stuff. How do you know these people don't even live in our neighborhood to vote yes on something for us? Where do they come from? I don't know where these people, who are these people that voted yes? I don't know them. They probably live in, Community Board 5 is pretty big. They probably live in Middle Village. Let them build it on Middle Village. You got plenty of buses over there in Woodhaven. You can, for transportation, wide streets, plenty of streets. We already did our part. We already have 2 facilities on Cypress, and, it's enough. That's, we don't need another one, Thank you.
Okay, thank you.
Next speaker, yeah.
This one and this one.
My name is Martha Armache. My English not so good. I'm gonna try to speak a little bit, but I think the project is gonna impact in the school too. So I have little kids in the school around the neighbor, and if it's coming more students, it's too hard to my kids to learn. So that's why I'm not agree with this. Even I live in the end of the 59.
She's a bit closer to the.
She's at the dead end.
Yeah, she's closer to the.
To Cooper.
Yeah, to the proposed. No.
Oh, the other way.
Yeah.
Towards the building.
Yeah. So I have a little kid yet, so I think it's a little hard for me.
What are you concerned about with your kids?
Because they are little, and I have my kids in the school, so if the project coming, it's more students in that school. So if more students...
I see. There'll be more students living in the building, so the school will be larger because there'll be more
students
enrolled.
Yeah, and the school is not too big, it's a little school because of that.
Okay.
I see.
Okay, well, that's something that needs to be addressed in what's known as the environmental assessment statement.
Just one second, yeah.
Yeah, so let me just finish. So there's an environmental study that's required to be done for all of these projects. And when it sees that there is too much impact on the local school system, then there's a result, right? But, so we need to look at what the study is, and if there isn't a further study, then there needs to be one. I'm just asking them to make sure that they've studied school seats. Right.
There are thresholds.
Yeah, I just want to add in reference to the schools, just because that's what I know. Schools have to take them regardless.
Yeah,
We can't turn anyone away, whether you have the resources or not.
Right, but so when we look at the environmental study, we look at whether the project will produce more children than what there is an environmental threshold set, and the threshold looks at the capacity of school seats and whether or not the existing school seats have the capacity under essentially the law to accept the X number of additional children. If I would just exaggerate this, if there were 1,000 additional children proposed for a project, then it's very likely that another school would be required to be built. So that's the kinds of things where you look at the impact of additional children on the school system, and oftentimes on a big project, they'll actually build a school in the building, right? So those are the kinds of things we look at. This is quite a small project, but there is a study done for how many children are anticipated per unit, right?
Right. But just from a school's perspective, you only need 34 for one class, right? And that's provided that they're all the same grade, which I'm sure they're not. But that 134, if you don't have the services the students in that class needs, the school has to take them regardless,
Understood.
and then the children are underserved. That's
understood.
And these are, you know, assuming these are kids also that coming from troubled homes also. So you don't want them, it's also bad for them that coming in. You should go to a place where they're really going to get help, not just
Right.
put somewhere.
But understand that a lot of the people who are going to live here are frail elderly, right? Guessing they don't have kids. Just guessing.
But that is something that they can
Yeah,
talk
right,
about.
okay.
Thank you so
Thank
much
you.
for coming.
Thank you very much. We appreciate it. We know you waited a long time also.
Do you want me to state the thresholds from the checklist? Or
No,
school
it's okay. We'll get more into it the next time. Hello.
Good evening. My name's John Caruso. I represent Mount Judah Cemetery, which property abuts this project here. And our concerns aren't quite what the residents have, but I understand them. I mean, this building is going to be put up as a 6-story building, which is out of character with the whole neighborhood. I don't think there's a 6-story building within miles of this location. But our cemetery had a board meeting yesterday, their annual board meeting, and one of their main concerns was this demapped street. Is this part of this project? It's not, it's...
So the street belongs to the city of New York?
Correct, yes.
And so what we were just talking about is to find out whether the city ever intends to open that street. We often find out from the Department of Transportation what their plan is. If they have no plan to open the street, then it's possible that, and the city owns that little strip, then it's possible to actually plant the strip, you know, to treat it, to reach out to DOT and ask whether it would be okay to forest it, basically. So somehow or other, that could be actually an asset that turns into kind of a park.
Sure. I mean, would that be up to this project?
No,
Or this would be a city project?
So we would be reaching out to DOT to see first if they're ever intending to open it up. If they're not, then the next step would be to work with the agencies and have this group work with the various agencies to see if it can be forested. And you might want to be involved because it's adjacent to your
Absolutely.
property.
That's what I was saying. We have about 350 graves right adjacent to this building.
Right.
And the existing building, there's a 3-story eyesore, which when I bring people there to buy graves, they look
Nobody
at
wants
that,
it.
they don't want it.
But
You know,
adjacent to a forest would be very nice.
That's what the board wants, is something, you know, who's going to maintain it and, you know, if.
Right.
But I was also led to believe that the cemetery, there's also an option maybe to purchase half this, how does that work? No, okay, this is what it.
We haven't heard anything
Okay,
about that.
I don't know, this is what I was told.
But, you know, one thing that this is me thinking out loud, if the city owns that land,
Right.
if the city's not intending to use it, it could transfer this property to the Department of Parks, then Parks develops it with a forest, which you could coordinate with them, and then it's Parks that maintains it, right?
Okay.
So that's something actually to consider, which would be great for everybody.
Okay, so as it stands now, it's not part of this deal, it's still
No,
going to be that.
no, they don't own
There's
it.
still going to be that buffer between the
Yes.
two properties.
Yes.
Okay, thank you very
Okay,
much.
Thank you.
Mhm.
Was there any more speakers? Come back. Doesn't have to be a lot of speakers to be heard, so.
Right.
Don't worry. Doesn't have to be many speakers to get the point across.
As long as your ideas were expressed by somebody, it's good. It's good.
Chair, we had two discrete points. Ms. John was going to address some of the program issues that were discussed with regards to the residents and time spent during the day. So,
Hi, Crystal John again. Thank you very much. I understand your concerns, especially about the transportation piece and the distance to the bus and public transportation. And I think we will probably incorporate some type of shuttle or some type of van service, because that's something that's really needed. And as far as daytime activities and work, a lot of individuals today, they stay home and they receive home service. So the service is coming to them. We have home-based community services called HCBS. They come in and they work on case management. They come in and work with vocational. If the individual want to go back to work, they have peer support. Whatever you want to do, they come into the house. So as far as wandering the community, a lot of these individuals are home. We're going to have 24-hour security. We're going to have cameras around the facility. It's going to be a facility like all of our others that are well supervised at all hours, 24 hours. We're going to have a porter on site. We're going to have a super.
What's the porter for?
The porter is going to be, it's basically the same thing as a super. Fixing things in the household, making sure that the facility is clean and neat, cleaning up inside and outside of the
Which is different from
grounds.
super?
Excuse me?
Which is different from the super?
It's different, yeah. One is this called a super because the person is going to be living on the premises.
And I think
then,
that's a question Chair had. Is the super just there to maintain the building or is also taking care of the needs of the
taking care of the
resident?
needs of the building. One is going to be maintaining and one is going to be taking care of the needs of the building. So if a light bulb needs to be changed.
Yeah, who does
or
that?
The toilet needs to be unclogged. Thank you so much.
Who does that? The toilet and the light bulb? The toilet and the light bulb, or who?
That will be the porter.
The porter.
Right.
What does the super do?
And the super is picking up, emptying the garbage, the trash.
Okay.
Bringing out the trash. If there's anything on the outside, maybe snow removal, removing the snow, those type of things that the super will be doing.
So the super isn't also sort of an in-house caseworker or something like that? There's no 24-hour kind of caseworker type person?
Well, we're going to have 24-hour staff. We're going to have 24-hour case managers. We're going to have 24-hour, what they call direct care professionals. And those are going to be the individuals that's going to be there overnight, someone sitting at the front desk. If an individual comes in the building, they have to sign in and sign out.
That's security. Let's stay on one subject at a time because I'm totally confused now.
But if,
So-
actually, I just wonder if the hour is getting late and
Yeah.
maybe we could do
Oh,
this
okay.
in written submission? just
Yeah,
because
no, but I
longer
need
it
to make
goes.
clear before we do that, that when you're talking about these different functions, they're all blending together into the same thing. So you need to make very clear, what's the difference between what a super does, what a porter does, what the person who sits at the front desk does, that the concern of the community is that there are people who have special needs, and they don't want them kind of wandering in the neighborhood and, for instance, disturbing the kids, right? Is there going to be on site at all times, or what are the hours of the times, a person who attends to people who might need those kinds of special attention?
Okay, so when you say...
the number of those people.
And the number of those
So
people.
just the number of the people that are there, their roles, what their duties are and their obligations, and the times that they're there.
Okay, so
It's all part of the
right, I can also write it up, but just briefly. Per shift, okay, we have at least 2 people per shift.
Two people.
Two
So
people,
I don't
two
want to get into this
individuals.
because
Okay.
Richard needs to
Yeah,
work
okay.
with you
Yeah,
to
just-
clarify
Okay, no
your
problem.
answers.
No problem.
Because you just confused me again by your answer.
In closing,
Sorry, I just want to
Yes.
throw in there, we heard about the concern the community has that people, by having this through lane between
Yes.
Cypress and 59th, there will be people who will be bypassing
Yeah.
the traffic, and we would like you to address that, whether this is going to be for all people to use it, or is it only for the residents or visitors to the site, and how you're going to control that to ensure that won't be any abuse of that
Right.
throughway.
Other than a gate?
yeah,
I
no,
don't
I
see
think
how
it sounds like we need to, we want to be as accommodating as possible to the community board, but it sounds like we really need to revisit traffic and circulation on the site. We'll do so. And just to close, we did discuss with the community board also supervision on the site, and that population which would typically require supervision would not. This was an intense area of conversation. We talked about the current facilities operated by Well Life, what the staffing was like there, the similarities in the population. So we have all this. We're going to give it to the BSA for you to review.
Great.
Please.
And I have another,
Yes.
you want to do yours?
No.
So I actually do have an issue about the height of the building.
Okay.
And though in the nature of the kinds of people that this is serving. I'm delighted that the idea that anyone wants to build such a project, because there's so few, but at the same time, it's quite a large building, which is why I was looking at spreading it out.
Yes,
more.
Chair.
I would like that looked at. You know, we always talk about, well, different kinds of urbanists look at whether you do something skinny and tall, but this isn't skinny and tall. This is sort of fat and tall. So what about a little fatter and not as tall?
Understood.
Right? Okay.
Yes, again, something, given the comments in the executive session that we've already mentioned internally, and are happy to look at that. I just want to close by saying that, you know, there was a discussion of the community board vote, where these people are from. This was a duly notified and discussed meeting of the community board. We met 3 times. And again, as I'm under oath and discussing what happened there were members of the community board and the land use committee who looked at me and said, what can we do to make this facility larger? And so the entire team was really taken aback by that, because there was a very wholehearted interest in serving the population that is intended to be served by this building. There was a discussion at the full board of individuals in the community who did not have services and had issues, which you know, they were thankful that there would be a facility like this to address some of these needs. So again, we will engage with regards to the traffic conversation. I think it's a good point with regards to the pass-through. We will incorporate our discussion with the community board as well, because we'd like to keep them informed of all of this. And we're happy for the board's comments today. We feel very positive with regards to our ability to come back to the board with evidence.
And I also want to emphasize that this is indeed a residential building. So persuade your neighbors.
Understood.
This is a residential building. It isn't a facility. And you should stop using the word facility. People live here.
Sure.
Right?
It's a good point.
I know that's what you get used to when you're in this business, but it's actually an apartment building.
It is.
Right?
And we talked about that too.
Okay, good. All right, thank you. So what's our schedule?
I think the earliest the board can see you is June 11th.
June 11th. So how much time does?
22nd.
How much? So for submission, that gives us approximately.
May 22.
May 22nd.
Approximately a month.
No, more than that.
More than
1,
that.
2, 3, 4.
Oh wow, approximately
5,
2
6,
months.
7, 8 weeks.
8 weeks.
This is a question I always ask for all of the affordable housing. Is this on HPD's pipeline, and
Mike?
is this on HPD's pipeline, and is it slated for June closing?
No.
No?
The drawings aren't done. How can you close?
Mike Newman again, CSD Housing. We've been talking to HPD about the next 9% round in August, September. That's what we're shooting at. We don't know that that's possible at this point in time, but that's the direction we're going in. And based on the discussions we had today, we will be re-engaging HPD and seeing what kind of support we can get in writing at this time that may be helpful for you.
Right, okay. Well, we're also reaching out to HPD, so it should come from 2 fronts.
Thank you.
Okay, great, thank you. All right, so what did you just say?
In 8 weeks. Wait.
I mean, Chair, is there any possibility of coming in sooner?
No.
Really?
That's the earliest.
Okay, I mean, obviously, we're subject to the board's discretion. It's just as we talked about how much time we'd need to respond, which was going to be a month. So this puts us in a little bit of a.
Let me just confirm. So April 20, something about April 22nd. I think those are the, May 1st is target. April.
Keep looking.
There's April 17th if you could submit in 3 weeks.
But I
don't want to rush your.
No, we understand that.
We want a good submission. We also want assurances from HPD by then, right? So this gives you some time.
Yeah, if I could just suggest, Madam Chair, because, I mean, HPD will obviously spell out their guidelines, which will dictate maybe design
Okay.
and program.
Yeah, one moment, please.
Yeah. We also want maybe a shorter note. I think
It's
that's
not
the
small.
right
Is it small
amount.
enough for target day? No.
Do you have a comment?
The applicant team has discussed the fact that we intend to produce such a complete submission in May that the board will, feel compelled to.
Yeah,
exactly.
And I would say
Bring
use
this
this
matter to
opportunity to
resolution.
reach out to HPD and try to see any design issues that they may have with the modified plan that
Understood.
we're recommending, and how to integrate that into their HPD's requirement.
Right, exactly.
Okay.
All right, so we're
Great.
set.
So to explain to them.
And then for the benefit of the neighbors who came out, and so the next hearing will be June 11th. It'll be here, it'll be starting at 10 a.m. And so if you have additional testimony you'd like to submit, you don't have to come. If you don't want to, you can just submit this electronically, your testimony. They'll also be providing a revised materials to the board on May 22nd. So anytime after that, you can make an appointment to come see any of those materials, which will also be provided to the community board. So you won't have to come all the way here to Manhattan if you don't want to.
Thank you, Chair and Commissioners.
Thank you very much.
Thank you.
Okay, thank you all.
This concludes the public hearing for March 26, 2019.